Yeah,
I've never met him.
that's what I was.
So this is
I definitely see this. I didn't think this. I didn't realize this was the 2020. I got you.
Shapiro, Pat Crowell's, David Hughes, and I believe before the jury comes in, you may be hearing from Mr. Altenberg, Chris Altenberg.
Thank you very much. And who's your corporate rep today?
Oh, I'm sorry, I beg your pardon, Your Honor. Our corporate representative today is Dr. Richard Elliott.
Thank you very much. I was provided an exhibit list. Did you all want to go over that at this point, or are there other issues we need to address?
Yeah, okay, Judge. On the list, the one that says 9/28/2023, the only ones I think we have left, well, I can't say that. 2065, you'll see Dr. Chopra's bill for evaluation of Maya's exception to hearsay. There's no requirement of a corporate representative, and therefore, we don't need to read the predicate for that. Its relevance is, under our theory, that all of these damages after October 7th or so are relevant and material and damages. So that goes to causation, but I don't believe it's a basis for exclusion. Would you like to go through this sequentially? Or?
I want to deal with exhibits to the extent that we need to deal with exhibits.
Yes, sir. Well, I can just
Would you like a response to that?
Well, what is his bill? What's it for?
It's for his examination of Maya Kowalski.
During what time?
During the shelter action.
And after discharge.
Well, yes, and after discharge. He saw her again. The one after, anything.
He wasn't a
this
treating
case-
physician or a treating doctor, was he?
He was an examining physician listed here as a non-retained, well, I'm not sure, but he's listed as an expert here. He was not a treating physician in the traditional sense of the word. There's an order, which is the next one down there, amended order authorizing examination of child by Pradeep Chopra. And if the court reviews the order, I believe it'll clarify why we want this in, because the court requested in the shelter action that a doctor be proposed in order to give some clarity. The judge also ordered that the Kowalskis are to pay for it and the travel costs. But the fact is that Dr. Chopra was not chosen by the Kowalskis, not even suggested by the Kowalskis. And so we wanted to put the order in, and we believe the bill for the evaluation of Maya that they had to go through because of Johns Hopkins malpractice in misidentifying this and then mistreating it is relevant material.
Judge, it was an examination ordered in the dependency action for the dependency action. So again, say the bill is not relevant.
Where's the, I don't understand their objection.
Well, I don't understand why you're trying to move it in if he's not a treating physician of Maya Kowalski.
Well, Judge, virtually anything under our theory in the medical malpractice action, virtually anything after the date that we are allowed to raise the issue, any expenses that they had at that point, in our point of view, are damages because they should have never had to go through any of this. And as a result, having to pay for Dr. Chopra by court order in that action is a damage. That's why we believe it to be relevant.
What about Chapter 39 immunity? And you're seeking damages for an expense that occurred in the dependency action. I don't see how that's relevant to this case at this point in time. So I'm going to sustain the objection relative to 2065.
All right, the next one is the amended order authorizing examination of Dr. Chopra, and that is, of course, a public record.
Well, can someone show it to me, please?
Yes. I think I've got it. That's the amended 2076.
page? So why are we trying to put this order in?
The defense is trying to portray the doctor as simply a hired gun, that he was chosen by the Kowalskis to serve as an expert witness in the case. That is not true. That is not the case at all. He was suggested, and he still doesn't know, and I'm not sure who suggested him. I assume it was Hannah Kirkpatrick or someone else of the doctors, but it wasn't us. And so if they are going to raise, as they appear to, the idea that he is a hired gun, hired by us for no other purpose in the underlying action than to be an expert witness, that's simply not true. As the court can read the order, there was a concern, and the doctor can explain this, there was a concern about the differing sides. The court wanted the parties to suggest a real expert, a true expert, not that ours aren't, but an independent expert that had nothing to do with this and was not going to be contacting the parties. They were simply going to send records, and then he was going to do an examination up at Brown University. And that's what happened. And so I want to establish here, in terms of his credibility, is relevant and material to establish the means and reason for his retention, so that there's no attempt to impeach him or somehow cross-examine on a point that, according to the order, is simply not true, that he is a hired gun.
Email from Beata Kowalski to Dr. Kirkpatrick dated November 17, 2016. Quote, "Do you have any contact with Dr. Chopra in Rhode Island? I'd like him to be the, quote, unbiased CRP expert," unquote. It was absolutely Beata Kowalski that emailed Dr. Kirkpatrick suggesting Dr. Chopra be the, quote, unbiased CRPS expert, unquote. If they're going to suggest it, I'm going to impeach him with this email. It's just not true. Beata found it and suggested it. I've got the email. I'm happy to approach with it if you need to see it.
Well, perhaps the better course here is to wait and see what actually happens before, if the hospital starts contending, then we can talk about it. But it sounds like that email then is also going to come in as well. So why don't we not for now, but if the circumstances warrant it, then we can address it at that time.
So then upon redirect, I guess, it will be time to discuss it, and I will not raise it in my direct examination. All right. So the next one, 2408, 1711 to 1712, the defendants have been gracious enough to withdraw their objection to that. This is a photograph of the next witness, Rachel D. Young.
Okay, so I'm sorry, what's coming in at this point?
2408-1711 to 1712.
Okay, so defense, you've agreed to those 2 pages?
Yes, sir.
Okay, the court receives 2408-1711 and 2408-1712. What's next?
2528-008, photo of Jack Kowalski as
Okay,
a
so
firefighter.
every place that says yes, am I supposed to go ahead and just admit them at this time?
That would be great.
We're saying that we have no objection to them being admitted, Judge. We do have some concerns that we raised to some. So it was hard to do. We're not objecting to them being evidence, but we had some concerns about them being published to the jury without context, and we mentioned that when we noted it.
Okay, well, for those that I see that are clean, I'm going to go ahead and admit
Understood.
them. So at this time, the court's going to admit Exhibit 2528, pages 8, 14, 21, 24, 37, 45, 70, 102, 115, 124, 129, With respect to Exhibit 2529, pages 5, 19, 26, 35, 39, 42, 69. With respect to Exhibit 2530, pages 43, 46, 61. With respect to Exhibit 2532, the court will receive page 1, page 26, page 39, with respect to Exhibit 2571, page 30, and the court will also receive Exhibit 250, sorry, strike that. The court will receive Exhibit 2705. Okay, I think those were all that were clean. What's next? We lost Mr. Anderson.
I was just making sure my expert came in and pulled out.
Judge, if I can, do you want me to explain the objection to description comment?
Sure. Are we on 2529-058, or is this?
041, I think is the first.
And what is that?
2529041. Because it's the same comment for all of them. Judge, really my concern is I didn't know what the court's intention was with respect to when the exhibits go back with the jury. Are they going to be giving this detailed list? If they're not, if the jury's not getting this description, then we don't care. But if this is a description that's going back with the jury, then we do.
Well, normally we don't send back a table of contents.
No, but there's one in each of them, matters and the context.
What I would suggest is when we are getting to the point of getting ready to send the case to the jury, that I'm going to have the lawyers work with the clerk's office, because if we're only entering certain exhibits, we're going to have to be very clear what is in. And then perhaps what we could do is create a clean exhibit table for the jury.
I think they'll need one, Judge. I'm not disputing that.
Yeah. But the ones that we've been working on would not, in my mind, ever go back, because there's lots of commentary on them that are not appropriate for the jury.
That was my concern.
So
if this description is not going back to the jury, then we'll remove the objection to description.
Okay, so the court at this point will also receive Exhibit 2529, page 41, 48, 61. I'm sorry?
You said 48. I think you meant 58.
Oh, I apologize, not 48, 58. So it's 2529, page 41, page 58, page 61. The court will also receive Exhibit 2571, pages 1 and 26, page 40, page 53. Court will also receive Exhibit 2604.
Can I, Judge, briefly, my understanding is that you took care of the issue of 2603.
So I can receive 2603 at this time?
That's my understanding. They gave them ones with it whited out.
Well, meaning they gave it to the clerk?
Yes, sir, sorry.
So court will also receive Exhibit 2603. That takes us now to, I guess there's an issue with 2703.
Well, Judge, again, we're not objecting to them being admitted. Our concern and we wanted to just address it with the court, if they're admitted, does that mean then they can just go publish it to the jury? We're concerned that things will be published to the jury without context, and they're just going to play some videos for the jury. So that was the discussion. I didn't know what the court's
And
ruling on that is.
2703 has to do with the 41 hours EEG room issue?
Yes, they're all clips from that time she was in the EEG room.
It's 41 to 42 hours long, and we didn't want to subject the jury to that and to sit here and watch the entire thing. So we picked out the clips, and the defense has picked out some clips as well that they would like to show as exemplars of what can be seen in there. The jury will have it back in the jury room, can view it to their heart's content, but I really don't think that it is appropriate or, well,
Her issue just is when you are publishing it to the jury, as my understanding. You
Right.
want to do it in context, maybe with a witness or...
Right, that's what I'm saying, Judge. So as opposed to just playing it, the jury, and then replaying it again, and then commenting it again. That was our concern.
I can suggest, we're going to use it with Dr. Chopra, who's our second witness, and he's familiar with the tape. So what we'd like to do, if the court needs to do the instruction on video or photographic evidence, fine, but this is just simply me explaining in my question where it's from. Are you familiar with it? Yes, I am. We show it, and then I ask him, what if anything is significant about that?
Judge, I guess we'll deal with it at the time. I just don't know if it's relevant to Dr. Chopra's testimony.
Well, I'll go ahead and receive them, and then we can discuss publishing, but right now it sounds like it might be logical to publish it or pieces of it at this time. So I will receive Exhibit 2703, Alpha, Bravo, Charlie, and Delta.
Judge, if I could inquire one matter about that, is it counsel's intention to publish all of the, I'm going to call them grabs from the surveillance video, both the ones they like and the ones we like, or just the ones they like?
Mine are, I don't think it's a question of one likes or the other likes, it's the same evidence. These are the ones that we chose as most appropriate for this witness to comment on, as he's an expert in this particular disorder or disease. And so these are the ones that best exemplify what he'll be commenting on. If they want to put on something in their cross or whatever they want to do in their case.
I think counsel has answered my question.
I'm so sorry?
I believe counsel has answered my question.
Thank you. Does that deal with the exhibits, at least to the extent we can deal with them at this point?
Yes, sir.
Okay, what's next?
There is one more, Your Honor, and discuss this with counsel. It's Exhibit 2116-001. It is not on the list provided to the court. We discussed this briefly this morning. It's the text messages between Aladis and Sally Smith.
How many pages is this?
It's about, let's see, it goes from 2489 to 24.
It's 10 pages, Your Honor.
Judge, we would need some time to look at this. I mean, they didn't tell us about this yesterday.
Yeah, but we're not going to deal with that until they've had an opportunity to look at it. So that takes care of the exhibits for now? What's the next issue we need to address?
Your Honor, we briefly discuss deposition designations. Only to the extent that
Is it important for this morning?
it's important for next week.
So we can do it this afternoon?
Yes, Your Honor.
What's next?
Judge, I have one other issue I can wait till we break this afternoon.
I've got 10 minutes before I'm bringing the jury in, so is it something we need to address right now?
The one thing I would bring up, Judge, we provided Your Honor's office with a tape of counsel giving an interview to Court TV on a couple of occasions in the last couple of days. I'd like to address the entire matter when we have more than 10 minutes, but the immediate concern that we've got is the question of the court's inquiry when the jury arrives. The court's been very diligent in inquiring whether they've spoken with each other or gathered outside information. We'd like for that inquiry to include whether they have been approached by others, and if so, whether they have brought that matter to the attention of the court deputy. Because of the nature of the comments made by counsel during trial, we're concerned that the jury may be approached by someone who they know and who knows they're on the jury and given information or given implications that may affect their deliberations or affect their attitude regarding the case going forward.
This goes back quite a while. The court may recall the defendant's chief counsel, as I understand it, trial counsel in any event, had a series of comments in the Daily Mail, which was then picked up. This was the Daily Mail of, well, it says July, 1st of July 2023. And in it, they reveal on the headline is, Maya Kowalski's mom, Beata, was fraudulently writing prescriptions for her daughter and faced charges before she killed herself. Florida hospital. And the court then had ruled, or was going to rule, eventually ruled, that there was no basis whatsoever. And we had informed the other side about this. So I don't know what counsel is worried about with this. I did give a comment to Court TV, but I in no way brought up any facts, whether in this case or outside of the jury's purview. And so my comments were limited to how's it going.
What I hear Mr. Hunter asking for is he wants me, when I'm asking, my normal questions in the morning, he also wants me to ask if any of the jurors have been approached by anyone about this case, and maybe perhaps have you seen any media reports about this case?
That's correct, Your Honor.
And that's just a standard, would become a standard question or questions.
I don't think there's any problem with that. I don't believe that jury in any event is big watchers of Court TV. No offense to Court TV, but that was a joke.
Well, then it sounds like there's no objection from either side for me to ask the standard, to include in my standard, have you been approached by anyone about the case? And have you seen any media reporting on the case? Okay, what's next?
That's it for now. We would like to bring this up after we're through today, but that covers us for now.
Judge, I have one thing.
All right.
I'm sorry.
Ms. Crowells went first, and then Mr. Anderson, you'll come second.
Recall yesterday. Last time we were at trial, that the comment came in through Mr. Whitney's question.
What witness are we talking about?
I'm sorry. Duncan. Thank you.
Dr. Duncan. Okay.
Dr. Duncan. The question he started, and then the court sustained objection, was if the record shows that MK did complain to the doctors at the hospital of physical and sexual abuse on multiple occasions. We stood up, we objected, the court sustained our objection and instructed the jury to disregard. We think that more needs to be done because, frankly, I just heard the word sexual. I didn't even take in the whole thing. When I read it, it made me more concerned. And we think that the court should instruct the jury that there are no claims for sexual abuse by the Kowalskis. Because this statement is that she complained to the doctors of physical and sexual abuse on multiple occasions. And at this point, the jury may think, well, that maybe they just ought to be allowed to hear about it.
I think this is a conversation more than the 5 minutes we have left. Maybe we can address that this afternoon.
All right, thank you, Judge.
Mr. Anderson.
Judge, we have a PowerPoint. We sent it over to both the court and defense counsel. It has 3 pictures in it and it essentially simply has a title, and then exactly, we basically told them all of his direct examination, and I would think they'd be thanking us. But now they object to it. And so, for instance, if the court's got it here, there's one that says,
I have no idea what you're talking about. Can you put up whatever you're talking about?
sure.
Judge, I would point out this is for the second witness. I mentioned that in case you want to go there.
But Dr. Chopra is the second witness, right?
Yes, he's coming right up.
And the first witness is quick-ish.
Yeah, I hope so. Rachel Dion, who's a physical therapist. You can show him the court. Go to the third page, signs and symptoms of CRPS, or the next page. The court can
Why
see.
are we doing a PowerPoint in questioning?
Because it allows the jury, in a case where the timing and the particular topic raised are important to make clear, so that the jury understands the different parts of the testimony, and they can read as well as hear what's going on. And so it is simply an aid in a complex case involving complex medical terminology, so that they can better understand what's being talked about up there. I cannot see any prejudice to them, the other side, because, again, they've been given this, and he's going to testify virtually identically to this. And so that is a purpose, in our understanding, Judge, of a demonstrative aid, is to assist the jury.
Mr. Shapiro.
Yeah. My objection is not, there are some pictures in there that could be demonstrative aids. My objection is the language. I mean, the first page is him and his credentials, and then he basically is just writing out his testimony. He's welcome to testify to this. The words are not demonstrative aids. We object to the wording in it. If there's a picture that they want to lay a predicate on a demonstrative aid, they're welcome to. But I object to all the language on here.
Here's my thought. Before technology, the old chalkboard,
Right.
people would, during the witness would say something and the lawyer would write it on the chalkboard. That concept doesn't offend me. The concern I have is you have language already written out and the witness hasn't said these things yet. So I don't care if you want to use, as he's testifying, you write out something that is displayed to the jury, but I don't think it's appropriate to have his testimony written ahead of time and then he just reads off the PowerPoint slide.
He has a great deal more to say on each one of these topics, Judge, that he prepared this, not me. So this is not a situation where counsel is coming up with directions for the witness to testify. These are simply points to remind the witness and to orient the jury. And the other thing I would remind the court is, if there's any doubt in the court's mind, we deserve a little bit of leeway because on opening statement, they were allowed to give, I grant you there's some difference between opening statement and witness. However, they were allowed to use a demonstrative aid that had pure argument in it with graphs overlapping and statistics and things like that. That's not appropriate for opening. We objected at that time. The court overruled it. So in our point of view, if in the future we can't use demonstrative aids like this with witnesses, fine. But we spent a whole lot of time with this one.
I am, again, when the witness says something, if you want to write it down on a technology and broadcast, that's fine, but it's not appropriate to broadcast what he's going to say before he says it. I don't know how else to explain it.
Then is it appropriate, because my handwriting is so poor and it will take forever to write these things up there, for the witness
The
to
gentleman
testify?
behind you, and sorry, I keep forgetting your name.
Dan Reyes.
Mr. Rice. If he, I'm sure, can type, and I'm sure that his typing skills are sufficient that the jury will be able to read it, if that's the way you want to go.
We can do it that way. Good.
If you want to use the overhead projector and handwrite it, you can do that as well, if you want to, but you can't broadcast this testimony and then have him testify from it.
What I was hoping to do is have him testify and then bring it up.
If he has testified to it, that's fine. But you can't broadcast it before he's testifying.
Agreed, Judge. Agreed. We'll stay on this last slide before he finishes that area. Then we'll bring it up. If they have an objection, they can make it.
Okay, we're at 9 o'clock, and I see Mr. Altenburn trying to get my attention as well.
I'll be very, very brief. On the motion in limine yesterday about the 2015 material, Mr. Anderson promised he wouldn't bring it up, and I appreciate that. It occurred to me when I realized that Dr. Chopra was the witness that if we're not giving curative instruction to the jury, that maybe a doctor that wants to talk about the 2015 to 2016 period needs to be clear that they're not going to volunteer information that's standard of care or criticism of the doctors in the period between 2015 and October 2016.
As it is right now, I think we're okay waiting a day. If it starts to look like that's what's happening, then I'm sure someone's going to stand up and object, and then we can possibly write a curative at that point in time.
Thank you, Your Honor.
But I'm taking Mr. Anderson at his word that that's not going to happen.
My questions will not be addressed to that period, other than obviously in predicate for 2016.
Okay. Anything else before we bring in the jury?
I don't believe so, Your Honor.
No, Your Honor.
Let's bring in the jury. Good morning. Everyone, please be seated. Members of the jury, I want to confirm, while you were away, you did not discuss this case amongst yourselves. You did no investigation. You received no information. Is that all correct? Correct. Okay. Was there a...
No, I'm good.
Okay. I'm also going... I understand. I'm going to now ask you what will become standard questions as well. I want to ask you, have anyone approached any of you about this case at any time since you become a member of the jury? Has anyone? Okay. And have any of you seen any media reporting concerning this case since you've become a juror? No. Okay. Thank you very much. Those will become standard questions during the days. Mr. Anderson, Mr. Whitney, who's Mr. Anderson?
Rachel Dion, plaintiff calls Rachel Dion.
Face the clerk and raise your right hand.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Good morning. Mr. Anderson.
Please state your name for the record.
Rachel Dion,
And where do you live, Ms. Dion?
Venice, Florida.
And have you been called here as one of the physical therapists that worked with Maya Kowalski both before and after her visit to Johns Hopkins from October of 2016 to January of 2017?
Yes.
And I want the jury to know a little bit about you. Are you from here?
Yes, from here. I've lived here about 30 years.
And where'd you go to school?
I went to Florida Gulf Coast University for my bachelor's, and then Kaiser University for the physical therapist assistant license.
And what did you study? What was that for the physical therapy, or was there other?
I studied for my bachelor's. I have it in exercise science. I did 4 years with that. And then Kaiser was just focused solely on the physical therapy license.
Okay. And then when were you first licensed?
July 2016.
And incidentally, was that one of the first days that you saw Maya Kowalski?
Yes.
And so you have been then a physical therapist for some 7 years. Is that right?
Correct.
And in your career, have you had pediatric patients from time to time?
When I was a student, we worked with some pediatric, yes.
As your profession progressed, did there come a time then that you were working more with older people?
Yes, yeah, being the demographic in the Venice and Sarasota County area, it gets a little older.
Okay. All right. And through the course of this, have you continued to keep yourself apprised of any innovations, new techniques, and, for lack of a better term, the latest news in physical therapy techniques?
Yes, actually now this is the year we need to renew our license, so we're in continuing education courses now. But yes, I do those every 2 years.
Okay. And so where do you work?
I work for a home health care company called Patients First Home Care.
Okay, and how long have you worked for them?
It just opened up, so under a year.
Okay. And then prior to that, where did you work?
I worked at Aviana. It used to be Doctor's Choice Home Health Care, and then before that was Agility Physical Therapy.
All right. And how long did you work at Agility Physical Therapy?
I did many positions before I started working as a licensed therapist there, so the time blends. But I think as a physical therapist, I worked for a year.
Had you had a number of pediatric patients, pain patients, or, well, physical therapy patients prior to Maya Kowalski?
At Agility, we got a lot of students in soccer injuries, so I was used to working with children.
Right. And in working with children, how important is it, from your experience, that they trust the physical therapist?
I see a lot of when therapists interact and go by their emotions and not be too aggressive too quickly, that they respond better.
And so is the point then to make sure that the patient trusts you and knows you're not going to hurt them?
Exactly.
And have you found that that approach generally brings better results with the patients?
Absolutely, yes.
All right. So the first time, and I think we can bring up, that's the last appointment. Where's my first appointment? All right, can we bring up then Joint Exhibit 1028-0023? And for the record, this is an Agility Physical Therapy and Sports Performance daily note billing sheet for July 29th, 2016, the day you got your license, I guess.
Yeah, the day after.
All right, so this is going to go back to the jury. This is in evidence, this will go back to the jury, but I wanted to take you through a few of these so that the jury had the breadth of what we were doing. Can you explain a little bit about these different areas here on the first and second page and what they mean?
Okay, so we have the assessment which is basically how the patient is presenting, what they're feeling, how we're viewing their ability to stand, their strength. So we're looking at also her range of motion, what can be performed with pain, without pain, if there are any deficits in her strength and range of motion, and what we need to focus on first. And those would be, our short-term goals that could be achieved in 4 weeks, 6 weeks, and then the long-term goals, which is much farther out at 12 weeks.
And then, how did Maya Kowalski present to you on this day? How'd she look? How was she doing?
She looked very thin. Her heel cords with the Achilles, her calf muscles, very, very tight. So toes were always down. Very, very sensitive to leg touching. Skin mostly everywhere, very hypersensitive, but definitely on the legs and feet, for sure.
If you're aware, was this after the trip to Mexico and the ketamine infusions there?
Yes.
And was this after the series of infusions from Dr. Hannah she received over the course of the spring and summer?
Yes.
And so, tell us what you did that day and your assessment as you worked through it with Maya.
She tried very hard to do all of the testing, even though it was very painful. She wanted to have the most accurate test results with this first visit. That way we can plan our plan of care accordingly.
Did she appear interested in getting well?
Absolutely. Very, very, very committed.
Right. And what could she do and not do at this point, noting this is approximately, and for the record, this is approximately a month or so before she went in on October 7th to Johns Hopkins?
She was sitting up pretty well. In the very beginning, she needs some support with sitting, but eventually we worked to unsupported sitting. Her trunk and core were getting very strong, and eventually it led to upper arm strength, and that helped her a lot with sitting without her back supported, without any pillows on the side to prevent her from falling over.
Did you, was she still in a wheelchair? Is she still arrived in a wheelchair?
Yes.
And through the course of your treatments there, prior to the visit to Johns Hopkins, did she make progress?
Oh yes, prior to John, yeah. We made a lot of progress together, and I was very hopeful at the time because the infusions were going pretty well. She would still have her bad days and struggle, but she was very hopeful and very committed to what she was doing and tried absolutely every exercise I would throw at her.
And based upon what you saw, and again, these will be in evidence, but did it appear to you that Maya was getting close to getting out of that wheelchair?
Yeah, yes.
And was Maya excited in this end of the summer, beginning of the fall to get out of that wheelchair?
Very much so.
Did she like being in that wheelchair?
No.
Okay. And you were aware at this time that Maya had been receiving different treatments for, well, first, were you aware that she had CRPS?
Absolutely, yes.
Were you familiar with the symptoms of CRPS?
Yes.
Can you tell the jury whether Maya's symptoms, as you observed them, appeared consistent with your knowledge of CRPS?
Absolutely.
What did you note?
The hypersensitivity in the skin. Hers was a very severe case as it was global, meaning that it was in the arms, legs, trunk. So she would wear shorts a lot because she could not even tolerate any fabric on her legs. Sometimes there might be a little lesion on the thigh, pale coloring, cold skin, and grimacing a lot because any sort of movement is very, very painful.
Was she the type of child that would, leaving aside the CRPS supersensitivity, but was she the type of child that would, lack of a better term, scream bloody murder if it started hurting, or was she the type of child that was quieter and more stoic about it?
She definitely tried to be stoic as possible. Never screaming, a couple times it would have gotten bad enough, maybe tears in her eyes, but never screaming, never crying. I would never get her to that point. however.
And can you explain have you worked with chronic pain patients who are not receiving pain medication at the time they're going through it?
I have not met anyone not receiving pain medication going through CRPS.
But leaving aside CRPS, have you had experience with people trying to make it through physical therapy without any assistance for the pain?
I've had patients try to do it, and they can't tolerate it.
Does the pain inhibit the ability to perform certain of these exercises?
Absolutely. Anything from brushing your hair, washing your hair, rotating around to wipe yourself for the toilet, getting in and out of bed, those things.
Did you receive some medical records upon referral over to Agility Fitness?
Yes.
And I don't have them here in front of me. If you can recall, what did you receive?
From Dr. Hanna,
Okay.
about what his treatment was for her, what he wanted us to avoid as therapists, certain techniques that could make her condition worse.
Okay. Let me show you then what has been previously marked into evidence as 2793 and also 2794 right after it. And for the record, 2793 is a photograph, and then 2794 is an email, and I add 2794 to orient you as to the date of this photo. I'm sorry, it's 2408. God, these 2408 1712 and 2408 1711. Now, is that you there?
Yes, that's me kneeling down in front of Maya, getting her strapped in. If you guys aren't familiar with what this is, there's a thick cord and it's attached to a railing system that goes around. So if someone is not able to tolerate or stand up strong enough with their legs, with their full body weight, we can kind of adjust it, lift it up, almost like they would kind of be up on their tiptoes, to try to associate what it would feel like to have your feet on the floor without all of your weight pressing down on it, to try to slowly introduce that to her body and to the bottom of her feet especially.
So at this time in September 23rd, 2016, can you tell the jury looking at this whether Maya was going to be capable of getting out of that wheelchair and walking on crutches soon?
Yes, as you can see, we loosened her heel cords quite a bit, her Achilles, so if your calf muscles are so tight, your feet will mimic walking on high heels without any shoes on. So we were working on getting her heel as close to the floor as possible to get her feet flat, but you could see that right foot is still wanting to turn in and point a little bit because there was some tightness and definitely a lot of pain.
So, but was her dystonia, did her dystonia, that is the turning in of the feet, improve as you worked with her through the end of the summer?
Yes, we were doing a lot of gentle stretching, and she was doing some of that at home.
Now, I noticed on her legs there are pretty thin. Mm-hmm. At this point, from the beginning when you first started to work with her up until she went into Johns Hopkins, can you tell the jury whether Maya was putting on any muscle mass on her legs?
Yes, her thighs were getting stronger. You could start to see the tone in her thighs as we were progressing.
And as she did better, can you tell the jury about her mood? Did her mood improve?
Yes, she was much happier coming in, looking forward to the treatment. Even though it was very taxing, painful, she was getting some results out of it, and that's very motivating as a patient to keep trying. Even though it's hurting, it's worth it.
And in your time when you had a lot of adolescent and pediatric patients, Did you have any parents that demanded to be with the child on every minute to more or less control the situation?
No.
And with Beata Kowalski, can they tell the jury if it was true with her as well, that whether she was trying to control everything, unusual behavior, or whether she was a normal parent?
Absolutely normal. Of course, in the beginning, both parents wanted a little rundown of what we were going to be doing with her, as they should, and they felt very confident and comfortable. And after that, I just saw Jack, and he would just hang out in the waiting room, and if Maya needed to look at him to see his big smile, he would have it, and if he saw us doing something really cool, like this, he would snap a picture, and
Okay.
it was really good.
All right. Let's see if we need to skip ahead here. All right, so let's jump ahead then to, I want to get the last one before, so pardon me for a moment here. Let's find the last one. There's 927. I did have these marked, but. All right. Let's turn to, if we can, Joint Exhibit 1028-009 for the record. This is a daily note and billing sheet dated September 27th, 2016, and depending on whether September has 30 or 31 days, I think 30, then this would be approximately 10 days before she went into Johns Hopkins. Was this the last visit with her?
I believe so, yes.
And so, tell us again, right before she went in.
What's the exhibit number?
Exhibit number one, it's got it marked here, 1028-0090.
I have that up.
Okay. Well, that's it. Now, 927.
90.
Yeah, that's it.
Exhibit, joint exhibit
Yeah, that's it.
-90.
Okay. Well, we've got it up. So I'd like you to review this, and then in a moment we'll turn to the second page. And so you've got there under current complaints and prior levels of function, current functional, all of that. Are these aspirations? In other words, what you're trying to get the child to do?
Yes, this is the goal, her
Okay.
goals.
So where it says, for instance, maintaining body position and remaining standing, is that an indication that she was actually doing it, or that was the goal to do it?
That was the goal that we set up, to get those muscles stronger to eventually be able to achieve those goals.
Let's look at the next page, 1028-0091, and that's the second page of this. And tell the jury what's going on here.
These are all the exercises we would do, but the deferred today is what we avoided. So instead of me erasing all of that, I would just kind of grab it and see what I did last time and how she responded to it, if there was anything I needed to remember. But as you can see, she was doing some tall kneeling balance. So that means she is on her knees, not her butt resting on her heels, kneeling and able to control her trunk.
So that means she could kneel up on the bed.
Yeah.
And if there's a video later of Maya kneeling up on the bed, she had gained that much strength to be able to do it?
Yes, and a bed is difficult because it's soft. So there's a lot of give, and your core needs to engage to avoid falling side to side.
Okay. Now, there has been some testimony here about Maya sitting what has been referred to as crisscross applesauce. Have you seen children, patients of yours or others that sit in this position, and can you explain to the jury why?
This position provides some relief on our low back. That's why we have a tendency to cross our legs when we sit. It kind of gives relief on the pelvis where it meets the low back, providing some muscular relief from pain, especially if you're uncomfortable. I've known a lot of adults do it as well as children.
Is this generally well known among physical therapists that sitting crisscross applesauce is not an indication of the child is doing wonderful, but more an indication the child has low back or upper leg pain?
Absolutely. She asked, yes, she was just trying to get comfortable.
Okay. All right. And so completing this here, she has, turning to the third page, she still has some, what does it say, diminished AROM. Maybe you can help the jury with some of these acronyms.
The AROM is active range of motion. So what she can do on her own. She can physically take her arm and lift it. No one else is taking it and lifting it for her. LE is lower extremities, so that's your legs. And UE is upper extremity, your arms.
All right. So as of this date, were you feeling positive or negative about Maya getting out of that wheelchair and returning to a semi-normal life?
Very much so. That was very helpful. We were going strong, and she was doing very well. The kneeling was the big next hurdle, and she was doing that excellent. She had her core strength improving, her trunk control. She was doing very well.
All right. And so I'm looking for over the course of the rest of the year, did you see Maya? Did you see her? When was the first time you saw her, if you recall?
When she came back after after she was in the hospital. Okay.
And I have a feeling there's one before this. I'm sure someone will point it out. But I'd like to take you to Joint Exhibit 1028-0093, which for the record is that billing sheet 01, so January 17th, 2017. Let the record reflect that Maya was discharged from the hospital on January 14th, 2017, approximately, 3 or 4 days before. So this is your first time seeing her back?
Yes, and this will show just how motivated she was. You know, a lot of us would have probably wanted to take a lot more time off, but she was in there days after everything she went through.
Threw herself into it.
Absolutely. She's very committed.
But tell the jury about the difference in physical condition as you saw it from a physical therapist's point of view from the last time you saw her before she went into Johns Hopkins and as she literally had just come out of Johns Hopkins.
She seemed much, much thinner than the last time I saw her, especially her legs. There was a couple abrasions on the thighs. Her pain was through the roof, very distant, very difficult to communicate with at the beginning because she doesn't, she's fearful of opening up, fearful of the consequences.
And so, did you notice whether her dystonia had returned or not?
Yes, it was worse. Although the stretching that we did for her calf muscles, Achilles, the heel cord, tightened up again, maybe even a little bit worse than when we first started.
Okay. And so on the pain scale there, I see partly down, she's describing worst 8, best 5, current 7. Orient the jury to what that means.
So that's the pain scale. 0 out of 10 means you have no pain at all. 10 means that you can punch your injury and it won't hurt any more than it already is. So 8 out of 10 is very high.
So at 5, was this a good day for Maya?
I would say that was about medium.
Okay. All right. And what else can you tell us about Maya's upper body? Did she need assistance to stay upright in the wheelchair?
Yes, she was slouched to the side, so you need pillows to support, otherwise you risk, skin breakdown. So Jack was very good about making sure she was turning, that she was offloading those bony prominences on the side of the wheelchair because she was also very, very skinny, much skinnier than when I last saw her.
How about the circumference of her thighs and then calves? Had it increased or decreased?
Decreased.
Significantly or just a little bit?
I would say moderately.
All right. And in terms of range of motion, did you find that she had diminished in terms of her ability to move?
Yes. Before I saw her, she had deltoids that we would all be jealous of. Her shoulder muscles were so defined, and she was so strong. She could walk on her hands probably if she wanted to. But when I saw her again, everything was very, very weak, no tone left in the shoulders.
And in terms of the ability, for instance, to raise her arms, was that increased or decreased as she came out of Johns Hopkins?
Decreased range of motion.
And did you go through all of the standard evaluations as a physical therapist to assess her state at that point?
Yes, Alan did that.
And so you set about, I guess here, a chance to bring her back, if you will. Is that right?
Oh, yeah.
Okay. And so, again, what did you notice about Maya in terms of her tolerance of the pain she was in? Did she reject a lot of exercises, or did she just try to gut it through best she could?
She would participate in everything I asked her to. The only reason if I would change something is if she was grimacing pretty significantly and that grimace wasn't going away. I would maybe change her body position, maybe change the exercise, but still work the same muscles. And so it would still give her some strengthening without excruciating pain.
So throughout the therapy, you were constantly looking for signs she was in pain and would then adjust?
Yes,
for that
if
pain?
it were appropriate pain, or if it were pain that she's not going to want to ever come back to see me again.
All right, and you said before that she had some, and I forget the term you used, but the jury's interested to know, did you note any lesions on her?
Yes,
And where were they?
the upper thigh.
And what did they look like?
They were small, round, a little red, irritated.
They look angry?
Yeah.
All right. And were there parts of her body that were even more sensitive than when you had last seen her in September of 2016?
Significantly, her feet, the legs, below the knee was very excruciating, and it was sad because we made a lot of progress towards getting those feet introduced to some light touching and to some contact on the floor. She was getting very close to that.
And so you continued to see her then through January and into February, and let's see, the last one I have is on August, I think, of 2017, and at this point, some 7 to 8 months later, were you able to bring back some of Maya's? My question is, she had a certain level of fitness and ability to do things before she went in. Were you able to bring back all of it, a part of it? Where was she by 9 months?
She was back to tall kneeling, doing some dynamic balance exercises, which are movement exercises without having support, without a hand on the counter or something that'll stabilize you. So I would throw balls in different directions and she would catch it and be able to come back to the starting position in the kneeling with her tall kneeling. So core and upper body strength was doing great, and we were tackling the legs next and their tolerance to weight bearing.
And so in terms of the levels of pain, was Maya still in pain?
Yes, always.
Did you have to adjust your techniques from time to time so that she could continue a particular exercise or part of the body?
Absolutely, yes.
Can you give the jury some examples of what you would have to do if you saw Maya grimacing about a certain exercise?
Yes. So if she were sitting up performing an activity or kneeling and her body position wasn't cooperating with how her pain was coming in from that movement. So I would maybe make her lie down, do something against gravity, working out those same muscles, but having less pain throughout that.
Right. And from what you saw, although there may have been areas where more or less, did Maya appear to have pain over most of her body, with different areas more sensitive than others?
Yes, the legs were much more painful than the arms. In the beginning, everything was very, very painful. And then the arms were getting a little bit stronger. Her range of motion is improving, able to lift the arms over the head. So then that opens up grooming. She's able to help groom herself. She has some independence there.
But still not out of the wheelchair by this point?
No.
But hopeful, trying to?
Absolutely.
Okay. All right. So at that point, she left your care, and can you tell the jury whether this is unusual in terms of once you have worked through a period, and why?
Yeah, very unusual. I care a lot about my patients, so when they disappear, it's a little shocking, especially with how hard Maya and I were working together and the progress we were making with her treatments by the doctors. They were able to help her get stronger by the treatments they were doing to help get that pain level down, still there, but able to achieve the exercises that we were trying to do to get her stronger.
Did you subsequently learn that Maya was attempting to do many of these exercises on her own at home?
Yes, homework, home exercise program. So if any of you have been in physical therapy, you should always get a sheet with your first visit of exercises to do at home. And because if you don't do them every day, it's not, the physical therapy won't work as well. So she was doing, especially I wanted her to emphasize stretching the heel cords, and that would kind of also hide in some tactile sensitivity, getting used to that with her feet. I was trying to stretch them so she would have contact with her feet and try to introduce some sort of sensation in her feet without excruciating pain.
And I believe, if you have reviewed them, that in the records for ability fitness, those exercises are set out?
Yes.
I'm trying to find them, but we'll let the jury look through them. Now, I noticed one other thing, and that is that from time to time you had something called a patient outcome. And if we could show an example, this one's fairly early, this is before Johns Hopkins, 1028-0041. And then, of course, it would be 0042. All right. So the jury's back there and they want to look through this and educate themselves further on how Maya was before and after. Take them through what this is for.
So this is for activities of daily living. How is she able to accomplish those things, if at all? So we would rate that based on a number.
Got it. A 1 to 10 scale again.
I'm sorry?
1 to 10 scale.
Yes.
Okay. And then, now this was obviously before, on August 17th of 2016, but at that time her pain level was still an 8 on certain days?
Yes.
And she had like moderate difficulty lifting an object like a bag of groceries?
Yes.
But overall, did she appear to be doing better despite her scoring there?
Yes.
Do the patients become more, when they're filling one of these out, do they tend to be more pessimistic than what you're hearing, or optimistic? How would you describe it?
I would say it's per patient, but Maya was very accurate and she's very intelligent, and she would want everything as accurate as possible. So, told her not to embellish, or, if it's bad, tell me it's bad.
Okay. And so then by the time she left you, can you give the jury some idea of, just an estimate of when you were hoping she could get out of the wheelchair?
Before the hospital or after?
After.
The goal was before school. So I think in August the school started. I'm not
August
sure
or
when.
September.
That time of year, yeah.
But she was not able to do that.
No, we were really close, and then the pain was just too unbearable, and I said, maybe by Christmas. And she's like, no, I don't like that answer. So she went home and she said, that's it. and she put on her backpack, got out her crutches, and made herself walk in the home. And I believe that maybe she didn't want to put herself in such a vulnerable, such a high pain position, maybe in public, in the clinic at Agility. Maybe she didn't know how it was going to make her body, her emotions respond, and that's why she didn't want to do it in therapy. She wasn't sure. But at home, she has her creeps, her comforts, her dad, her brother, maybe her favorite show. She can call a friend if she's having a really bad time with it after her experience to try to walk. But she did very well.
Got it. Okay, so I gather overall you felt that the therapy was successful,
Yes,
and Maya was now working as hard as she could to
every day.
every day. Just one moment. Tell us about asthma. When she came in, did you notice any, or?
She would have
Like-
intermittent coughing, but sometimes with asthma, it could worsen with cardiovascular exercises, some jogging, things like that. We weren't doing high heart rate activities. We were focused on strength, balance, transferring.
Okay. Your witness?
Please score.
You may.
Good morning.
Good morning.
My name is Howard Hunter. I don't think we've ever met.
No, nice to meet you.
Nice to meet you. You are here today to testify as Maya Kowalski's physical therapist during a certain period of time, correct?
Correct.
And if I understand correctly, at the time you first saw her, you were still a student.
Mm-hmm.
Is that right?
Yes.
Okay. And then you became licensed almost immediately after seeing her
Right.
as a physical therapy assistant,
Mhm.
correct?
Correct.
Say yes or no.
Correct.
Okay. And then you're still a physical therapy assistant today, is that
Correct.
Okay. When you saw Maya Kowalski, had you seen any other pediatric CRPS patients?
Pediatric, no. Adults, yes.
You've seen some adults, but
Mhm.
no pediatric CRPS patients?
No.
Have you seen any since?
I have had one adult with CRPS.
Okay. Have you seen any other pediatric CRPS patients besides Maya Kowalski?
No, I shortly after I stopped working in outpatient and went into home health, and mostly those are covered with geriatric, Medicare insurances, so I don't see a lot of pediatrics anymore.
And incidentally, when did you leave Agility Physical Therapy?
I'm not sure on the date exactly, but I think I practiced with my license there for a year.
So sometime in, let's say...
I think I started the home health position May 2020.
Okay.
Or, I'm sorry, May 2018.
Okay. Sometime after August of 2017.
Correct, yes.
So like a year or so later.
Oh, less than a year. I started May in my new job, so I finished out, I went through the fall and the winter and the spring, and then by the summertime of the next year, I was at a home health company.
Several months later.
Correct.
Okay. Let's talk about, if we could, some of the chart entries you've talked about. When Maya Kowalski first came in to see you folks in July of 2016, the first person to see her was Mr. Dalton?
I believe so. I think there was Carol Pierce, Alan Dalton, and another therapist that signed off on some notes that I saw.
Okay. And according to what I see here, you apparently didn't really see her yourself until August of 2016. Is that right?
With the evaluation, the physical therapist sees her first,
Okay.
and then I do the routine visits after that.
Okay, so let's talk for a moment about her patient outcome form. That would be 1028 2000 or 1028-14. These forms are filled out periodically during a patient's tenure at a facility. Is that right?
Mm-hmm. Yes.
So periodically, you folks have to update things to give benchmarks of how patients are doing. Correct?
Yes.
Okay. I've been to physical therapy. No others works. Okay, so if we can look at this form, and if I can see it, the first question is pain level, and that's a 0 to 10, right?
Mm-hmm.
And does that solicit how the patient's pain level is that day in the clinic?
Yes, we emphasize how your pain is right at that moment.
Okay. And then her answer was 8, correct?
Yes.
Okay. And then the next question is not on a scale of 1 to 10, but rather 0 to 4, correct?
Yes.
And that's true of all the rest of those categories, all the way down
Yes, on the page, yes.
to that page, and then over to the next page, the same is true. Is that correct? The whole form from that point
0 to
forward is
4,
0
yes.
to 4, correct? Okay. So, not to belabor it too much, because the jury will have this to go back with them, but the number 1 is kind of an overview of all the activities the patient is doing, her usual work, housework, school activities, and it asks the extent of the difficulty that they're having or their ability to perform that activity, correct?
It's focusing on if you had a job, if you were in the working, if you were able to perform your work or household chores or attend school activities.
Okay. And the answer to that question on the 22nd was 0, correct?
Yes.
And if you look at number 2, her ability to go about her usual hobbies, recreational, sporting activities, etc., was a 2, or moderate difficulty, correct?
Mm-hmm. Correct.
And then getting in or out of the bath was 0. She just couldn't do it.
Correct.
And in fact, when she came in to see you folks in July of 2016, this was after Mexico and a number of trips to Dr. Hanna,
Mm-hmm.
correct?
Yes.
She had no ability to get in or out of the bathroom or walk between rooms in her home, correct?
Yes, no walking.
And then she could put on her shoes and socks with a little bit of difficulty, correct?
Yeah, I mean, I think being in Florida, I mean, especially kids, they wear their flip-flops a lot, so she wasn't wearing, I've never seen her in tennis shoes. If she was wearing any shoes, it would have been sandals hanging off of her feet because she couldn't tolerate anything on it.
But what she rated was a 3 out of 4.
Right. So her
A little
ability
bit.
to put it on, not the ability to tolerate.
Right, okay. And then she was unable to squat at all, correct?
Correct, because she cannot weight bear.
Right. And then she had moderate difficulty, a 2, lifting a bag of groceries from the floor.
Yes.
And then the rest of these are 0, performing heavy activities, getting into or out of a car, walking 2 blocks, or certainly walking a mile she couldn't do, correct?
Correct.
And at this point, incidentally, she was wheelchair bound, correct?
Correct.
Then if we go over to page 1028-15, she's unable to go up or down stairs, stand for an hour. She had no trouble sitting for an hour, but she couldn't run or make sharp turns or let alone hop, but she could roll over in bed, correct?
Yes.
Okay. So we look and we see that were you aware that in August, several weeks after that, she went back to Dr. Hanna for a number of ketamine treatments?
Yes.
Okay. And that followed a situation in which she was demonstrating low tolerance for half kneeling and trouble with pain and fatigue, correct?
Yeah, in August?
No,
Yes.
in July.
Oh, in July, yes, yes.
Okay. So then she went back to Dr. Hanna for 3 infusions. Let me ask Clay to put up the next patient outcome form she filled out, which would be 102899. And let's compare those for a moment if we could. Could we put up those side by side? Okay, so we've got 117 on the left, on my left, on the screen's left, and 722. I'm sorry, I've given you the wrong number, Clay. It should be 817, not 117. It should be 14 versus 41. We'll get to 99 in a minute. So we've got her patient outcome form from initially on the left, and basically a month later on the right, correct?
Correct.
And so we see that on the 17th of August, she still had a pain level of 8, correct? And she was still unable to go about any of her usual work, housework, or school activities, correct?
Correct.
And her rating regarding hobbies and so forth was the same, a 2, correct?
Correct, yes.
And if we go down this form, on the first page, we basically see that her responses to the patient outcomes on August 17th of 2016 are the same as they were a month earlier upon admission, correct?
Correct. It takes about 6 to 8 weeks for a muscle to gain in size. So 4 weeks, it's
And
not
if
going to
we-
be too significant of a difference.
If we flip over and we see page, and we compare the second page of July 22nd to the second page of August 17th, that would be page 15 versus 42, we see the same thing, that there's been no change, correct?
Correct.
Okay. Now, after that August 22nd encounter, or I should say on that date, was there some indication that on that day she was experiencing increased pain and having trouble doing her HEP, her home exercise program?
On 7/22 or 8/17?
On, I'm sorry, 8/17 was what I meant to ask her today.
Okay. So was she having difficulty doing those?
Yes, on
Exercising?
8/22.
She was still having some difficulty, yes. She had difficulty throughout the entire treatment, but she was still trying, and this
Right.
test is mainly geared towards weight-bearing activities.
Okay. And then as matters progressed, were you aware of her going back for other ketamine treatments during your treatment?
Yes, yes.
Okay, were you aware she went back for one on September 22nd?
I can't remember the exact dates of her treatments,
Sure.
but
But let me ask to put up number 91, 89 through 89, I'm sorry. And at this point, was she having some difficulty with still performing tasks of daily living? and some increased pain.
I think her grooming abilities were getting better, so managing her hair, bathroom, what we do in the bathroom, wiping, things like that, washing her hands, I think she was improving there
Okay.
by that time, by September.
Okay. Well, after that, she saw y'all, we see on the 23rd, and then on September 27th, let's put up page 90 if we could. So on this date, she's complained of increased pain levels since her last treatment, and she's going for ketamine treatment after today's visit.
Okay.
See that?
Yes.
Before this visit, were you aware of her having any kind of relapse in her CRPS?
I can't remember.
Okay. But you can't remember that before this last visit, the last visit that you saw her on, that she had a CRPS relapse in early September?
Yes. Yes.
Okay.
Is that the relapse she had before she went into the hospital?
Yes, ma'am?
Yes.
Okay. And do you remember the circumstances of it or what caused it?
No, I wasn't there.
But you do recall, I suppose, the last time you saw her before she went in the hospital?
Yes.
Okay. And we see that she was having increased pain levels, and she was going for a ketamine treatment?
Yes.
Okay. Now, were you aware that she went to ketamine treatments on September 27th, 28th, 29th, and 30th?
I mean, I guess all I knew was after today's visit.
Okay.
I didn't know her.
So you didn't know anything about any of that?
I didn't inquire about her daily schedule, no.
Okay. So you weren't aware of an emergency room visit on the 1st of October or the circumstances that led to her being admitted to All Children's on October 7th?
I mean, I can't remember at the time if I found out right then or if it was a few days later after she went to the ER, if I found out then.
But to be clear for everyone's benefit, as of the last time you saw this young lady on September 27th, 2016, before she went into the hospital, I'm talking about last time.
Okay.
As of that time, she was still in a wheelchair,
Yes.
and she still had a significant pain level, correct?
Yes.
Okay. Now, let's talk about, if we could, when she came back on the 17th of January 2017. At that point, the initial evaluation was done by Mr. Dalton.
Yes, I think so,
And
yes.
he's a full-fledged physical therapist.
Yes.
He's your boss.
Yeah, he was. Yeah.
He was at that time. I'm
Yes.
sorry. Not now, but he was then.
Yes. He
Right.
still feels like my boss.
Okay. Well, he was supervising what you did with Ms. Kowalski, correct?
Always, yes.
Okay. And at that time, when she came back on the 17th, she was still having pain level of 8, correct?
Correct.
And she was still wheelchair bound?
Correct. Yes.
Okay. And she was still having difficulty with virtually all of her activities of daily living at that point?
I believe so, yes.
Okay. Did you actually weigh her, or was she weighed?
I don't think I physically weighed her. If it was done on the initial evaluation, I think it would have been on one of the...
Did you folks at any point ever speak with her physical therapist at All Children's Hospital?
I did not speak with anybody at the hospital, no.
Did you at the time, or as far as you know, did anyone from Agility ever look at the records from All Children's from a physical therapy standpoint?
Alan, I'm not sure if Alan had or not.
Let's just kind of hit a couple of high points here. Can you put up, please, 172? Well, I take that back. I'm sorry. Let's back up, if we could, to February 28th. It's 153. And just focusing on current complaints and gains, she was adjusting the size for a wheelchair, had a new wheelchair.
Yes.
And the note indicates that her father stated that she was doing a lot better and was scheduling an MRI of the spine. Correct?
Correct.
And when she, up to this point, was she getting any additional ketamine or pain medication?
As far as I can remember, no.
And after she came back to you from All Children, she never got any of that, did she?
I don't believe so.
So let's go to March 16th. Put up 172. And if you look at the history there, it relates that the patient is doing online school activities daily and swimming regularly. Correct?
Correct.
And she's pushing herself in her wheelchair. Correct?
Correct.
And the history...
Hold on a second, Mr. Hunter.
The beeping.
There's a little beeper going off over there. Can we turn it off? I think it's off now. You can continue.
Sorry, I think I better see.
Yeah.
I didn't hear that. That's wrong.
I heard it.
And by this point, which is basically 2 months after you saw her again, correct?
Correct.
She's pushing her wheelchair as a form of physical activity and exercise?
Yes. Yes.
And she's, the father was telling you folks that he sees her using her legs more, and he feels her exerting pressure when he picks her up to maintain her hold, correct?
Correct.
And he's seeing her with her feet flat sometimes without her knowing,
Yes.
correct? That's making some progress, right?
Yes.
Okay. And then if we go forward once again for another month or so, I'm losing my place here, I apologize. We go to April 18th. And we put up 204. We see in the history assessment that she's increasing her swimming, and her father reports that she's using her legs in the pool, getting stronger. Is that correct?
Correct.
And she's going out on the boat almost every weekend.
Yes, they would physically put her in there, but it would help her spirits to be out on the boat.
Okay. And this is 3 months after she came back to you folks.
Correct.
Okay. So once again, she is making progress.
Correct.
Okay. So if we go forward one more month to May of 2017, to Joint Exhibit 1028-240, there's an indication that she's swimming almost every day for several hours, or for hours at a time, right?
Yes.
And she's starting to scoot from place to place in their house to get around.
Yes.
And she's independently propelling her wheelchair for long distances.
Yes.
And she's able to do her own ADLs.
Yes.
To some
I
degree
mean,
without assistance.
yes, light ADLs, I would say.
Right. Grooming.
Yes.
So then we go forward another date, 7/6, which is 17 to 286. And by history, she's swimming in the ocean without issues, correct?
Correct. That was what was said to me.
And she's got a new bedroom set with a top bunk bed, and she's able to get up and down the ladder without help.
Yes, her upper body was extremely strong at this point. She could basically lift her up without using her legs at all. It was quite amazing.
Okay, and so, but she's also able to climb a ladder.
She would just kind of like swing herself, just kind of use her arms and core and get up there on her own. She might use her knees instead of her feet.
But this is an advancement.
Yes, correct.
Okay. And once again, through this point, she's not getting any analgesia or ketamine.
No, I think she realized she was going to have to do this on her own.
Okay. Now, if we go forward one more time to the last time you saw her, on August 22nd of 2017, page 334, she indicates she's back in school. Very tired from using crutches.
Oh, that was when she went. Yeah, that's when she. I saw her, and she, I said maybe by Christmas we could start walking. And then when she went home and said, "I don't like what Rachel said," and she proved me wrong.
Okay.
And obviously, it was very, very taxing on her because you go from using the chair every single minute of your life to not using it at all. You're going to be very fatigued.
And by that point, her father was telling you that she is no longer using the wheelchair.
Correct.
Okay. And you never saw her again after that?
No. I was glad not to. I was told her, get out of here and don't come back. Well, she had to come back for a discharge, but other than that, I just want to see her at school, at the grocery store. I don't want to see her in the clinic.
I have clients that feel that way about me, too. When you've never seen her again since then as a patient. You were about her age, correct?
Oh, it's whose age?
Well, you were younger, and she was your only pediatric patient.
Yes.
Correct? Okay. Have you had a chance to talk with Mr. Anderson before you appeared here today?
Her lawyer?
Yes.
Yes.
Yeah. And you met with him about your testimony here today?
Yes.
That's all I have. Thank you, ma'am.
We met by phone.
Yes. Oh, yeah, by phone, not in person.
I called you and told you you were going to be a witness.
Yeah, that's it.
Much to your chagrin. The point is that when Maya went in, from everything you saw, all the exercises you saw, when Maya got out of Johns Hopkins care, was she worse off?
Yes, mentally, physically.
And although pain meds may not cure things, can you tell the jury whether it tends to increase the ability of a patient to do the work and makes quality of life more significant?
Yes, Your Honor, Foundation. Overruled.
Yes. When we perform our activities and achieve pain, it makes us not want to do those things. So with some pain medication, your suffering isn't as great, and you can achieve your activities of daily living. You can perform some exercises that will help get you stronger and eventually and hopefully kind of take place of the pain because your muscle's stronger, and maybe you won't need the pain meds as much once you're at that point.
So doing it without pain meds means gutting it out?
Yeah, I'm unnecessarily so.
And I believe you testified before that from what you saw with Maya, her CRPS pain, the levels of it were periodic. Is that right? That the levels would differ depending on which day you were asking her.
Objectively, Your Honor.
Sustained.
What, if anything, did you notice about any variance in Maya's pain levels? Noting she always had pain, but
They would vary in intensity based on activity, based on maybe events the day before, currently, emotionally, I'm sure. And when we're upset, our pain becomes worse. And if she was doing something particularly taxing to her that previous day, she could be in more pain the following.
nothing further.
I think
Members of the jury, do any of you have any questions? May this witness be excused.
She may.
Thank you so much.
Thank you for being here.
Oh my gosh, I forgot to ask you.
Members of the jury, I think this is going to be a good time for a break. Let's try to keep it to 10 minutes. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. You will see it. Will you come?
All rise for a second tape.
Everyone, please be seated. The jury's out of our presence. Are there any issues that we need to address before we take our break?
Do we have anything?
Anything, Mr. Anderson?
I don't believe so, Judge.
No, you're wrong.
Okay, let's be back in about 10 minutes. Are there any issues we need to address? Defense. How long do we anticipate this witness to go, since it's now 10:30 almost?
Direct examination should take approximately an hour, 20, maybe an hour and 30 minutes. I'll try to go through it as fast as I can. And then I don't know about direct. I would expect it to be approximately the same.
So it sounds like we will probably take lunch at the conclusion of direct examination before cross-examination.
Correct. And then we have, if we want to bring it back after lunch, we have now, the court's been hardworking and got us back. We have 5 depositions, I believe, that we can play. I certainly wouldn't put them through that, but we could probably use to have the afternoon as the court had planned.
I'm uncertain. Are you saying you just want to do Dr. Chopra today, which is what we talked about yesterday?
Yes, sir. I was just giving you the options.
I'm fine. That's what I assumed we were doing based on our conversation yesterday.
That's what we understood the schedule to be.
Okay.
And on break, the court deputy did say that the jury has asked that if we could tell them whenever we're going to have like days off.
Oh.
So my thought is I will tell them, we should be able to tell them tomorrow what next week's going to look like.
Okay. I would anticipate, despite our best efforts, that we will finish slightly early, maybe 4, somewhere between 3:30 and 4:30. It just depends on length of cross-examination.
Today?
No, tomorrow.
Okay.
Friday. So I'm sure they won't be upset getting out a little early on Friday afternoon.
Do we know who we're calling tomorrow?
Well, it's a number of them. We're still waiting for confirmation on a couple of them. Give me a couple and we know.
Spiegel and Barr.
Oh, Dr. Spiegel, Dr. Barr. You don't want to know about those. Yeah, Dr. Spiegel and Dr. Barr tomorrow. And
Are they confirmed already, or are you waiting?
Yes, they're confirmed. But our lay witnesses, we're juggling. But we may know something by the end of the day.
So I thought at lunchtime will we know more? Okay.
We're doing our best.
Okay. Anything else?
Not before this witness.
Bring in the jury. Please be seated, everybody. Members of the jury, I want to confirm that while you were away, you did not discuss this case amongst yourselves. You did no investigation. You received no information. Is that all correct?
Correct.
Again, I'm going to be asking you these additional questions as well. Have you been approached by anyone about this case since the last time we talked? And have you seen any media coverage concerning this case since the last time we talked? Okay. Mr. Anderson, your next witness, please.
I'll call Dr. Chopra, Pradeep Chopra.
can raise your right hand.
Do you solemnly swear or affirm testimony about to give will be the truth, the whole truth, nothing but the truth?
I do.
We're going to come this way. You're going to sit in the witness stand there.
Sure. Welcome, Doctor.
One moment, Your Honor, I want to make sure I've got an exhibit correct.
You're welcome to have a seat if you wish.
Yes, sir.
Please state your name for the record. I apologize. Please state your name for the record.
Pradeep, Pradeep Chopra, Chopra.
And have you been asked to testify here as to the condition of Maya Kowalski when you examined her in 2017?
Yes.
So I'd like to give the jury the benefit of some of your background, training, and experience. The first thing I'd like to start with, if we could, is your schooling. If you can tell the jury a little bit about that. First, what kind of doctor are you?
I'm supposed to be a pain medicine doctor, but I take care of medically complex patients, mostly with pain.
Okay. And where did you go to school, starting with college?
My medical school was at the Harvard Medical School. I did my basic training over there, and I did my residency in anesthesia and critical care, and then I did my fellowship in pain medicine.
And was this all at Harvard?
This is all at Harvard, yes.
How many years did you spend at Harvard Medical School and the Harvard Medical Center?
6 brutal years.
And do you often speak on the issues of CRPS and chronic pain?
I do.
Have you prepared different TED Talks or the same type on these issues, CRPS and chronic pain?
No, I haven't done a TED Talk, but oftentimes different organizations, various organizations invite me to give a talk. It's mostly to patients, and sometimes hospitals will invite me to give a talk to their physicians on CRPS.
I know that you have won several. Well, first, tell us a little bit about your family. You're married?
Yes, I am.
And you have how many children?
I have a child.
And I understand one of them has some challenges?
Objection, Your Honor.
It's predicate for his ability to...
I have a son, and he's a special needs child.
And so are you familiar with the challenges to parents for special needs children?
Yes, I'm very familiar with that.
I understand that you have won several awards over the course of your career for humanitarianism involved in medicine. Can you tell the jury about that?
Yes. There's a bunch of awards that I've won, actually.
Okay.
But for the humanitarian award, it's called the Compassionate Care Award. This award is only given to one physician in a year out of the entire country, and it's a very rigorous selection process, and they look at the patient is the physician is compassionate, has empathy, and many other things.
How long have you been in practice?
I started practice in 2000.
Okay. And are you board certified?
Yes, I am.
And what are you board certified in?
In anesthesia and critical care, and in pain medicine.
And do you have experience in pediatrics of any of these areas?
I do.
Tell the jury a little bit about your experience with pediatric pain management.
So of the 6 years that I spent in Harvard, about a year of that was spent at Boston Children's, where I practiced anesthesia, critical care, as well as pain medicine.
And so you had the opportunity at that time to see pediatric patients with pain, chronic pain issues?
Yes, I did.
And what do you do now? Are you teaching now?
I do. Well, I run the Center for Complex Conditions, which means I see mostly very, very medically complex cases, both adults and children. And I also teach at the Brown Medical School.
And Brown University is an Ivy League school?
It is an Ivy League school, yes.
And what do you teach there?
Same thing. I teach my students how to, I tell them that you're going to learn medicine all your life, but you need to learn how to be able to examine a patient, how to be empathetic to a patient, how to listen to them, how to understand what they're trying to say, and that's my job. That's what I try to teach them.
So you're a professor at an Ivy League school. Can you tell the jury the importance of a physician gaining the trust of the patient in terms of care and treatment?
Well, gaining the trust of a patient is to be able to, number one, the most important thing is listen to the patient. Take the time to listen to what they're trying to say. And once you listen to them, then you can, ask them some questions, get to know them better, even get to know their families, and then do a full physical examination, not just a partial examination, and then sit down with them and come up with real expectations. What are the real expectations? What to really expect, and what your plan is to help them.
Now, tell the jury a little bit about how you got involved in the examination and rendering opinions about Maya Kowalski.
I was back in whenever she came, I can't remember the year.
2017.
2017, I received a call from the court. And I can't remember whether it was the judge himself or somebody else from the court. And I was told that they needed me to examine a patient and give an opinion on that.
And do you know how or who recommended you to perform this examination?
I honestly don't know who recommended that because I wasn't really paying attention on that.
Okay. It could have been Beata Kowalski, it could have been one of the physicians involved, could have been any of the parties involved.
No, it wasn't anybody from the Kowalski family. It was not a physician. I know it was somebody had to do with the legal system. It might have been her attorney at that time, or it could be somebody from the court.
I see. And so, what steps did you take then? And ultimately, did you prepare a report, which the record reflects is in evidence at 2005-001 through 2005-021. May I approach to have the doctor identify?
You may.
And is this the report you ultimately prepared?
Yes.
Now,
this is the report.
Okay, you can. We'll get it back in a moment. Now, so you weren't a formal, what's known as a CME or IME, but you understood that you were supposed to render a fully independent opinion?
Yes. So this call that I got from the court in Florida I was tasked with one job, and the job was to give my opinion about what was going on with Maya. And that was it. I was not going to be the treating physician. I was not going to take over the care, just give an opinion. End of it.
Got it. I forgot, you have some additional degrees. What is a MBBS?
MBBS is, so before you come to the US, you have to be a physician back in India. So I'm from India.
Right.
And you get a degree, it's called MBBS. It's a British degree.
Right.
And then you do your MD and all that again. So I went to med school twice.
Okay. And what's a DA? Is that similar?
A DA is a kind of it's a diploma in anesthesia. It's like a mini training in anesthesia for a year.
And then MD and then MHCM. What is that?
That was from the Harvard School of Public Health. That was on Masters in Healthcare Management.
All right. And so have you worked in both hospitals and in private, seeing patients clinically?
Yes, I have worked in quite a lot of hospitals. Now I don't work in a hospital. Now I work in my own office.
Okay. Now, tell me what you first did. Tell the jury, rather, what you first did in your job, as you saw it, to survey this course of treatment, and then subsequently, I suppose, examine Maya. Tell them how you went about it.
Right. So, they sent me a boatload of documents. Scary. That was scary. That was like documents like 5,000 pages. And but I don't review documents before the patient comes in. I need to make my own opinion first.
Why is that important?
It's important because I don't want my thinking to be biased by reading other people's reports.
Is there a problem in medicine with a diagnosis taking on a life of its own, otherwise known as a narrative?
Yes, it's a major problem. What happens is that one physician, maybe depending on his competency, incompetency, makes a diagnosis without any basis, and then that gets populated into the medical records, and then it's just, after that, it's just passed on forever because no one wants to change that.
And so it takes quite a bit of gumption, for lack of a better term, to step in and change the narrative.
Objection to the leading, Your Honor.
Sustained.
What, if any, effort does it take to change the narrative?
It's almost impossible. I've had a few patients who have tried to do that, and it's extremely difficult.
But does that mean a doctor should just blindly follow a narrative, or should they give it an independent view, excluding a narrative?
So if it's a major diagnosis, and it affects, so if I'm seeing a patient, and let's say that I'm seeing the patient for pain in their left knee, and they also have asthma, I'm not going to worry too much about the asthma part. I might say, hey, do you have asthma? And they'll say, yes, I do. But I'm not going to go into great depths with it. My focus will be more on the knee part then.
So you saw Maya first before you reviewed all those records?
Yes, I tend to, the way I work is, I don't like to be biased, so I see the patient first, make my opinion, and then I go back and look at the medical records in detail, and then figure out where we are with it.
So I want to deviate a little bit from going through your findings, and I first want you to help us understand CRPS as you know it. Have you treated CRPS patients?
Oh yes, I have a lot.
Okay. Can you give the jury an idea of how many per year?
I actually did that calculation for this. Yes. So approximately 5 patients a week for 20 years, and the math came out to be about 125,000 patients in the last 20 years with CRPS.
My goodness. And have you yourself participated in any studies or surveys?
No, I haven't. You mean done research on it?
Yeah, or cooperated in providing patients for clinical evaluation, things like that?
No, I don't want to. I don't like to send my patients for clinical. They're already in so much pain and they're already suffering, and I don't do that.
Understood. So tell us now the signs and symptoms of CRPS that they can understand as we go through this and show photos that they should look for here.
CRPS is one of the few pain conditions that you can literally see. I mean, if I say I have a headache, you can't see the headache. If I say I have knee pain, you can't see that. But CRPS is one of the conditions you can actually see. And the diagnosis of CRPS is based on very clear rules and regulations. There's a whole checkbox, and you have to check certain boxes. And when you check a certain number of boxes, then you come to the conclusion that the patient has CRPS. So, for example, am I?
Yeah, no, please. I'm asking you to go through. If it's okay.
Right. For example, obviously the first one is that the patient has severe, excruciating pain, and there is no other explanation to it. Nothing else explains it. That's the number one. Number two, the rest are kind of optional, and you have to pick and choose which ones you see. So one of them is there a temperature difference? So if I have CRPS in the left leg, and so the temperature in my left leg might be hotter or colder as compared to the right leg. The next thing is you look at color change. Oftentimes the affected side is either dark red in color, even blue in color as compared to the right side. You look for swelling. In the initial phases, swelling is pretty obvious. Later on, you don't see it as much. So you look for swelling in these patients. You look for skin changes. The skin may sometimes become thin and shiny, or they may develop small, tiny lesions, almost like blisters that are painful. They can develop that. They even develop hair changes. Some patients actually grow more hair, and some patients have less hair. It can be in the same side or on the opposite side. You can see nail changes. Their nails start to kind of break off. They get brittle nails.
What about asymmetry in muscle groups from right to left? Is that an indication?
I was getting to that. So the last one is muscle symptoms. So do they have what's called dystonia? Dystonia is a terrible condition. So I'm going to show you. If I had dystonia in my left hand, it would be like a tight muscle, like the arm is taking a life of its own and it's cramping up. Or they may have tremor. So they may not have tremor when you don't do anything, but if you say touch them and then they start to have a tremor, they may have muscle weakness, they have muscle atrophy, the muscle starts to shrink. So there are many muscle symptoms that these patients can have.
I want to, if you could, and I think I wanted you to explain what really happens in CRPS, the central. I want you to explain what we know so far about CRPS, how it starts. Yes.
I just have one other clarification on
Go
CRPS.
ahead, please.
When I say that these patients have pain, we're talking about the world's worst pain. I mean, this pain is worse than amputation pain. This pain is worse than childbirth pain. The gentlemen on the jury won't understand that, I'm sure. This pain is so bad, so bad. The worst part about this pain is that, if I stub my toe, it looks like the world is going to come to an end. Okay, but I know that this is going to go away in a few minutes. But CRPS pain does not go away. It's there 24 hours, 7 days of the week, and it just stays on and on and on. And the worst part is that there's no known treatment to this. We try all sorts of things. Some work, some don't work. But this is such a this is often known as a suicide condition, because these patients, the pain is so bad, they can't sleep, they can't eat, they can't work. Their families don't believe them, because you don't think like somebody. The general impression is, oh, you have pain, take a Tylenol and it'll get better. This is not Tylenol pain. This is your hand in a hot stove. That's exactly what they described as. In fact, patients describe it as if their hand is inside a hot fire stove, and and they can't take it out. That's the thing. So I just want to clarify that this is, when I say pain, it's not a small itty bitty pain in the joints.
And what is the McGill pain scale?
The McGill University in Canada decided to see, like, okay, where do pain conditions stand? So they interviewed a bunch of people, and they said, all right, where in this scale would you put your pain? Like pain from labor or pain from amputation of a digit. And so they drew a scale, and that scale, CRPS was was way above anybody else. It was way above amputation pain, cancer pain, or even labor pain.
With your permission, Your Honor, I'd like to publish a photo of the McGill pain scale. Can you bring it up? The jury can see. Ta-da!
So
miracles of technology.
What I'm seeing is what the jury's seeing?
Yeah, the jury sees that.
Okay, so if you go from the bottom, you can see, tension, headache, sprain, and so on. As you go up, then you see non-terminal cancer, chronic back pain, and as you keep going up, prepared childbirth is number 32, and then you keep going up, and then you come to amputation of a digit is 39, and then so forth, and then finally CRPS, often it was originally known as RSD, is rated as 46. So on a scale of 50, 0 to 50, CRPS is 46. Nothing is higher than that. It's such a terrible pain.
Now with this, can you tell us from your experience whether any of your patients have had, not parents, patients, but any of your patients have had difficulties going through a number of doctors before they're diagnosed?
Yes. So unfortunately, most doctors don't know about CRPS. They may have read about it and they must have blown it off as being an extremely rare condition. I don't need to bother with it. I'll probably never see it. But unfortunately, it is a very common condition. And they miss the diagnosis. They think it's an arthritic pain, or they think it's some sort of a muscle pain, and they get prescribed some of these itty-bitty pain medicines. And it was not an official study, but it was a very unofficial, kind of an anecdotal article in a journal. And they said the average...
Hold on,
what's the legal basis? Sustained.
Well, just tell us without going into the details of any study, just tell us what the latest finding is.
Same objection, Your Honor.
What do you understand the latest, the standard, the knowledge of CRPS is, as you were about to relate?
You mean how many patients develop CRPS?
Well, that'd be interesting.
Okay, so, essentially patients go through a lot of physicians before somebody will say, you know what, I think this is CRPS, you should go and see the pain physician, and they might be able to better diagnose it.
Have you seen or is it, the better question is it prevalent or not prevalent that when doctors cannot figure out this disease, they assign a somatic basis or a psychological basis?
Okay, so this is an interesting phenomenon. There is a difference between young women, especially, versus adults. Usually, young women, and CRPS is, by the way, very much more common in women than in men. When they present with it, it is often stamped as being psychological or anxiety or making it up or some sort of a psychiatric diagnosis. Like you really don't have pain, you're just seeking attention. In adults, it's a whole different situation. In adults, it is taken much more seriously. You know, they are offered different treatments and different specialists who can then look at it more carefully. And that's the big.
Go ahead.
That's the big difference between younger patients and adults.
And so, what is the effect on these children, younger patients, for having their pain denied by physicians repeatedly?
Well, put yourself in their shoes. Let's say you're a 12-year-old girl who develops this CRPS in her left leg from doing, acrobatics or something, rollerblading or something. And then now you have this severe pain, and obviously the first thing your parents are going to do is, put something on it, give you some Motrin, Aleve and all that. Doesn't go away. And now it's becoming excruciating, and it's becoming red, hot, swollen, and you can't even wear clothes. So then your parents take you to the doctor, and then the doctor, again, has no clue what's going on, not sure what's going on. Eventually go from doctor to doctor because they go to an orthopedic, the orthopedic sends them to a neurosurgeon, the neurosurgeon sends them to a physiatrist, and it continues the cycle, and eventually they'll get to one person, and that one person will say, I know this condition, it's CRPS, and then they go on to, getting the treatment that they need.
So now once, what I'd like to go through now, if we could, and for this, I don't think counsel has an objection to the actual the pictures. That was not part of your objection. Glial cell pictures.
No objection to the
all right. So let's go to 12 if we can. Now, coming up here is something I think you provided for us to. It's an incredibly sophisticated artistry, but
that it should be in the Smithsonian. I can tell you that. Are you seeing it?
Yeah, just a second. He's getting it. I tend to jump around a lot, and so.
All right, I apologize, but that's my drawing. Okay. But that's how I think. Okay, when you have only one brain cell, that's how you think. So this. So I just want to, before we get into this picture, I just want to explain to you what happens in CRPS. Like, okay, we got this pain, but what is going on? So the brain is not a bunch of nerves. So if you cut open, well, my brain you'll see only one, but if you open Attorney Whitney's brain, you'll see a ton of nerves in there. But that's not what. It's only 20% of your brain is made up of nerve fibers. The electrical wires in your brain are only 20%. The rest of it is packing material. And that packing material is known as glia, which means glue. So in the old days, the thinking was that, there are these nerve wires in the brain, and to support it, you would put some packing material in there. And that was the idea, that there was glial cells, and they had no other function. But now we know that they have a lot more function. And besides CRPS, they're also implicated in Alzheimer's disease and dementia and other conditions. But in any case,
Let's show the next one.
Well-
The 13 here. Another beautiful sketch you've done for us.
so what happens is, this one I need to explain. If I take a pen and I stick it in my finger, a signal goes up into my brain, up my arm, into my spinal cord, into my brain. And my brain then reads it as pain. And I yell out, pull the pen out, I rub it, it feels better. Everybody goes back to their business. But if I take a pen and I keep sticking it into my finger again and again and again and again for 24 hours a day, then there's a barrage of pain signals that are going to my brain, and there's a barrage of pain signals coming down. This traffic of pain signals activates the glial cells. These glial cells get upset, they get angry. And when they get angry, we can
Yeah, let's show
go to the
14.
next slide. When they get angry, they release chemicals. These are called chemical inflammatory mediators, which means that they produce chemicals that cause the nerves. Because remember, these glial cells are around the nerves. These glial cells then, when they get angry or when they get inflamed, they then release chemicals that cause the nerves to get inflamed.
Let's go with 15. Okay.
So now the nerve is inflamed. And this is the basic mechanism by which a lot of chronic pains can be explained, but this is the basic mechanism behind which CRPS is explained. So what I'm trying to say is that CRPS pain, so if I have CRPS in my left leg, it doesn't live in my left leg, it lives in my brain. So you could essentially cut my left leg off, I would still feel the pain because the glial cells in my brain are still activated. Eventually, if you cut off my leg, eventually the glial cells are going to say, oh, we're getting no more signals, and then they calm down, but that's a different story. So the treatment for these glial cells to calm down is, all treatments that we do are to make these glial cells calm down, so that they're not as angry.
Do we know why the glial cells get angry yet?
We're not 100% sure why they get inflamed, but one of the theories is pain that comes on from CRPS. The repetitive pain signals going to the brain cause these glial cells to get inflamed.
And can this process, the CRPS, glial cell aggravation, start in some patients from an emotional event?
So once these glial cells are inflamed and you're in the process of treating them and they're starting to calm down, like not all of them calm down at the same time. Some calm down and some don't, and say 20% will calm down first. But if there's a triggering event like, let's say, emotional stress or physical stress, then these glial cells go back to getting inflamed again.
And so does that happen every time, or is that, again, kind of a hit or miss on whether it's going to happen?
That's a difficult question to answer because there's a lot we don't know why this is happening. So it's, I mean, depending on the stress, okay, I have an exam coming up, the glial cells are probably not going to get activated. But if somebody came and punched me in the nose, then I guess the glial cells would get activated.
And through the course of this, and we'll get back to the examination in a moment, but through the course of this, have you had the opportunity to review the Johns Hopkins records pertinent to this case?
Yes.
And can you explain to the jury in terms of this, some of the cells being activated, some of the cells being not, the problem with interrupting a treatment process?
so I have to go, in order for me to explain that, I have to go a bit outside the John Hopkins treatment paradigm.
Go ahead.
So, in this case, she was getting her treatments, okay. She was seeing doctors, the doctors were giving her drugs, and she was starting to, there's a whole algorithm. It's not just simply giving ketamine or some one drug and magically everything disappears. So she was slowly starting to get better and much more active. And then what happened was at the John Hopkins, all of this was suddenly stopped. And when it stopped midway. It stopped at a point where she was improving, everything was stopped, and the glial activation came back, her pain came back, and plus the stress, the emotional and the physical stress. Remember, one of the things I told you about CRPS was that this is pain to touch. So it's not as simple. Even the slightest touch causes pain. But the problem is that if I have CRPS in this hand, and if I touch it lightly, the whole hand hurts. And it continues to hurt for weeks. And what was happening at the hospital was everybody walking by would touch her. I'm not sure why, to test her, to examine her, for whatever reason. Various people would touch her again and again at different places. And each time they did that, it was triggering the pain again. And remember the barrage of pain signals going up to the brain that would cause the glial cells to get inflamed? That would keep repeating again and again.
Is that one of the reasons why well, let me ask you, do you have an opinion based upon your background, training, and experience, and from your examination of Maya and your review of the records in this case, as to whether the treatment she received at Johns Hopkins All Children's Hospital in October, November, December of 2016, and then into January of 2017, whether that permanently aggravated Maya's CRPS?
Is that the time when she was sequestered in the hospital?
Correct.
Yes, that did.
And that what you just explained, is that the reason why the glial cells had not fully gone back to normal at the time it was interrupted?
Right. So
objection, I would like to approach him.
Approach, please.
I'm going to overrule that objection. Mr. Anderson, you might need to re-ask the question for the doctor.
Yes.
You didn't remember every single word of that? All right. Do you have an opinion based upon your background, training, and experience, and to a reasonable medical probability, based on your review of the records, which we'll get into in a moment, and your examination of Maya Kowalski, as to whether the interruption of her treatment process at Johns Hopkins aggravated this process and thus her CRPS?
Yes, without a question.
And can you tell the jury whether, I need to lay a predicate, are you aware of the psychological symptoms that Maya Kowalski suffered from at Johns Hopkins All Children's Hospital?
I mean, I don't remember them off the top of my head, but I do remember reading about them.
Okay.
But it's not surprising if a 10-year-old girl with severe excruciating body-wide pain is segregated from her parents would develop psychological issues.
And again, can an emotional situation like that trigger aggravation of CRPS in the future?
Object to the same objection, Your Honor, and I'm happy to approach again if you
I'm
want.
going to overrule that question.
But just to protect the record regarding future carrier review.
I understand. I'm overruling the objection.
So, yes, like I said, the brain is a very intricate structure, and it's not simply saying that, okay, it's dealing with pain, structural pain from the leg. It's more than that. It's connected to many other emotional things. Pain and emotion go much together, hand in hand. And so, if your emotion, you're in this world's worst excruciating pain, and imagine you have a child that's 10 years old, has this world's excruciating pain, is now separated from you, put into a hospital that you cannot go and see, or even your family cannot see. The child is going to go through a lot of emotional stress, and that itself would trigger her pain. Well, for one, it was interrupted. For second, the emotional stress of having not exactly very friendly people come in every time, and people who weren't listening to her, people who were not paying attention to her pain, people who were not treating her pain, was stressing her out, and that was causing a lot of her pain to flare up.
The answer stands.
Let's get back to your examination now. And
Okay.
I believe with the court's permission, you may refer to the document and evidence, your report. Explain to the jury the results of your physical examination. And first, was this down here or was this up at Brown University or the Pain Center? Rhode Island.
This was in Rhode Island.
Okay. All right.
Yes.
All right. And
The smallest state with the longest name. It's Rhode Island and Providence Plantations.
So, all right. So, who arrived there at your offices?
This was back in January of 2017, and Jack, her father, was there, and I believe her little brother was there.
Mm-hmm.
He was there too, and and that's it.
Okay, because Beata had already
passed.
And so tell the jury the results of your examination. What did you do and what did you find?
All right, so the whole exam took 5 hours and 22 minutes. Get ready for the 5 hours and 22 minutes of court time. I'm going to shorten that down. The first thing I did was I took a history. I asked her what was going on, and what was the problem and all that stuff. And then I started to examine her, and that's standard for any medicine. First, take a history and what treatments have been tried, what worked, what didn't work, and all that stuff. Then I did an exam directed towards her painful areas. And she described kind of a diffuse body-wide pain. And she reported pain to soft touch. And that's a classical symptom of CRPS. Soft touch meaning it's just the softest of touch causes a severe excruciating pain. Both her feet were internally rotated. So both the feet were turned in like that. And it was a constant pain that never goes down to 0 or 10. Okay, I'm going to continue. So
Please do. I'm just trying to find a next exhibit.
okay, so it's a constant pain. It never goes down to 0. That's another feature of CRPS we always ask is, does this pain ever go down to 0? And they'll always tell you no. In fact, their pain is always 10 out of 10. On a good day, on a very good, rare day, it will be 9 or 10. That's how severe this pain is. And then I asked her if it spontaneously shoots up. You're just watching TV, you're doing nothing, and it shoots up. And she said, yes, it does. The pain increases with any physical therapy. Whenever someone touches her leg, that is. She did notice, I'm sorry, I'm reading her history. You want my exam?
I wanted to show the jury photo 2529-061 in evidence. It's a photo of Maya Kowalski. I'll just show you. Dated November 19th, 2015. Go ahead. May we show it? Display it.
Is it in evidence?
It is in evidence.
Yes.
All right. Now, I'll represent to you the record shows that at that date, Maya was undergoing her procedure in Mexico and that she was under general anesthetic. Why is that important in light of the allegations made by Johns Hopkins that she was faking her feet?
Objection, Your Honor. Move to strike.
What, if anything, is significant about her feet being turned in while she's under general anesthetic?
So your feet get turned in because the muscles that control your feet are in a spasm. That's what happens. And you know, if someone is quote unquote faking it, then they wouldn't be doing it if they were under general anesthesia, because now they're not awake, they're asleep, and her muscles were still contracting.
So she had no control over it, and they were still contracted?
That's correct.
And that tells you what about it in terms of it being voluntary or involuntary?
It's completely involuntary.
Okay. Please continue on with your examination.
Okay, so I apologize. My first part was not the exam. The exam part was, so she had diffuse pain to touch to both legs, and as well as the upper extremities. On the legs, the pain to touch extended from the front of her thigh to the side of the thigh and to the back of the thigh. So basically all around the thigh, extending over the knees. So even her knees had pain to touch, and then it went down to her lower legs, below the knees, up to the top of the feet. Then she had pain to touch to the front of the left shoulder, above the collarbone and below the collarbone, side of the shoulder, going down the arm, into the forearm, up to the hands, but she didn't have it in the hands.
Is that significant?
She didn't have pain to touch in her hands,
okay.
But up to the wrist she had it. Then I checked her temperature. So I used one of those laser thingies, and I checked her temperature. The temperature to the left thigh, the left front of the thigh, was 87 degrees, and the right was 89 degrees. So there was a difference of 2 degrees.
Is that important? That's significant, that amount of temperature change?
Yes, according to the criteria, which is known as the Budapest criteria, a 1 degree difference is considered significant.
Okay.
Then I measured the temperature of her leg of the left leg below the knee, and that was 82 degrees, and on the right it was 83 degrees, a difference of 1 degree. The temperature to the left arm, so this is called the arm, it was, I didn't mean to, what I meant was that in medical terminology, this part is called arm, this is called forearm. In lay terms, of course, we call that the whole arm. But the upper arm was 92 degrees, and on the right side it was 99 degrees. There's a whole 7 degrees difference. Left forearm was 92 degrees, right forearm was also 99 degrees. And this was all done without touching her. Because when you touch them, then they have pain, and then you don't get the right readings. So to be sure that she was, if someone is faking it, let's put it like that. Let's just say someone is pretending or faking it, and they say like, I have weakness in my leg. What we do is we measure the circumference of that leg or the arm, and see if the muscle has atrophied or the muscle has shrunk. So I took a tape and I measured her left thigh, and it was 11 inches. And the right thigh was 12 inches. So there's a whole 1 inch difference between her left thigh and her right thigh. I measured the left lower leg, and it was 8 inches. Whereas the right lower leg was 9 inches, so a 1 inch difference. The color change between the two sides was not very obvious. It was mild, it wasn't like glaring. And that color change happens when they're in an acute flare-up. So if I had touched her and I had aggravated her pain, the color change becomes more obvious, which I had not done, obviously.
Let me show you a photo. See if I've got it here, of Maya. Yes, here it is. The knee. And do we have the one? Can you find the ones with the hand? Her hand was up. Okay, I'll find it. This is in evidence as trial exhibit 2604-021, and the date of this is January 6th, 2017. Still at Johns Hopkins. May I approach, Your Honor?
You may.
Or actually, can we just put this up? I keep forgetting I'm old school. Okay. What's significant about the knees here?
So you can see how her knees are different colored. In fact, the left knee is a little darker than the right, but they're pretty much the same. And this is a kind of a significant change, but if you aggravate the pain, this change becomes far more significant, far more prominent.
Talk to us about lesions.
Well, let me just finish my exam and then I can go on to the lesions.
I apologize, doctor. Sorry.
And both her feet, as you all saw, both her feet were internally rotated. Now, I wanted to see...
Oh, I found it. Sorry. It's 2604-014. Sorry, doctor. I keep interrupting you. I know.
There's
Direct you to the hands here.
$1 charge for every time you interrupt me. So the legs were in... Time to make some money, right? So her legs were internally rotated, okay? And I looked at why they were internally rotated. I tried to straighten them out. They straightened them out, and then they rotated back in, and I could feel the muscles were in a tight spasm.
This is another photograph from this day, which we will discuss later, of Maya being photographed. What, if any, significance is there to the hand?
You can see that how her hands turned dark red in color. It would have been nice if he had both hands, but you can see.
I'm looking for it. I'll do my best. And I'll represent to you it was on both once I can find it.
There's a dollar for him interrupting me again. She did have skin lesions. Now, in CRPS, one of the things they have, I told you skin changes, right? One of the things they have is they have these, it could be anything from a small dot to a big balloon-like blister to a long line skin lesions. And the difference between this CRPS skin lesion and any other skin lesion is that this skin lesion is not itchy. The CRPS skin lesion does not itch, but it is excruciatingly painful. If you have a skin lesion from something else, like you bumped your leg against something or whatever, that would be more itchy, but not as painful. The one from the CRPS skin lesions are not itchy, but very painful.
All right, so, and these lesions can appear different parts of the body?
Yes, they can appear anywhere. They don't have to be on the affected area.
Is one of the significant things here about them that it takes quite a while to heal?
Yeah, so these skin lesions were a mystery to all of us in the medical world. Like, what's going on here? We didn't know what was going on. So they actually from some of the patients who had big blisters, they actually took some fluid out of there and they examined it, and it turned out to be that there was inflammatory fluid there. And so we knew that this was part of the inflammation from CRPS.
Let me show you, and with the court's permission, they are in evidence, Trial Exhibit 2571-030 and 2571-053. And I'll represent to you that one is a picture of Maya's forehead and hands on Christmas Eve, 2016, December 24th. And the other one of just her forehead is on January 5th, 2017. And if my math is correct, that's a difference of what, 11 days? 12 days.
So, ladies and gentlemen, if you look at the picture on the left side, which she's holding up her hands, that little dot there on both her hands, the one on the forehead, these are classical CRPS lesions, and these are extremely. So she has pain in the arm. We know that. That's the CRPS pain, but the lesion that she has is extra painful. And she has one on the forehead, and then she has one on each hand.
Let me show you then one from even now. So does it appear to you, doctor, that this lesion had lasted for 10 days, this one on the forehead, based on the different dates of the photographs?
That it doesn't, you can't make a decision whether that's a CRPS lesion because it lasted 10 days. You can't.
But do they heal up magically in 10 days, or do they, if something stays, is it indicative that it is a CRPS lesion?
It does stay for a long time, but we don't know.
How long?
I don't have a number for that.
Okay. And I'll ask you to take a look at one earlier on the, I think it's the knee, and it's 2571-001, dated October 1st, 2016. I believe there's two of those, one healing and the other one, why the difference here?
Right. So obviously everyone can see that big line there, but right next to that line you'll see another lightish spot. That's right. That spot is a healing CRPS lesion, and this one it started at the part where the skin is broken. I'm talking about the long one. It started where it broke, where the skin broke, and then it kind of continued. And this is not a continuous line. This is it's a series of blisters, and they've all connected to each other to form a line. But you can see little bumps everywhere. It's not like a scratched line. It's more like little blisters all in a line.
Okay. Let's return to your examination. I promise I will not interrupt you if you'll let me know when you're done.
I've already made a few dollars. Made $3 so far. Okay. Actually, that was my examination. That's.
Ta-da.
But I did see skin lesions, and so she had multiple skin lesions, and they were. And I asked her, were they itchy? And she said, no, they weren't itchy. I asked her permission if I could touch one of them, and she said, please don't touch too hard. And then okay, fine. I just touched it very lightly, and it was painful. And the question that I had for her was, is this your usual CRPS pain, or is this particularly a much more severe pain? And she said, yes. The lesion itself was much more severely painful.
All right. So, do you have an opinion based upon your background training and experience into a reasonable medical probability as to whether Maya Kowalski, over this period of time, had, and I'm talking about October, November, December of 2016, January 2017 when you saw her, do you have an opinion as to whether she had CRPS?
Yes. So my diagnosis at that point was complex regional pain syndrome, that's CRPS, type 1, to both upper and lower extremities.
Okay. So then, having done the examination, did you review this tall stack of medical records?
Yes, I did. Starting from, I believe, 2010. And I went all the way to it's like 3 weekends. Approximately 2017.
Right.
So 7 years of records.
And since 2017, have you, although I don't believe you've been able to formally examine Maya Kowalski, is that right? Or since 2017?
No, I haven't seen Maya Kowalski since that day.
Okay. Have you kept up with her informally, though, as to her condition, how she's doing?
No, not really.
All right. So let me ask you to assume, for the purposes of this question, that Maya Kowalski has continued to have relapses, one in November of 2020, and the evidence will show that she has small relapses from time to time. Let me ask you to assume that, and that she is now some 17 years old. Do you have an opinion based upon your background, training, and experience into a reasonable medical probability, and based on those assumptions, as to whether Maya's aggravation is a permanent condition?
Objection, same objection, Your Honor.
I'm just asking for permanency on a hypothetical.
I think we need to approach on that one.
to a reasonable medical certainty, is CRPS a permanent condition?
Yes, in almost most cases. When I say that, I mean almost 90% of cases, it is a permanent condition.
And in your clinical experience, are patients who have had this type of aggravation where the glial cell recovery has been interrupted, does that increase the likelihood that the condition will be permanent?
Same objection.
Overruled on that one.
So, it's like any other wound. The wound, I have let's say I have a nasty wound on my hand and it eventually heals and closes up. But then if while it's closing up, while it's healing up, I go and, hit it again. It opens up, the whole process again starts to heal up, and then I hit it again, and then it starts to, and that's exactly what happens in CRPS is if you repeatedly aggravate the pain, whichever way, physically or mentally, if you aggravate the pain, the brain changes that happen go back to the same thing. The cells getting inflamed and the nerves getting inflamed goes back to it.
All right. Do you have an opinion based upon your background training and experience into a reasonable medical probability from your review of this case as to whether those physicians at Johns Hopkins All Children's Hospital in October of 2016 deviated from the accepted standard of care by failing to diagnose and subsequently then questioning whether Maya Kowalski had CRPS?
Objection, and just a very brief approach on this, Your Honor.
There's an order on that.
I'm going to overrule the objection. No need to approach.
Okay.
You can testify. Go
I
ahead.
can?
Yeah.
Okay. So what happened is, you have to imagine this thing. This is not something that's written and you just read it. Okay, you have to imagine what's happening. Here you have a 10-year-old girl who has this horrible, excruciating, body-wide burning pain. She's got these skin lesions and, which is a big deal for a 10-year-old girl. And now you're also isolated from your loved ones. And you have people coming and seeing you every day, all day long. People who are not friendly.
Your Honor, this is non-responsive to the question. I object.
I think it's a predicate.
Overruled. You can continue your answer.
These people are they're not there to help her. They're not trying to help her. They're trying to actually question that if she really has pain. And, they're touching her again and again and again. They're putting her into physical therapy, which she's trying. It's not like she did not try it. She did try physical therapy. She did what they said. She was not improving at all. And this, I really think, is what aggravated her condition.
And so was that a yes? They breached the duty of reasonable care and deviated from the accepted standard of care?
Yes, absolutely.
All right. And we actually have a short video we previously discussed at 2703-D from October 20th, 2016. Judge, may I publish this? It's short. It's,
You may.
I don't know, it's only about 30 seconds. Not even that. And after it's over, Doctor, I'm going to ask you to point out here the significance of the body movements.
Just a moment.
Approach on this.
Approach.
I'll take you off the firing line there. Okay. We're going to come back as soon as the technicals get that rolling. All right, so let's talk a little bit about ketamine. In your practice, have you familiarized yourself with the use of ketamine as a treatment for CRPS?
Yes, I'm very familiar with the use of ketamine for the last 30 years because this is something that we use in the operating room, in the intensive care unit, emergency rooms. We use it in the field.
Can you tell us some instances, by way of foundation predicate here, of instances where you have made a decision to use ketamine as the drug of choice, and any emergency situations that can perhaps explain to the jury the safety of the drug?
Ketamine is probably one of the most safe, I'm sorry, wrong English. It's probably the safest drug that you can use under any circumstances. So, as we speak right now, first responders all have ketamine with them. When they have a patient with an acute injury, or when they have a patient with asthma, it works on asthma. A patient with severe asthma, all they do is they shoot some ketamine and it improves. They shoot some ketamine and the fracture site can be stabilized. It helps their pain. If they're bleeding out, it helps with shock. Now, I mean, I've worked in the operating rooms. Obviously, I've used ketamine a lot. I've worked in the ICU where we used ketamine for patients who had severe asthma. I mean, this asthma was so severe that there was no air moving in and out, and there was no question that giving them the steroid would make a big difference. We would give them ketamine, their airway would open up instantly. There was one incident I really want to share to you how safe this drug is. It was a while ago. I was back in India. I was on call. I can say that story.
Yes, you can tell the story.
I was on call at a hospital. It was a teaching hospital. I was on call that night. It was on midnight.
I object to the narrative on this, really.
This is about this is just a predicate and the use of ketamine, his experience.
I'm going to allow it.
You can,
Okay.
yeah, you can talk.
Okay. We get a call and there was a train accident. Two trains, an up train and the down train, with passengers in it, had a head-on collision. So they had a head-on collision. When I got there, the trains were looking up like that. There was twisted steel everywhere. There were passengers that were trapped under like tons of steel. There was no way that we could remove all that steel with jaws of life or anything like that. And even if we did, they would have died from bleeding but then and there. We were giving these passengers ketamine injections right there. We had no access to the patient. We had no access to their airway. But because ketamine increases your breathing, increases your blood pressure, we would give them ketamine. It would take them out of their shock. The surgeon could do an amputation and remove them. And I think that night, just from ketamine, we must have saved about 300 or 400 lives. And these are patients we could barely see even or know anything about it. Ketamine, it would take care of the shock, it would take care of their breathing, and it would take care of their pain.
I found out that 2703D, the photo during the video, well, let's just go ahead and play it, and I'd like you to pay close attention to the body movements here, Doctor.
A dollar, yeah. Like normally a dollar $50, but the more shopping the better. Oh really?
Then she has your money finger, which should be helping a little bit. I want to try to use the walker just to stand, pivot, get in the chair, like you did with Betsy the other day. So I'm jealous that she got to see it and I did not. So I'm going to help you, but I want you to try to get your feet flat on the ground. I'll hold you up just so your feet flat. Put your feet in.
You got it, good job.
Turn the walker.
You got it.
Better than yesterday. Hey, give me a high five. That was awesome. Better than yesterday. I wish we had the feet for you. That was awesome. Great job.
It's gonna hurt just a little bit because you haven't put any weight on the leg. No.
Okay. This depicts them trying to get her to walk with a walker. What did you notice about body position and legs and so forth?
So she has no motor strength to both her legs. I mean, she's trying to stand, and she actually tried 2 or 3 times to try and stand, and each time her knees buckled, and she had no motor strength at all.
Were you able to hear her moans in the background?
Yes, she was.
Did it appear to you that she was in pain? Did it appear to you
yes.
that she was...
I'm sorry. Yes, I was looking at the video. Yes, she was. Absolutely, she was in pain.
Okay. Let's get back now to ketamine, and let's talk a little bit. We've established that it is a safe drug. And by the way, in your 30 years of practice or more, how long have you been practicing?
Well, I've been a doctor for about 30 years now.
Okay. To the best of your knowledge, has any patient ever died from the medical administration of ketamine?
Never.
Has anyone, a patient, suffered a permanent injury from the medical administration of ketamine?
Never.
And would that include patients that have been titrated up above, say, 1,000 milligrams or more per hour?
Yes.
So let's talk then a little bit about the dosing of ketamine, particularly for complex regional pain syndrome disorder, and particularly with Maya. And I'm interested, if you could, in explaining the concept of titration to the jury.
So the concept of titration works in pain medicine. It works. The way we do that is, say somebody comes to me and has pain in their hip. They have pain in their hip, and we've tried everything, nothing's working. We give them a small 1 pill of a pain medicine, okay, and we try to see the response to it. And if the patient comes back and says, "Hey doc, it helped for some time, only for a couple of hours, but I still have pain for the rest of the day," we increase it to 2 pills a day. And the same thing when the patient comes back and they've had some good response, but not a we are looking for function. We're not looking for zero pain. That's in pain medicine. Even in medicine, we don't look for zero pain. We look for functional. And so he's somewhat functional, but not enough. So we go up by another dose. And so forth, we go up very slowly, step by step. It's the same principle used in seizures also. You start at a very small dose, and it's called start low, go slow. You start at a small dose, and you slowly titrate it up. And in pain medicine, we do the same thing because we don't know how much you're going to take. I might give you a tablet for your headache, a Tylenol for your headache, and it'll go away. I might need 4. Actually, I might need 4 right now. But it might, I'm sure all of you guys need 4. But it might, so we don't know. And so the way we do it is because we don't know, I'm not going to give somebody I'm not going to give them 4 tablets of Tylenol and say, "Hey, take this." I'm going to give them 1, and if they're not happy with it, I'll give them another one and another one till they get to a point like, okay, now I can tolerate listening to testimony from me.
Is that known as a therapeutic dose?
Yes, the therapeutic dose for that patient.
All right. And so in Maya's case now, are you aware of, because of her asthma, she was taking any medications that might affect, or did affect rather, the amount of ketamine it took to bring her to a therapeutic dose?
All right, so this question I have to answer with a little bit of science in it, in that any drug that we take is destroyed by a chemical in our body called enzyme. So there are enzymes in my body that destroy any chemical. For example, if I take a Tylenol, there is an enzyme that burns up the Tylenol. And the reason is to protect me because, if I take one Tylenol, it'll continue to exist for the rest of my life. So that not to avoid that happening, there are enzymes that destroy it, and then it's thrown out by the kidneys or the stool. In Maya's case, she was on massive, that's a whole different subject to talk about, but she was on massive doses of steroids for her asthma. And those steroids were revving up one of these enzymes called, which really hard for me to remember, it's called the CP2D6. And what it does is
is that otherwise known as P450?
P450, it revs up that enzyme. Now, this is the same enzyme that also destroys ketamine. So now you're actually burning up the ketamine faster because she's on the steroid. The steroid revs up this enzyme, and this enzyme, by the way, also destroys ketamine. And so she's burning up the ketamine. And so her requirement for ketamine kept increasing, and that's one of the reasons.
So do you have an opinion based upon your background, training, experience to a reasonable medical probability as to whether the ER docs that first saw Maya in October of 2016, including Dr. Farhan Malik, Dr. Beatrice Tepa-Sanchez, deviated from the accepted standard of care by not researching more fully and confirming any reasons why Maya would be taking larger doses than they expect?
Renew the objection, Your Honor.
Mr. Court Reporter, may I have that question read back, please?
So do you have an opinion based upon your background, training, and experience to a reasonable medical probability as to whether the ER docs that first saw Maya in October of 16, including Dr. Farhan Malik, Dr. Beatrice
Tepa-Sanchez,
deviated from the accepted standard of care by not researching more fully and confirming any reasons why Maya would be taking larger doses than they expect?
I'm going to overrule the objection. The witness may answer.
Yes, they deviated from because this is something standard. They are the ones who are giving her massive dose of steroid, and they should know what the side effects of these steroids are in respect to ketamine.
In fact, from your review of the records at Johns Hopkins, at least for a period of time initially, did they maintain her on those steroids? Do you know? If you don't know, it's okay.
I don't know. I don't remember.
There's a lot to remember in this case. All right. So did it come to your attention that in this particular admission on October 7th of 2016, whether immediately thereafter they put Maya right back on ketamine at Johns Hopkins Hospital?
No, they... As far as I recall, they did not start her on ketamine right away.
Well, actually, we know they didn't keep her on ketamine, but in the first day or two. I'll show you the records. How about that?
Okay.
It might be a little easier. All right. Now, in terms of treatment of CRPS in the future, what is your opinion about what somebody who has had CRPS diagnosed and then aggravated, what can they expect in the future to a reasonable medical probability?
Same objection.
I don't know.
I'm going to overrule that objection.
So, if someone has had CRPS, I tell them, and we all tell them, that this is a lifelong condition. In fact, it is so surgeons will refuse to operate on a patient once they find out that the patient has had CRPS ever in their life. That's how scary this is.
Is it listed as one of the 11, I'm going to owe you another dollar, one of the 11 essential drugs of the World Health Organization?
Yes, it is.
Please continue, I'll pay your dollar.
So the World Health Organization has a list of essential drugs that every country must have, and ketamine is one of them.
So please continue.
Yeah, you need to put $1 in the tip jar.
Yeah, I know.
So
you're going to own me by the end.
So CRPS is a lifelong condition. Okay, now let's say we've done the treatment, we've done everything, and the patient is doing better. Okay, now better means more good days than bad days. That's better in their lives, and so they still have to be extremely careful of aggravating it. They cannot afford to have any injury. They cannot afford to have a lot of stress in their lives. If they ever go in for surgery, then they have to take extra special precautions. And actually, one of the precautions is that the anesthesiologist has to give them ketamine during the surgery, after the surgery, and continue into the post-operative period, because that's the only drug that works on this. Most surgeons will refuse to do surgery if the patient has a history of CRPS. That's how severe this is considered in the medical world.
So does that prevent, in many instances, the patient from getting the appropriate treatment in the event of an accident or something like that?
Well, in the event of an accident, of course, they have to do what they have to do. But if Maya were to have a surgery that is kind of maybe optional, let's say she has a bone that hasn't healed well and has to be straightened out, the surgeon won't do it.
Now, I have to ask these questions in follow-up to the two questions about the deviations from the accepted standard of care. Just to be safe here, Doctor, do you have an opinion based upon your background, training, and experience and to a reasonable medical probability whether the two deviations that you've testified to here in court caused or contributed to permanent injury to Maya Kowalski?
Yes, absolutely.
Overruled, the answer stands.
One moment, Your Honor. Oh, I know what I wanted to ask. Is ketamine now used to treat depression and other psychological illnesses?
Yes, ketamine has now been approved. The best news about ketamine now is that it has been approved for treatment of what's called treatment-resistant depression. So these people have such severe depression that drugs are not working anymore. The normal antidepressants are not working anymore, and they get ketamine, nasal spray, or some centers will do IV ketamine. The FDA has also approved ketamine for treatment of CRPS since 2019.
So in the event that someone, for instance, Maya, there's testimony that she's diagnosed with a permanent psychological injury, would the ketamine be of use to her in the future?
Objection, relevance, and scope.
Tie together later based on further expert testimony as to psychological conditions.
What's your approach on that one? The objection to that question is sustained.
You have an opinion based upon your background training at first. Are you aware that Johns Hopkins All Children's Hospital during this period refused after the first couple days, refused to allow Maya to have ketamine to help her get through this? Are you aware of that?
Yes, I am.
Do you have an opinion based upon your background training and experience and to a reasonable medical probability as to whether refusing to allow a patient, Maya Kowalski in this instance, access to the most successful drugs to treat her condition is a deviation from the accepted standard of care, breach of the duty of reasonable care?
Yes.
And is it your opinion to a reasonable medical probability and based upon your background training and experience as to whether those deviations caused or contributed to injury, permanent injury to Maya Kowalski?
Renew the objection, Your Honor.
Overruled. You can answer.
Yes, absolutely.
Thank you. One moment. That's right. One more question. Can you tell the jury, based upon your background training and experience and to a reasonable medical probability, whether titrating to effect in the use of ketamine is the standard, accepted standard of care?
Oh, yes. I mean, that is without a doubt the standard of care. No question.
Your witness.
Okay. Well, given that it's 12:10, I think it's lunchtime for everybody. Members of the jury, I'm going to ask Deputy Coley, I want the jury to be ready at 1:40. So at 1:40, I want them to be able to come in. So whatever time you need at the rallying point. So
Ask the jury if they want to stay through cross and then lunch. This is our last.
no, we're going to lunch right now. I can tell you that without a discussion at sidebar.
Yes, Your Honor.
Members of the jury, please do not discuss this case amongst yourselves. Do not do any investigation and receive no information. I will see you after lunch. Have a good lunch. The jury's out of our presence, Doctor. We're going to be taking a lunch break. During this break, you're not allowed to talk to either side about your testimony, okay?
Yes, sir.
You can talk about the weather, you can talk about plane flights or whatever else, but you cannot talk about the subject matter of this case or the testimony.
Absolutely.
Okay. And so I want you back here, let's say, at 1:30, okay? So if you want to take off and go to lunch, you're free to do that at this time. Are there issues, plaintiff defense, that we need to discuss before we go?
Not unless, not from the plaintiff.
Not from the defense, Your Honor.
I will tell you, I've received Mr. Altenburn and Mr. Elligott's drafts with the various different objections and counter proposals. What I have here is my amalgamation of those, so basically kind of my thoughts on the matter. I'm going to hand them to you.
You all can look at them. We can discuss them when we come back, or perhaps after the jury leaves today. So this goes to the plaintiffs, and this goes to the defense.
Thank you.
Thank you, sir.
With the jury coming back, and I want the jury to be able to walk in at 1:40. If we come back at 1:30, which is an hour and 16, 17 minutes from now, is that enough time for us to do whatever we need to do before the jury comes? Or do we need more time?
Does that mean discuss the jury instruction, or does that mean anything else?
I think we can do the jury instruction after the jury leaves today.
Especially, are you expecting to have Mr. Alligator appear?
I'm going to call him on lunch.
Okay.
I think 1:30 is fine. Hopefully we can come to some type of an agreement. If not, we prefer to do that after the jury's excused for the day.
And what you'll see, the top one is the enrolled version. The bottom, I kind of left with the legislative change and my thoughts on it. You will be pretty self-evident. Okay. Everyone will be back at 1:30.
we coming?
Oh, I'm sorry, Judge.
I'm here. That's okay. I don't want to interrupt. I just kind of figure out.
Judge, can you flip it on? I want to show you. I messed up. When we were having that colloquy there, I should have remembered the report. The report lays out an entire life care plan over the course of 2 pages, and I wanted to show it to you if you don't mind.
That's fine.
Okay, so if you go up here.
You just highlight it, the area.
Yes. Next page. Okay, beginning with considering the complexity of the condition down.
I need to turn it off and turn it back on so the gallery comes back on.
Okay.
For whatever reason, sometimes those gallery TVs just don't like coming on. There we go.
And then on down from there, continue down, highlighting to the bottom, and then the start of the next page, please.
Doctor, can I actually ask you to step outside for just a couple moments?
Sure.
Thank you, sir. No, I'm just waiting for the doctor to get out of our presence. The transcript will reflect the doctor's out of our presence at this time.
At this time, Your Honor, I would like to continue direct examination. For the record, when we had a colloquy about the scope of the doctor's opinion, I had focused on the deposition, completely forgot about his report, which is Exhibit 2005-1 through 32, something like that? 21. And in that, there is not a life care plan, but all of his recommendations to reasonable medical probability of the care and treatment for Maya Kowalski based on her symptoms and his diagnosis. If you go to the next page, please. 19, or 20. And so there he goes on. Also demonstrated positive results of physical therapy. Treatment with Dr. Hannah specializes. Basis for diagnosis, much of it is incorrect. She does not meet the criteria. I don't need that, but from that point up, and then the page before.
Mr. Anderson, I looked at it. Let me hear from Mr. Shapiro.
Yes, sir.
I guess I don't know what they're intending to do if Mr. Anderson wants to continue to correct on your objection. The basis for just to be clear, this is a plan that he had for Maya after one visit in January 22nd, 2017. If the question to him is simply, did you have a plan for Maya's care, you can walk through it, but that's different than saying as a result of the mistreatment that you allege at All Children's Hospital, do you believe within a reasonable degree of medical probability she has these future problems? That was the basis of my objection because, again, in his deposition, he, I believe, clearly disavowed any future care opinions because he hadn't seen her. But I don't object if he just wants to continue his direct and ask him about what his plan for the patient was on that day based on his exam.
Well, my recollection of the questions that were asked that we had the sidebar conversations on, or multiple sidebar conversations on, and my sustaining your objections, the concept was that it was an undisclosed opinion that neither in his report nor in the deposition was there discussion of future, whether it was care and treatment or a future opinion. But this report suggests that he did, in fact, have opinions about future care. And so at this point, I'm going to reverse my rulings and I will allow the questions that Mr. Anderson had previously asked, to which I sustained. And the plaintiff can continue in direct when we are in front of the jury.
Thank you, Your Honor.
Do you mind if I just get a quick point of clarification, respectfully, Your Honor, and I don't know if plaintiff intends to do this. Does this court find that merely because Dr. Chopra had a plan on this date for several things that he wanted and that his patient to undergo, that would open the door for him to then talk about life care plans in the future as a result of negligence, or just merely that he can discuss what his plan is?
What I was just seeing on the screen was talking about future items. So, certainly, I don't know what the doctor is going to say about future items. If it's beyond this, maybe that's going to be an issue. But it's clear that he had a forward-looking report that was presumably available to the defense. And as such, I think it's fair game at this point. And that was the basis of my objection, was it was undisclosed, but it seems like it was, at least in part, if not in totally, available to the defense and understood that that's what this doctor was going to be saying.
And just a last point of clarification, respectfully, the objection the defense is making is any testimony about future care related to future damages, as opposed to, and I don't have an objection to him talking about in his report his future plan of care for the patient. I think those are two different separate categories. Mr. Anderson may not be going back there, but I will make the contemporaneous objection.
I think you need to make the contemporaneous objection, and it may be that it is beyond his deposition and his report, but I think I need to actually hear the specific question at that particular point in time and the specific objection. Are there any other issues we need to address?
Your Honor, we had done a request for judicial notice, which the court granted on trial exhibit 23021 and 2301.
What is 2301?
And those are, and I've got copies real quick.
Can you just put it up so I know what you're talking about?
Can you put it up? My intention, these are House resolutions regarding reflex sympathetic dystrophy month, and there was one in 2004.
What are you trying to do with a legislative resolution?
I am asking the witness to identify this and asking whether this is further evidence that the doctors at Johns Hopkins should have been aware of the problem of misdiagnosing exactly what they were diagnosing.
I'm unclear. You're asking a doctor from Rhode Island to comment on a resolution by the Florida House of Representatives?
Well, he is licensed in Florida as well, and it's a relatively minor point, but I think it is.
Has he been in the Florida legislature?
Not that I'm not aware of.
My recollection when I handled this before was, I'll take judicial notice of it, but as a matter of evidentiary fact, that me taking judicial notice does not make it an evidentiary fact. I think that's how I ruled, I don't know, 2 or 3 months ago.
I agree with that. I think that's what you said.
And I don't see this witness being able to talk to us about what the Florida House of Representatives has done.
I'll save it for cross or something else and I'll bring it up again.
Anything else before we bring in the doctor?
Not from the plaintiff.
Not from the defense.
Let's go get Dr. Chopra, please. Okay, welcome back, Doctor. Just to let you know, when we bring the jury back in, since we've had this break, I'm going to remind you that you're under oath. I'm going to do that in front of the jury.
Sure.
Okay, just to let you know, I'm going to do that. Let's bring in the jury.
Yes, sir. Okay, everyone, please be seated. Okay, members of the jury, I want to confirm while you were away, you did not discuss this case amongst yourselves, you did not do any investigation, and you received no information. Is that correct?
Yes.
I also want to confirm that and ensure that no one approached you about this case since we last were together. Is that correct?
Correct.
And that you have not seen any media coverage about this case since the last time we were together. Is that correct?
Correct.
Thank you very much. Mr. Anderson, you may continue your questioning, sir.
I'm back.
I know. Sticky tape.
Before we broke, there was a series of questions concerning Maya's future care. And I'm allowed now to ask you about them. And I want to reference you to your report of January 22nd, 2017. And with the court's permission, I have it published here. Previously discussed it. Can you go through this? You don't have to dwell on every one of them, but I want you to name off for the jury here the various treatments and the reason why they are reasonably medically necessary for Maya, given her aggravation from CRPS.
Same objection, Your Honor.
So, one of the things about treating CRPS is that I do is I know the definition is everything else has been ruled out. So the patient has severe excruciating pain and everything else has been ruled out by definition. That's the definition of CRPS. But I still look for a cause. Maybe there is something somebody missed or there is something that I can find, and that would be obviously magical, because then if you know what's broken, we can fix it. So in her case, I looked for a condition called Ehlers-Danlos syndrome, or in brief, EDS. It's a kind of a benign condition where your joints are loose, you're hypermobile, and she had some features of that. Now, I wasn't sure about it because at that time, this was back then, there were no guidelines on how to diagnose this condition. It was actually in 2017, later on, that the guidelines came out on how to diagnose it. So I just put that there, that later on in the future in her life, she might ever want to explore that, she can do that.
Next one.
The next one was, I said that she meets the criteria for complex regional pain syndrome.
And then let's go to 3, as I think we've covered that.
So in number 3, I talked about a condition called tethered cord syndrome. And this is actually a condition common in children, and it is common in patients with Ehlers-Danlos syndrome. And in this case, what happens is that these patients have, their spinal cord is not hanging loose in their spine. It's tethered to the bottom of their spine. And it's a congenital condition, and oftentimes these patients can present with pain in both their legs. And it's a neurological condition, and it is diagnosed by a neurosurgeon. I also put that in there because maybe she has it, maybe we need to do a further workup, we don't know.
Okay. Then we go to the next one then. 4.
Are we going to magnify this?
Let's see. 1, 4. I don't need to cover
Okay.
that one. I was really interested in the CRPS treatment on the next page. Okay. Now, beginning in number 5, if you could go down and let me ask you the question. From 5 down through, I think then there's more on the next page. But these from 5 on down, are these reasonable and necessary medical condition treatments for Maya Kowalski based on the aggravation of her CRPS to a reasonable medical probability?
Yes, these are reasonably necessary, absolutely.
So let's give the jury an idea here of, we talked about things that she can look into in case, but let's talk about what you think she should be doing or the treatment she should have.
Based on my...
Your report, which
okay,
is in evidence.
so on number 5, I put in there, recommend physical therapy for upper body strengthening exercises. So here's the thing. When she got her initial ketamine at Dr. Kirkpatrick's office, her upper body pain actually improved. The pain in her arms improved, but not the pain in the legs. And so, you know, she was... When people use a walker, they need upper body strength because that's what they're supporting themselves on. They need to have stronger arms, stronger upper body. And so I said, all right, let's strengthen what we can strengthen. And at least so she can, you know, hold the walker and walk. So that's what I said.
And how much, as she continues in life, should she reasonably expect to attend or go to a reasonable medical probability in order to minimize the effects of the aggravated CRPS?
Well, to minimize she has to completely avoid aggravating her CRPS.
Let's assume in life there is aggravations now and again. Is the physical therapy, should it be periodic or should she continue to attend physical therapy throughout her life so long as she has the symptoms to a reasonable medical probability?
I need to clarify that.
Sure.
I actually said to hold off physical therapy for her legs.
Right.
Because you cannot do physical therapy on someone who has excruciating pain in their legs.
Right.
Okay, that's it. So for now, just strengthen the upper body, control the rest of her pain in her legs, which had been aggravated by her whole episode at the ACH, and then work on the legs.
Okay. As she has, and to a reasonable medical probability, is Maya going to have relapses from time to time of varying degrees and types?
Yes, she is. Okay, let's talk about the relapses for a second. This is not a joke. We're not talking about a relapse of a little headache. We are talking about severe. She lives at a baseline pain that you and I cannot even comprehend. Okay, that's baseline pain. Her brain has now changed enough that she is okay with that pain. When she has an exacerbation, it's horrible.
And are you aware, or has it come to your attention, that she has in fact had a relapse in November of 2020 that put her in the hospital?
Yes, I know that she did, and I don't know what happened. It may have been some sort of a stress. I know she didn't have an accident or a physical fall, but it could have been some stressful event that could have triggered that.
And her already having had a relapse 2.5 years, 3 years after getting out of Johns Hopkins, does that have an effect on your opinion that she may have more and longer and more aggravated relapses through her life?
Same objection.
You can answer.
It's the same, it's the same analogy I gave you. If you have a wound on your arm and before it heals, you whack it and it breaks down, the skin breaks down again and the wound becomes worse again. And if you keep continuing doing that, one day it's never going to heal. One day you're going to be left with a really terrible open wound on your hand. And that's the same thing with this. If you keep aggravating her CRPS, her brain is finally going to alter itself, if it hasn't done it now, it is finally going to alter itself. That is that her CRPS will never ever go away. It never goes away. It gets what we use the word remission, where it kind of comes down a little bit, enough that they can function.
And I believe you testified to this before, but just to tie it in, do you have an opinion based upon your background, training, and experience, and to a reasonable medical probability, if whether the timing and the intensity of what she experienced at Johns Hopkins over those 3.5 months aggravated that CRPS so as to cause her extra injury and damage?
Same objection.
Overruled, you can answer.
So, I need to give you the bigger picture on this.
Okay, go ahead. I just wanted to, yes, you do have an opinion or no?
You need to add $2 there. Right. So, I'm going to make money today. So here we are, so we have a 10-year-old girl and she's got CRPS in her legs, okay? But her mom's frantically running around all over the country from Chicago to Tampa looking for treatment for her. Okay, she finally finds Dr. Kirkpatrick. He does ketamine on her. It helps her partially. It helps her arms. Okay, we got a little win there. But then he says, look, you need much more than what I can give you. So you need to go to Mexico and see Dr. Cantu, who's going to give you a ton of ketamine. And she does. And she comes back and she does well. Mm-hmm. And in fact, she does so well that Dr. Who's the doctor from?
Hannah or?
No, there's a doctor
Cantu?
from Johns Hopkins, the pulmonologist.
Oh, Kreisman.
Kreisman.
Dr. Kreisman.
Dr. Kreisman and her pediatrician said, this is not the same girl. This is a different girl. Her skin lesions were gone. She was a whole different girl. They both commented on that. And then, obviously, you can't afford treatment in Mexico that long. It's expensive. So she did the next best thing was to go to Dr. Hannah, who tends to use higher doses. And so it was some sort of an agreement that she made. And she started to do ketamine with Dr. Hannah at somewhat higher doses. And she was doing great. There are videos of her swimming, running around, playing, doing great with physical therapy after Dr. Hannah's treatment. So you can see the progression that from a lower dose with Dr. Kirkpatrick to a higher dose to Dr. Cantu and then to Dr. Hannah, she is starting to make progress. Now she has this abdominal pain, goes to Johns Hopkins, and then everything goes down the drain. They don't believe her, they don't treat her stomach pain, they don't take care of her CRPS, they don't even, and she's been there dozens of times before, and now they treat her like they've never seen her before, they don't believe her, they stop all her treatments, and not only that, they mistreat her by keep touching her, keep handling her, and her CRPS flares up back to where it was.
So is that a yes, Johns Hopkins did aggravate her CRPS so as to cause her more damage and injury in the future?
Yes, very much.
And so let's continue down here. You've had, exercise and joint protection. I think you've talked about, avoid desensitization. Go down, avoid desensitization, sensitization exercises. What's that about?
So, one of the theories in CRPS is that, all right, if because your arm is so sensitive, I'm just taking the arm. If your arm is so sensitive and if you have CRPS there and touching it makes it painful, we are going to touch it even more. We'll take a rough towel or a sponge or something like that and rub it even more so that your brain gets used to it. Okay, now that philosophy is actually counterproductive because do you remember how I said this morning that a barrage of pain signals, if I took a pen and I stuck it in my finger again and again, there would be a barrage of pain signals to my brain. And then the brain then alters itself. And it now takes over the pain. And this is what will happen when you do so-called desensitization exercises. If I take a rough towel and I start rubbing it on the area of CRPS, you are sending even more signals up there. There is zero literature. I am not kidding you. There is zero literature on the benefits of desensitization. I have searched it everywhere. I've asked people who do this. I said, where did you learn this from? Where is it? No one knows. So,
Doctor, why don't we wait for the next question and then you can answer?
You owe me $1 back.
Oh, sorry.
No. The question then is, can you describe for the jury then with more specificity, is she going to have more of these relapses than she would have had she not been interrupted in her first round of care?
Yes.
Will they be more aggravated when she has them? That means more painful, more debilitating. And third, will they be, in terms of length, longer? So the three, again, are she's going to have more number.
How about one question at a time?
Yes, sir. You get my question?
Yes, to answer your question, yes, she'll have more frequent incidences of CRPS because the treatment that was initially working for her was interrupted.
And will those episodes be longer in length than they would have been, or will have any effect on that?
That's a slightly difficult question to answer.
Fair
Some will be longer and some may not be that long.
But can you tell us, when she does have them, are they going to be more intense than they would have been had she completed the therapies that were in place?
Yes, every exacerbation she's going to have is going to be a lot more intense.
So she's going to have a lot more and more intense, but there's no way to tell the length of them. It's just a summation. Okay. Now, we haven't finished this. Doctor, I don't want to take a whole lot of time because it's in the report, which is in evidence, and so you can read it. They can read it for themselves. But generally speaking, can you tell me? Can you tell us? I'm going to stick a step ahead here to number 10, gastroenterology, and why that's important.
So when I talked to her, and I went through every system, and when I got to the stomach, and I asked her, "Do you get bloating when you eat?" and she said, "Yes, absolutely, I do get bloating when I eat small amounts of food." And remember, she had already been to Johns Hopkins twice. I think, as long as I remember, it was twice for belly pain. And what happens as a complication of CRPS is the nervous system that controls the movement of your intestines. So your intestines move like a toothpaste, okay? So when you eat food, it moves along like a toothpaste. And that is controlled by a nervous system called the sympathetic nervous system. And that is affected in CRPS. And that was the reason her food was not moving, and obviously it was collecting, and she was starting to have all this abdominal pain, belly pain, and she was getting malnutrition because of it.
All right. Then is there a number 12 there, or have we reached the end? It says under 11A, it was minimized trauma. I think you've covered that. And then we go on the next page to continue on to the top, please. I think there's more. Go up. Here. Vitamin C exercise program, trial of graded motor imagery. What is that?
So there was a research that came out of Australia. It's actually accepted research modality for treatment of CRPS.
I'm going to sustain that objection.
What was the objection?
Holstering.
Oh, okay. Just tell us what graded motor imagery is, the basics.
It's in 3 parts, and the 3 parts I mentioned over there. It's a kind of an exercise you can do at home for people who have CRPS in one limb.
And then you said an echocardiogram. Is that periodic under number 12?
That's If she has Ehlers-Danlos syndrome, then an echocardiogram is a standard practice.
All right. And then, okay, positive results of physical therapy. So should she keep up physical therapy throughout her life as she's done?
Provided her pain is controlled.
Right. What about medications? Do you have an opinion based upon your background, training, experience, or reasonable medical probability if from time to time she would benefit from medication?
That's a difficult question to answer because her mother had tried a lot of medications, but that was a different time, and so we don't know if she can try them again. But she will need to try different medicines.
And with based on the assumption that the relapse occurred some 2.5 years after she got out of Johns Hopkins, do you have an opinion to a reasonable medical probability that the opinions you have offered here are equally applicable for this jury today?
Can you rephrase that?
That was a very good question. To a reasonable medical probability, is your report here in 2017 applicable today, these different treatments and future medical care?
Yes.
So, just a couple last questions. I think the jury will hear at some point about intrathecal pumps and Beata Kowalski's request, or just asking about it in theory. But what is an intrathecal pump, and is this some boogeyman that we should be afraid of? All right.
Why don't we just go with
What is the pump?
Sorry. Intrathecal pump simply means a pump in the spine. So the principle is actually amazing. And I'll give you an example. If a person needs, say, 10 milligram, needs morphine, 10 milligram pill for their pain by mouth, 10 milligrams by mouth. If you give the same morphine into their spine, they'll only need 1 milligram, which means they need lower doses. It is far more effective because you're hitting the pain at the source, and you're also not seeing any side effects. So intrathecal is in straight language, it means spinal pump.
And from your experience with mothers and fathers of children with this extreme pain, do you find it in any way unusual or odd that she would question whether the intrathecal pump would be appropriate for Maya?
Yes, it is an appropriate request. I thought it was an amazing request that she made it because she's trying to decrease the dose of drugs that Maya is getting.
All right. And finally, is ketamine FDA approved for children?
Yes, it's used all the time for children.
And is it now FDA approved as what's known as an orphan drug?
Yes, it is.
And what is an orphan drug?
So actually the sentence should be, is it approved as an orphan drug for CRPS?
For our CRPS, my apologies.
Yes, and so, there are some diseases that, like the FDA has these rules, okay? Like they might say, somebody with migraines, we need, 1 million patients. We need you to test this drug on 1 million patients.
On the FDA rules.
Well, I'm just trying to explain.
You can answer that one.
You can answer.
But in some diseases that are not that common, they can't get 1 million patients with CRPS. So the FDA says, all right, we let you do it with 400 patients. And that's called an orphan drug use. So they kind of make it, they're not all diseases are that common. And some diseases that are not common, they put them down as orphan drug use.
Is that because of the expense of doing a full trials?
No, it's because they can't find that many people.
Okay. And I have to ask you one last question on liability here. And do you have an opinion based upon your background, training, and experience into a reasonable medical probability from everything you've seen here, whether the doctors comprising the Johns Hopkins pain management team, that is Laura Vos, Richard Elliott, Amish Patel, and nurse Ashley Sumner, breached a duty of reasonable care by deviating from the accepted standard of care insofar as the care and treatment of Maya Kowalski?
Yes. Overruled. The answer stands.
And can you tell us to a reasonable degree of medical probability based upon your background, training, and experience whether that was a cause of this aggravation and this future we now know about for Maya?
Can you explain that a little bit more?
Sure. I want to know whether when you answered about they breached a duty of reasonable care, was that breach a cause of the damage and injury to Maya?
Yes, it was.
And is that to a reasonable medical probability?
Yes.
Your witness.
Mr. Shapiro.
Good afternoon.
Good afternoon.
Were you aware that Beata Kowalski chose you?
No, I had no idea.
First time you're learning about that today?
This is the first time I'm hearing this.
Okay. You're not an emergency physician, correct?
No.
You're not board certified in pediatric anesthesiology either.
No.
You, in terms of hospital privileges, you haven't had any in more than 20 years, right?
I chose not to.
Okay. You don't treat patients in hospitals.
I don't have the time to go to hospital.
Okay. In terms of your fees to be here, what are you charging?
Sorry, could you?
What do you charge to be here?
Oh, so far they've been kind enough to pay for my hotel. The rest I have no idea.
Okay. You haven't sent a bill to Mr. Anderson yet for your time?
No, I haven't.
Okay. Do you know what it will be, or you haven't tallied it?
I have no idea. My office handles that. I don't handle that.
Okay. I know you don't know the amount, but just so it's clear, Mr. Anderson, his office is paying you to be here today and for your review. Is that fair?
They're paying for my time.
Okay. Let me ask you about ketamine. You told the jury a moment ago about FDA approval. Back when Maya was getting ketamine in 2017, ketamine was not approved by the FDA for CRPS. True?
Well, yes.
That's true.
That's true.
Okay. I want to talk to you a little bit about your statement that Maya was improving before she went to All Children's in October of 2017. You base that on your review of Dr. Honda's records, right?
Actually, I based that not just on his records, but also on videos.
Okay. Well, let me see if I can narrow down a time frame here. Clay, will you put up what's in evidence as Joint Exhibit 1040-206? And you can enlarge this. I'll represent to you, we can go to, this is a signed letter from Dr. Hanna dated September 25th, 2016. Do you see that?
Yes.
I'll represent to you that this was written by Dr. Hanna to the school district to explain homebound status. And I'm going to ask you about some of the statements in here to see if this is consistent with what you're telling the jury in terms of how Maya was actually doing before she went to my client's hospital. At the top it says, Maya suffers from horrific disease, RSD, CRPS. Do you see that?
Yes.
Your testimony to this jury is before Maya ever went to my client's hospital, she had debilitating CRPS. That's what you believe, correct?
Yes.
And as a result of her debilitating, horrible CRPS, she was going to require, in your mind, a lifetime of care. True?
Yes.
Okay. Now, reading down on this, it says, on September 6, 2016, evening time, Maya had a relapse of her RSD. Maya became overstressed, extremely worried, and crying after a September 6, 2016 individual education plan meeting at Taylor Ranch School, which I strongly believe led to her RSD relapse. Do you see that?
Yes.
Okay. Did you know, and maybe you didn't, but did you know what caused this alleged relapse of RSD?
Well, it says right here.
Okay.
After the IEP meeting.
So, at least from your understanding reading this record, there was a psychological stress on Maya that you would attribute to the relapse of RSD. Is that fair?
A stressful event at the IEP meeting.
According to this letter, Maya was then complaining of severe pain to her legs 10 out of 10. True?
True.
She was complaining of severe pain to her back 10 out of 10. True?
True.
She was complaining of severe pain to her arms 9 out of 10. True?
True.
Severe pain to her stomach 9 out of 10. True?
True.
Migraine pain 10 out of 10. Correct?
Correct.
Severe weakness, nausea, and vomiting, and was unable to eat or drink fluids for 3.5 days, leading to her dehydration. True?
True.
And all of that was a couple weeks before she entered Johns Hopkins All Children's Hospital on October 6th, correct? October 7th, I apologize.
Yes.
This was her condition. And in addition, because you were telling the jury how well she was doing, I want to make sure that you understand this letter. Maya also required daily IV fluids for hydration leading up to her hospitalization at All Children's. True?
Well, this needs clarification. You can't just say true.
Well, do you have any reason to dispute what Dr. Hanna wrote to the school board saying that starting on September 6, 2016, Maya, on a letter dated September 25th, so now 3 weeks later, that Maya was requiring IV fluids for hydration? Do you have any reason to dispute this?
No, I have reason to dispute a lot of this letter because, you see, she was doing well, and then she had this IEP meeting on 9/6/16, and obviously that was a stressful meeting, and she went down. Everything, her condition got worse. Now that's a feature of CRPS.
But my point, doctor, is she never got better between this September 9th, 2016 relapse that you're claiming is a relapse of CRPS until she went to All Children's on October 7th. You recognize that, right?
No, I don't. How do you know that she didn't get better?
All right, let me show you the next record. Well, before we move on to this, the second last sentence says, as of September 15th, 2016, Maya K's RSD relapsed, and she has not returned to her usual baseline where she used to be prior. Do you see that?
When she used to be prior to 9/6/16. Okay, yeah, I do see that.
Okay, so now let me ask you about what's Joint Exhibit 1040-20. This is in evidence Dr. Hanna's records. Joint Exhibit 1040/20. And if you can zoom in to the top on the date, this is October 5th. So now, if you want to clarify whether Maya was better before she walked in the hospital, I'll represent to you, this is now 2 days before Dr. Hanna asked her to be admitted to All Children's. So let's scroll down a little bit more. Do you see on the history of present illness in capital letters, patient stated that her weekend was rough and she didn't sleep due to pain and had a great deal of nausea and vomiting. Do you see that?
Yes, I do see it.
And on the weight chart, 2 days before she went to All Children's, she was 60 pounds. That's the 5th percentile. True?
Yes.
and her height was below the first percentile. Do you see that?
Yes.
Do you know from your review of the records that Dr. Hanna then infused 1,250 milligrams of ketamine?
This was the day before she went to...
2 days before.
2 days before she went to All Children's.
Correct.
Yes, I know that.
Do you actually know that she underwent 5 ketamine infusions in the days leading up to going to All Children's?
Yes.
Okay. Let me ask you, Clay, if you'll turn to Joint Exhibit 1040/233. Were you aware that Dr. Hanna had his patient Maya fill out how she was feeling in her overall, what they call quality of life survey?
Okay, so I'm not just going to say yes to this.
Well, let me ask you this, and then if you need to explain, you can. You're aware of something called the American Chronic Pain Association Quality of Life Scale, correct?
Again, this is not an accepted quality of life scale.
Okay.
This is by an association that doesn't mean anything.
Okay. Well, the question, you can see there's 0 through 10, where they're asking Maya, how are you feeling, with 10 being go to work, volunteer each day, normal daily activities each day, have a social life outside work, take on an active part of family life. That would be 10, normal. 0 is stay in bed all day, feel hopeless and helpless about life. Were you aware that 2 days before Maya went to All Children's, her function was 0, according to the survey? Were you aware of that?
Right, and that's expected of it. A 10-year-old child with excruciating pain everywhere is going to be, she doesn't see anything left in her life because she's in excruciating pain all the time.
Let me ask you about Joint Exhibit 1040/17. Were you aware that even after this, Maya went back to Dr. Hanna the next day for a large IV ketamine infusion? Were you aware of it?
Which date is that?
This is October 6, 2016, the day before she was admitted to All Children's. Were you aware she was up in Clearwater getting a ketamine infusion from Dr. Hanna?
Well, I do see the record, so I'm sure she did.
Okay. And in fact, at least the time of the record is 3:40 p.m. I'll represent to you she was admitted to All Children's the next morning. But according to the record, again, it says on the history and physical, patient and mother state patient is still in extreme pain. Do you see that?
Yes.
And then, Clay, I'll ask you to go to Joint Exhibit 1040/225. This is the quality of life survey filled out the day before she went to All Children's. It was 0 again, wasn't it, doctor?
That 0 is going to be there for a long, long time.
You expected this 0 to be there for months, didn't you?
Listen, if you have the world's worst excruciating pain and you're a 10-year-old kid, let alone if you had it in one leg, you would be still 0. She had it in 4 limbs. She is always going to mark that 0 at that point.
But certainly what you're telling this jury, it sounds like, is based on her condition the day before All Children's, Maya was going to be sick with crippling pain for a while, correct?
She's going to be sick with crippling pain for most of her life.
Right, including through her hospitalization at All Children's. That's what you think. Not because of what All Children's did, because that's her condition. Correct?
Right, and she did not respond to the ketamine that given to her 2 days before that, and then she had abdominal pain. And that was the reason she went to All Children's.
Because the ketamine failed, correct? The ketamine...
That episode failed.
Okay, let me next ask you about some of the things that went on in the hospital. And before I do, let me just ask you this. You use ketamine. You do not, in your practice, recommend ketamine comas, true?
I don't do ketamine coma in my practice.
Okay. You don't do hyperbaric oxygen therapy?
No, I don't.
You don't do oral ketamine?
I do sublingual ketamine, which is under the tongue. You put this ketamine under the tongue. You don't swallow the pill.
You don't drink oral ketamine with Gatorade for your patients, do you? You don't have ketamine mixed with Gatorade and have the patient drink it at home, do you?
I don't believe in oral ketamine.
Okay. Let me ask you, before we move on to what happened in the hospital, you do recognize there is authoritative literature in the field of ketamine infusion, true?
Objection.
There is a what of literature?
Hold on a second, doctor. What's the legal basis?
Improper impeachment regarding literature.
Well, I'm asking him if he can, so I'll rephrase the question. For infusion of IV ketamine for CRPS, are you aware of consensus guidelines?
Yes.
And do you consider those guidelines authoritative in your field?
I'm sorry, consider what?
Do you consider those guidelines authoritative in your field?
No.
Okay. Do you remember when I took your deposition on February 25th, 2022? I'll hand you a copy. I'm going to ask you to turn to page 37. If I may approach it.
You may.
Sure.
This is a copy of your deposition that I took.
Page 37?
Yes, page 37. And on line 15, I asked you, for the infusion of IV ketamine for CRPS, are you aware of any consensus guidelines? And your answer is yes, there is one. And I asked you, do you consider it authoritative in your field? You said yes. Well, it is authoritative.
Well, I wasn't referring to the one you're referring to. You're referring to Stephen Cohen's.
The one attached to your deposition. I asked you, was that authoritative? And we marked as Exhibit 9 to your deposition. Are you saying you no longer recognize it as authoritative?
What's attached to my deposition?
I'll hand you the article.
Huh?
We're talking about the one authored by Dr. Stephen Cohen, correct?
You're talking about that, not me.
Okay. When I showed you Stephen Cohen's article in your deposition, you told me it was authoritative per your testimony, did you not?
I don't recall seeing Stephen Cohen's, because I've never believed in those guidelines.
Okay. Well, let me ask you about some of the care that went on at All Children's. You were aware, well, let me just ask you about, you reviewed the records from All Children's, true?
Yeah, 7,000 pages.
Okay. Let me ask you about Joint Exhibit 1001-2718. At the bottom where it says result comments R46, the second paragraph, did you review this record? Patient also stated in the room with me that she hasn't eaten in 5 days. I asked her if she doesn't have an appetite, and she said she can't eat because she's not allowed. Did you review that record?
Listen, there were 7,000 pages, so I can't tell you whether I reviewed it or not. But I agree that if you're showing it to me and you tell me this is from them, yes.
Let me ask you about Joint Exhibit 1001-3746.
Objection, Your Honor. Improper impeachment. He's not reading the second sentence right there that explains it.
Overruled. You can continue.
On Joint Exhibit 1001-3746, at the bottom, were you aware in reviewing the records that Mrs. Kowalski refused to have her child evaluated by psychiatry on admission? Were you aware of it?
Oh, yes, and I'm not surprised.
Okay. Were you also?
That's very appropriate.
Were you that so what you're telling this jury is you don't believe that Maya should have ever been assessed by a psychologist, true?
True, absolutely.
Okay, so let me ask you about her time in the hospital. Were you aware, in reviewing the records, that All Children's Hospital tried to transfer Maya to a comprehensive program for CRPS, but the parents refused?
Objection. No, there's no facts and evidence on any of that.
Okay, let me direct you to Joint Exhibit 1001-1765. Under projected discharge planning needs about halfway down, placement, and I'll represent to you this is November 10th, inpatient rehabilitation care, court order pending, parents declining to sign consent at this time. And then under provision of care, it says mother continues to deny consent for inpatient treatment at Nemours. Were you aware of that?
What's the question?
My question is, you've been critical of the care Maya received at All Children's. All Children's was trying to transfer her to a comprehensive center for.
Objection. This is
He asked me
not in
to.
evidence. None of these documents are in evidence.
This is the joint exhibit from All Children's.
Time out. Gentlemen, if you could approach. The question is sustained, but you may continue, Mr. Shapiro.
Thank you, Your Honor. Doctor, were you aware during Maya's hospitalization that the parents declined to have her transferred to another hospital for care?
But
Were you aware of it?
well, yes, according to what you're showing me on the document, yes. But I need to elaborate why they refused.
Okay. Well, you're welcome to when Mr. Anderson asks you questions.
Actually, you can answer.
Okay, go ahead.
Finish the answer now.
Yeah.
Go ahead.
Well, because the idea of treating CRPS is first you've got to control the pain. You can't have a patient with severe burning pain in 4 limbs and you put them into an inpatient rehab center and start making them exercise. So ACH was not doing anything to help her pain. And so they need to control her pain, and then they would have transferred her to any other place they could. She was doing rehab anyway. She was even doing rehab at ACH.
Are you telling this jury that in your review of all the All Children's records, they never offered Maya anything for pain?
Not enough.
They offered Maya pain medication during her hospitalization. You know that.
But they didn't control the pain.
You are aware that, or are you aware whether there were attempts to transfer her for outpatient therapy? Are you aware?
Same objection.
Sorry, could you rephrase that question?
Are you aware of whether All Children's attempted to transfer or discharge Maya earlier in her hospitalization for outpatient therapy?
Well, I mean, you're not getting my point. My point is that All Children's did not control her pain. And now they're trying to pass her off to an inpatient rehab or an outpatient rehab or something like that. That's what they're doing. And the parents didn't want that. Parents wanted her pain controlled, and they would have done the rehab happily by themselves. They were doing it at Dr. Hannah's place.
And we talked about Dr. Hannah's records and their success rate, but let me ask you about your evaluation of Maya in your report. By the way, the recommendations you made in your, well, let me just back up. I apologize, doctor. You've seen Maya once for a forensic evaluation in January of 2017, correct?
Yes.
You have not evaluated her since, true?
No.
Okay. You sat with her for 5 hours and 22 minutes?
That's correct.
What pain medication did you give her for your evaluation?
No, it's just an evaluation, not a treatment.
Okay. She was able to tolerate your evaluation without any pain medication?
She wasn't. She was in severe pain.
She sat with you for 5 hours and 22 minutes, true?
She lay down. She didn't sit.
Let me ask you about some of your statements or plans of care. And actually, let me, I think this is Joint Exhibit 2005-1. Clay, if you don't mind putting it up on the screen, please. Well, I may have the wrong exhibit. It's there we go. I think this is what Mr. Anderson walked you through. True?
Yes, he did.
Okay. The way, and it's just a technicality, but I thought it was important to point out, so let me just ask you. This report that you have was actually a letter back to a primary care pediatrician, Dr. Wassenaar, true?
Yes.
Did you ever speak with Dr. Wassenaar?
No.
Let me ask you about some of the recommendations in your report. By the way, at this point, Maya hadn't walked in almost 2 years, true?
I don't remember that.
Okay.
For how long she hadn't walked.
I'm not trying to trap you, I promise. The testimony that the jury's heard is generally that after about July 4th, 2015, she was in a wheelchair from that point going forward. And if I got that wrong, I'm sure someone's going to jump up and tell me. But all that being said, so now we're 2015, 2016, so about a year and a half, she has not been out of her wheelchair walking, okay? Would the lack of walking secondary to what you believe is CRPS cause her legs to be atrophied?
Yes.
Let me ask you about some of the recommendations that you were talking about with Mr. Anderson that begin, I think, on page 18, it could be 19. That's it. All of these recommendations are because Maya has CRPS, true?
No.
Well, I guess that's fair. Some of these are because you think she may have had Ehlers-Danlos syndrome, true?
Right.
That's a genetic disease.
Yes.
Did you test for it?
I did a clinical. There's no blood test for it. It's a clinical test.
Okay. Do you know if Dr. Wassenaar ever followed up on your letter to him recommending treatment for Ehlers-Danlos syndrome?
My job was very clear. The question I was asked was, does she have CRPS or not? And that was my job. My job was, I wasn't a treating physician.
I understand. You were serving as a forensic expert on this issue, true?
True.
Okay. But you did, in your evaluation of Maya, believe she may have had a genetic cause for some of her problems, true?
Could be.
And you also thought that she may have had a neurologic cause in the form of a tethered cord unrelated to CRPS?
I wasn't sure. I needed her to see a neurosurgeon to decide that.
Do you know if Dr. Wassenauer ever followed up with a neurosurgeon?
I don't know.
You also, in your report, if you go down a little bit on the same page, talked about bilateral thoracic outlet syndrome. Do you know if any follow-up was ever done for Maya regarding that?
We've already established that this was my one and only contact with Maya, and it is a forensic exam, so I'm not the treating physician. I don't follow up.
Okay. Then I promise you I won't belabor the question. The answer to any question I ask you of, do you know if Dr. Wassenauer ever followed up with this, any of this, the answer would be you don't know.
No, okay. I don't know.
And in terms of her complex regional pain syndrome number 11, it says minimize surgical trauma. At the bottom, 11A, minimize surgical trauma, including needle sticks. Okay, it was your belief at that time that Maya's CRPS was so bad that for the going forward, she wouldn't be able to tolerate needle sticks. Is that true?
No, that's not what the recommendation means.
Okay, so and let me try to clarify. I appreciate that. In terms of what you're telling this jury, you don't know in the future whether Maya is going to have this problem because you haven't evaluated her, true?
We know she has CRPS. So this rule applies to her for the rest of her life. So a person can have CRPS in their left leg and they still are at risk if they get a needle stick in their right arm.
Piercings, she'd be at risk if she got piercings.
That is a risk.
Okay, do you know if Maya ever got piercings?
No, I don't know.
Do you know if she got piercings, whether she had any pain from them?
I don't know.
Okay. Do you know if she's had any subsequent surgeries where she's had any problems as a result of surgery, or you don't know?
So that's not how the human body works. So if you have CRPS and you get a piercing or you get a surgery, the chance of your CRPS getting worse or spreading is high, but doesn't mean that it will get high or it will spread.
So what you're telling this jury, you're not saying that these things on her list are more likely than not to happen. You're just saying that these things on your list are things that somebody, for example, with CRPS might encounter. Is that fair?
It's
Overruled 14 of them.
It's a standard recommendation for any patient with CRPS.
Got it. The recommendations on here are standard for anyone who has this diagnosis, true?
Recommendation 11A.
Okay. The just a couple more questions, Bob. Well, let me ask you a little bit about, you don't know how, I mean, I know she's in the courtroom, but you don't know physically how Maya's doing today, true?
No.
Okay. But you can tell physically she's doing better today than she was when she was brought into All Children's, true?
Well, first I didn't see her when she went to All Children's, and today all I've done is see her from a distance. That doesn't mean that she can't be in severe excruciating pain.
Has anybody, have you, in your time working on this case and working with Mr. Anderson, did you ever ask Mr. Anderson, how is Maya doing today?
No.
And when she saw you, she was in a wheelchair, right?
Yes.
And now she's walking today.
Yes.
One moment, please. else further this time, Your Honor.
May we put one exhibit on?
Sure. Members of the jury, my conference is going to take a few more minutes, so what I'm going to do is I'm going to send you for a short break. Let's try to keep it 5 minutes or so. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. Let's try to keep it to 5, maybe 10 minutes, okay?
All right, for the next thing.
Okay, the jury is out of our presence. Everyone please be seated. Mr. Shapiro, Mr. Anderson, does Dr. Chopra need to step outside, or can he sit here while you do what you need to do?
It's up to Dr. Chopra. If he wants a break, I have no objection.
Do you want a couple-minute break, sir?
Yeah.
Okay, why don't you come back in 5 minutes? Just remember, you can't talk to anybody about your testimony. Just so the clerk's aware, we're now talking about Exhibit 3035 and perhaps certain pages, including 0024. And we're going to wait on Mr. Shapiro to give us additional pages to look at.
Thank you.
Do you want me to sit here, or do you want me to come back in 5 minutes?
You're welcome to come back in 5 minutes, sir.
Okay, I'll be back in 5 minutes.
I'm just looking, they just handed me the documents they want to put in.
Okay, go ahead and review and let me know if there's any objection.
This is still
Right. I mean, we don't need you at sidebar at this point. What are the, is there an agreement or are there objections?
There are objections, not to the complete document, but there's objections to the introduction of explanations of court hearings, court strategy, and the DCF.
Well, time out. Just tell me specifically what pages we're talking about. In Exhibit 3035.
3035-12 would be one of the ones that if we're going to go into this with this witness, I would want recross on.
12, and then what are the others?
3035-22 and 3035-23.
Okay, so can someone put up 12, 3035-12? And what is the objection, Mr. Anderson?
I think these are together, but if you look down under 3 p.m., Kathy stated parents are still in court reviewing patient's case with judge, and they do not anticipate meeting will conclude before 5 p.m. And my concern with this, Your Honor, is that I don't know what this witness is going to say once they open the door to the DCF matter, because I have not briefed him or prepped him so he knows the rules. And so when we get into the DCF stuff, I think it's going to be the Wild Wild West. And this is loaded with it, including, if you see the next page, Judge would like appointment to be scheduled sometime tomorrow morning. We're going to be starting to try the DCF case too. So if you look at the next page, it's more clear.
Page 22?
Yes. So this part. Yeah, CPS has been contacted and is going to come to All Children's this afternoon to begin their investigation. I thought that what's the date of that? I thought that was out of evidence in terms of being used for cross-examination, but.
Well, here's where I'm at right now, Mr. Anderson. Again, this is all predicated on what you're going to do with this witness. If I already told you, if you wanted to go into 3035-0024 with this witness, I'm going to let you do it. But so far, and these other documents will probably come in so far. I mean, and yeah, there's some things in here that I'd rather not be, but the Nemours issue probably is going to have to get explained somehow to the jury anyway.
Well, it's fairly complex, and again, what happens if the witness who doesn't hear anything, doesn't know anything, starts telling what he knows about the DCF investigation, how unfair it was, all of the different things that we're alleging. I don't know what his knowledge is on that, Judge. And so it's very likely, I think, that we're going to get a lot more. This particular point here that they're trying to raise, I think, can be covered in other ways, but the main thrust of this is that they're getting DCF involved. It's the 9th. It's 2 days after they came in.
Well, again, this is predicated on what you're going to do. And, I'm not going to tell you how to try your case. It sounds like you don't need this witness to talk about the issue that you want to talk about, but hey, if you feel like you want this witness to make those comments, then I'm going to let you address the 0024 document. But on cross-examination, then I'm going to let them address at least 12 and 22. I haven't looked at 23 yet. So if you don't go there, then we don't need to make any rulings. If you do, then we will. So it's up to you.
My biggest concern is I was hoping to have a couple extra hours this afternoon, which are rapidly evaporating. If they're just going to use those two, fine.
Well, there's a third one. I didn't look at 23.
I haven't seen the third one either.
Would be potentially 303-523. No, that's one. You don't want. No, that's one. Okay, I guess not that one then.
Not 23?
We'll take that one.
Yeah.
I beg your pardon.
We'll take 23.
Yeah, 303-523 would be a potential.
Yeah, we'll
Okay,
take 23.
Put 23
Can we
back
get
up,
those
please.
printed out somehow?
Yeah, we'll take 23 as well.
I'd like to use a highlighter. We're kind of on a spur of the moment here. Do we have the ability to?
Okay, so let me be clear that because I'm going to allow 3035-24, we're also going to allow in 12, 22, and 23. Is that correct?
That appears to be it.
Mr. Shapiro, do you agree?
One moment. Mind if I just get a proffer from the plaintiff of exactly what he plans to ask the doctor, only because the doctor said he doesn't know anything about the Moors. And so I'm trying to get a sense of how deep this is about to go and how we're responsible,
Well,
because
let's-
obviously we don't want to open up the door.
Let's bring in the doctor, put him on the stand, and see what happens
Okay.
outside the presence of the jury.
You get your exercise. Huh? You get your exercise.
Yes. Doctor, what we're going to do is we're going to ask you some questions outside the presence of the jury, and we may or may not ask them again in front of the jury. That's fine. Mr. Anderson.
May it please the court. Doctor, in your files, do you have the Nemours Hospital records? Do you know?
Look, I don't think I have them. I'm not 100% sure.
Okay. If I showed you a particular Nemours document, then in evidence, do you think you can identify this as a Nemours transfer notice? Let me show it. May I show it to him?
Let's just put it on the screen.
Let's put it on.
My impression was that Nemours refused admission.
Exactly, but we're talking now about the reasons why.
And when you say put this document, you mean 3035-0024?
Yes, sir.
Can I have one of the IT folks put it up, please?
If you could read that, Doctor.
So this is just to save time, this is a evaluation report on Maya?
This was a Nemours order for the transfer of Maya Kowalski and the reasons that it was rejected ultimately. And I wanted to ask you a question. I know I'm in the interest of time. Assume Jack and Beata Kowalski had researched and determined that Nemours does not have a comprehensive CRPS program.
I object to this.
We don't have a jury. Let's get the information out first. Then you can talk to us about your objections. Now, again, Mr. Anderson, let's not make predicate statements. Let's just ask the questions.
Yes, sir. Assume Jack and Beata Kowalski had researched and determined that Nemours did not have a comprehensive CRPS inpatient program. And assume further that the research revealed that it would be more of the PT that she had been through about 4 times. Assume further that from this form, as you can read, that the transfer to Nemours was based in part on Munchausen's by proxy assigned by Dr. Dees, who is not a psychiatrist or psychologist, let the record reflect. It says right there, pediatric hospitalist. And so, do you have an opinion, assuming those facts, as to whether the actions of Jack and Beata Kowalski in rejecting the Johns Hopkins reasons and methods of transferring Maya to Nemours in Orlando?
I object to that question.
We're improper.
I'm allowed to object before this. My objection is multiple. It's the court asked the plaintiff not to give a predicate, and then he just gave 6 predicates. But in addition to that, he's asking now the plaintiff to speculate on the state of mind of the parents. He's not disclosed as an expert on either and judge the reasonableness of their conduct.
Okay. Well, one thing I heard is you're now asking him an opinion. It sounds like this opinion wasn't disclosed. Is that correct?
He had no opinion about transfer unavailability.
Well, they were going to, I'm sure, open that door. I felt like they did on their cross. That's why I stood up.
Well, they opened up the door about Nemours. That doesn't mean this witness can give opinions that hadn't been previously addressed or disclosed.
I would. I can't remember the specific 2 or 3 questions, but my memory is that the questions were designed to give the jury the impression that somehow the Kowalskis had misbehaved or done something wrong in rejecting the Nemours transfer. That was clearly the thrust of them. To me, that opens the door for me to point out that they turned it down because it was based on, in part, Munchausen's by proxy, and I believe one of these codes here is from conversion disorder for Maya.
Why isn't this testimony from Mr. Kowalski?
It can be. It can be, but I think...
To me, I didn't realize you were going to ask him an opinion that had not been disclosed. So on that basis, no, this witness can't testify to an undisclosed opinion.
Well, can he testify to anything having to do with his experience and the narrative provided affecting the treatment of the child and the family?
I don't understand your question.
Can I show him this, and he's obviously aware of the prior questioning, and ask him whether his experience would be that this transfer notice being signed by the Kowalskis, is it...
Time out. Sir, do you know anything about the possible transfer to Nemours?
All I know is that Nemours refused transfer.
Okay. How did you come to that information?
It's somewhere in the records. That's the only way I would have known.
Do you know any of the details as to why the transfer was refused?
there was no details, but can I just put in something?
Sure.
If I were, as a physician, and with 30 years of experience, if I saw the word Munchausen by proxy, I don't want that patient.
Okay. Anything else?
That would probably be a pretty good question, if allowed. Having seen the Nemours transfer notice, would you, as a physician, want to accept the patient? Answer, I gather, is no. And then I would ask him why.
I'm going to object to that as an undisclosed opinion. My questions to him about transfer were very specific to malpractice claims, meaning there was an allegation from Dr. Chopra that my client committed malpractice and not giving her the proper therapy. The only reason I was asking about transfer is part of the defense of that is all Children's tried to make a transfer of the patient to a center in Nemours that specializes in comprehensive regional pain syndrome and in the rehabilitation of that, and that was not consented to. It had nothing to do with his state of mind about whether a mom should want this purely as a defense of a malpractice claim, that very narrow issue.
Well, here's where I'm at. The issue of Nemours, I think the defense has opened that door. And you're going to be able to call whatever witness or witnesses to explain. It doesn't sound like, other than seeing some sort of reference in the records, he really has details as to what happened or didn't happen with respect to the proposed transfer. And so I don't think this is the witness for you to go into that.
I have a possible solution then. I'm happy to not go into this with this witness. If the court enters an instruction that strikes the three questions about the transfer to Nemours because they were asked before it was put into evidence.
Yeah, but there was testimony about it 2 days ago as well. So it's...
I probably objected at that time too.
I don't recall. I really don't recall.
Well, our problem is this, Judge. If we're going into this, the jury should not be left hanging with this impression that Beata and Jack were being unreasonable. We have a right to rehabilitate, or whatever you want to call it, by pointing out that if they sign this, they're signing on to agreeing to Munchausen by proxy, among other things. And it's just not fair to our side that if the jury hears one side of that story, they won't hear the other side.
And again, I've said that you can call witnesses because the door has been opened. The reality is, I'm not going to allow in an undisclosed opinion. I think that's pretty clear. And it sounds like you're now trying to get him to make assumptions or assume a hypothetical to give an opinion that he has not previously given prior to today. That's no issue with Dr. Chopra because I don't think this was something that was ever asked of him. So, I told you earlier, if you're going to want to show this record, that's fine, but you can't ask him opinions that were undisclosed. And once you show that document, we're showing the other documents that we were talking about. So,
well, it really puts me in a dilemma here, and it's not a dilemma of my making. And the defense was allowed to ask questions of for a witness for documents that were not in evidence, thus leaving the jury with a certain impression. So if
Mr. Anderson, I just need you to decide.
Can we have 1 moment, Your Honor?
Well,
literally 30 seconds.
Dr. Chopra, I'm showing you Exhibit 3035-0024. Do you have it in front of you?
Yes.
And does there appear to be a series of diagnoses in the middle of the page by a Dr. Dees, a pediatric hospitalist?
Yes.
And is one of the diagnoses assigned by Dr. Dees Munchausen by proxy?
Yes.
if you turn the page, is there...
I can't turn it. Somebody else will.
That's all right. But there's a second page for a place to sign, which we'll bring up. And that's all I'll ask you. Was there a place where the Kowalskis were supposed to sign to agree to this for transfer? That's my own. Those are three factual questions.
There's no place for the patient or the patient's representative to sign.
Well, it says E-level, encounter E-level signatures, order-level documents, and so forth. It's kind of in bureaucratese, but this is, I believe, what they were presented with.
He gave his answer.
All right, so I don't ask him about the signature page.
I don't know what encounter level e-signature means.
E-signature is one that's sent through the court. Yes.
He doesn't know.
Okay.
So
I
I'm
can
not
ask
going to tell him for him to turn around and say it. So.
Well, I understand, Judge. I'd like to ask the factual questions here because I don't want the jury left with that impression. And it could be 4 or 5 days before we call Jack Kowalski.
If I understand, Mr. Anderson wants to address with Dr. Chopra the reasonableness of accepting transfer with a diagnosis of Munchausen in the record as an undisclosed opinion.
I think at this point it's just the last 3 or 4 questions, the factual questions he asked about the document.
And the problem with that is the redirect, if the implication, I don't think this is a secret, if the implication is going to be that we would have accepted a transfer except now that there's a diagnosis in the record, it's going to open up a redirect on the fact that it was also in the record in 40 other medical records and providers from Lurie's to et cetera. And I don't know how much of this I need to get in front of this witness. It's just...
That's a difference between a diagnosis and a theory.
Here's where I'm at. Those questions that you just asked Mr. Anderson, except for the parent signature question, I'm fine, and I'm fine with the 0024 and 25. But if you go there, I'm going to allow 12, 22, and 23 as well. So I just need you to decide right here, right now, whether you're going to use this witness to do it, have this discussion, or you're going to call someone else down the road. And I know you feel like you're in a box, but at this point in time, you got to make a decision.
Well, over my objection, I probably at this point will hold off, with the document. But I will ask questions about does he know the basis for the transfer? Does he know the basis for the transfer in part was Munchausen by proxy?
Okay.
Is that okay?
If you're basically now going to ask him questions off of this document, I see that as the same thing as us introducing and showing the jury the document. So
that's pretty much the way I felt when on their cross-examination.
Mr. Anderson, we are where we're at. Do you want to use this witness to talk about the Nemours issue as I just outlined, or are you not?
One moment.
I've got a jury waiting.
I don't know. It's very difficult. One more question of him, and then
in proffer or
proffer
outside or with the jury?
Proffer.
Okay.
Are you able to identify this as a transfer form as opposed to something else?
This is a report of an admitting nurse from Nemours.
Okay. And can you see from this document why we have an admitting nurse at Nemours giving this report?
Yeah, I would object to the speculation.
You can answer the question. Sir, do you know the answer?
If you don't know,
What's
you
the
don't
question?
know. Yeah, the
Sorry.
question is, do you know why, and at this juncture, a transfer nurse was involved?
Well, yes, that I know. All children wanted to transfer Maya to Nemours for rehabilitation.
And then what does the diagnosis in part show as a reason assigned by Dr. Dees to transfer her over?
It shows Munchausen by proxy.
And in your opinion, did this child have Munchausen by proxy? That is in the report and in the record.
Absolutely not.
Right. I'll use it.
Anything before I bring in the jury?
I don't think so.
So to be clear, at this point in time, and I'm not making this, but are we admitting 3035, 12, 22, 23, 24, and 25? Is that correct?
Yes, Your Honor.
I believe so.
Oh, wait.
You don't. There's a portion of that. I beg your pardon, Judge. There's a portion of 24, I believe it is, that does make reference to dependency court proceedings that I would like to redact before it gets admitted to evidence.
Well, again, I'm not fond of this entire exercise, but be that as it may, I feel like Johns Hopkins, by its questioning, has put the issue of Nemours squarely into contention here, and the plaintiff has a right to discuss that.
I don't quibble with that a bit, Judge. That's not the point. That's not the point of what I'm saying.
If they'll withdraw the testimony, the attempted cross on something that was not in evidence, then I'm fine, and we can go home.
Just for the record, I didn't question the doctor on a single record from the Moors. It was about the records from all children that were in evidence.
Yeah, the testimony that is the testimony stands at this point. So the question is, and again, it's the same question I asked you 10 or 15 minutes ago. Are you going to want to use this witness to talk about those factual questions that we just were talking about and your opinion on Munchausen by proxy that you just elicited, or are you not?
How long do you plan to go today, Judge?
What can I do to get an answer out of you?
I think
Okay, so then my question is 12, 22, 23, 24, and 25, and I now am hearing from Mr. Hunter that he has an objection to 25, which we should have probably told me 30 or 45 minutes ago. So
It's basically the bottom of 24, Judge.
can someone put up 24, please?
Is that 24?
Okay, what specifically are you talking about?
It makes reference to having an order in place.
Just tell me the specific language that you're talking about.
Patient.
Patient must
Just
have
go ahead and
court
say
order.
it, Judge, I'm sorry.
So a patient must have court order in place to be transferred?
Yeah.
Is that what you're talking about?
I was talking about the reference to the court order, and there was one in here earlier there was reference being made to the family being in court in front of the judge and would not be available until the next morning. That was what I was really concerned about.
I mean, is it any
any surprise to the jury that there were dependency court proceedings going on? And we're not trying that case, but.
Okay, as long as that's understood, go ahead, Judge, I'm sorry.
Okay. So the court at this time, Madam Clerk, is going to receive 3035 pages 12, 22, 23, 24, and 25. And let's go ahead and bring in the jury. Okay, everyone, please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation, and you received no information. Is that all correct? Correct. And I want to confirm that since the last time you were with us, you were not approached by anyone about this case. Correct. And that you have not seen any media coverage concerning this case. Correct. Okay. And I'll have to tell you, my wife always loves when I said it's 5 minutes. I seem to have a very elastic sense of time when it comes to 5 minutes. At least it wasn't one time I was with her and I said 5 minutes, and 4 hours later I was still at the office working. So I apologize, but sometimes things just take a little bit longer, and I'm glad I didn't have you sit here while we were having that discussion. So.
And you're still married.
And I'm still married, which is the biggest surprise of all. Mr. Anderson.
May it please the court. Insofar as the specifics of the day-to-day, month-to-month care of Maya Kowalski, would you defer to our physiatrist who has worked that out? Your opinion, would you defer to the physiatrist for the day-to-day minutia of the care?
I didn't, you'll have to rephrase it. I didn't get that question.
Don't worry about it. Okay. On cross, you were asked about an authoritative source, and I believe you answered that that it wasn't authoritative, and it might have been authoritative, but do you know if we can put up 1001 to 2718? Okay, I'm shifting gears because that's not the one I wanted, but I can use this one to get that point, which is my next one. You were shown on cross-examination this. Can we highlight that middle, the entire paragraph instead of just the top? And can you read to yourself the reason why Beata Kowalski said she's not allowed to eat? What's a TPN?
It's called, TPN stands for parenteral nutrition. I forget the first T, what the T stands for, but it's nutrition that's given through an IV. And is TPN a ban on feeding until the diagnosis could be understood by the hospital? No, there's nothing wrong on giving TPN. I mean, there are some risks involved when you give someone TPN. Okay. And did it come to your attention, though, that there was an order from Johns Hopkins that prohibited Maya from eating until they actually diagnosed what was wrong with her stomach?
Objection, lack of foundation.
I wasn't aware of that rule, but that would be standard practice.
And so, if this is standard practice, and there was, in fact, such an order, would it be reasonable for Beata Kowalski to inform whatever the nurse was or whomever that Maya couldn't eat because there was an order saying not to eat?
Objection. It's lack of foundation. It's also speculation on the state of mind.
Well, it says that Beata said that she is not allowed to eat, that she was just quoting the hospital orders, which the nurse should have known.
Yep. Okay. There was also a question about a tethered cord. Let me show you Exhibit 1028-147. And I'll ask you there if we can highlight the line where he says the patient and father state she saw her GP. What's a GP?
General practitioner.
And so what's happening here? What does it show insofar as Jack Kowalski following up on the tethered cord recommendation you made?
He did. He did follow up.
Let me show you then 2004-44. It's the MRI and Dr. Wassenauer's records. Now, there are no findings there of tether cord, are there?
No.
Does it appear to you then that the Kowalskis followed up on your recommendation and found that now that they had the test results, there was no tethered cord?
There was no tethered cord. They did follow up on it. Yes.
You were asked on cross-examination about what was an authoritative source, and it was specifically the guidelines. I'm forgetting the phrase that they used.
Consensus guidelines.
The consensus guidelines. Do you recall that testimony?
Well, I was reminded about it. Yes.
Okay. And you said you were aware of it. Does it show that Stephen Cohen is one of the authors of that?
Yes, he's the first author on it.
And tell the jury who Dr. Stephen Cohen works for.
John Hopkins, All Children's.
That's an objection. I move to strike it as an inaccurate statement.
It's just Johns Hopkins.
You can overrule.
Thank you. All right. So now, turning to whether or not the Kowalskis actually transferred or the reasons, let me show you what's been previously marked into evidence as 3035-0024. If we could bring that up.
I have it here.
All right. And so, in this, does it appear to be from Nemours?
Yes.
And does it appear to be a transfer nurse that is creating the progress note?
So, for the ladies and gentlemen of the jury, just want to explain. When a patient is transferred from one hospital to another, the second hospital sends over a nurse who does an assessment. And then based on the assessment, the second hospital will decide whether they want this patient or not. And that's this report.
So if you look at under Sandra Perez, MSW, does it say that she met with the Johns Hopkins people?
She met with, yes, she did meet with them.
All right. Is one of the diagnoses already made and placed into this Munchausen by proxy?
Yes.
Doctor, what happens, and you've previously discussed this, when a diagnosis like this is put into a patient's records.
I object to this.
He's already testified about narratives.
That question I'm sustaining.
If I...
Hold on a second, sir. I sustained it, so Mr. Anderson's going to have to ask you another question.
Okay.
What, if any, effect in your practice as a physician does having this Munchausen by proxy in the record?
Same objection.
I'm sustaining.
As opinion?
Yes.
Right. Well then, does it say that Johns Hopkins told them it was Munchausen by proxy
Objection.
among the...
Overruled the objection. You can ask that question.
Does it say Munchausen by proxy is one of the diagnoses?
Okay, I have an opinion on this.
Please.
Can I say? Okay. For one, they...
Object, Your Honor. Same objection.
Well, the jury needs to know the truth.
Sir, what I need is you to answer the specific question that was asked.
Okay.
Which I have now forgot.
The question that you'd asked was, is Munchausen... No, what...
What happens when... Well, that one's already been overruled. I said, was Munchausen's by proxy assigned by a Dr. Dees with Johns Hopkins?
Yes.
And did Maya have Munchausen by... Or did Beata have Munchausen by proxy?
No.
And is that a psychiatric diagnosis?
Yes.
Is it a negative psychiatric diagnosis?
Objection.
It's a grossly...
Overruled. You can... the answer stands.
It's a grossly negative psychiatric diagnosis.
All right. And so, if you look at the bottom, does there appear to be some editorial about Maya with Johns Hopkins?
What do you mean by editorial?
Okay. Was there a comment made about whether or not she could clearly move her arms to do so?
Yes.
All right. And so, in the actual diagnosis for the transfer, which the Kowalskis would have to consent to, obviously, was there a finding that was, in effect, an admission that if they signed, it would be Munchausen by proxy, they would agree to it?
Objection, Your Honor, in scope and foundation relevance outside.
Mr. Court Reporter, can I have that question again, please?
Okay, and so in the actual diagnosis for the transfer, which the Kowalskis would have to consent to, obviously, was there a finding that was in effect an admission that if they assigned it would be Munchausen by proxy, you would agree to it?
I'm going to overrule the objection. You can answer that question.
Yes.
None can say.
If the Kowalskis signed it, they would be admitting that they have Munchausen by proxy.
Thank you, Your Honor.
Is it defense turn?
Just very briefly.
Well, one last question. Was this transfer notice for the purpose of CRPS treatment or for a psychological psychiatric treatment?
Objection.
Sustained.
Nothing further.
Okay. Very briefly, Your Honor.
Yes.
Just because you were asked about Munchausen's and prior psychiatric diagnoses, are you aware of whether records prior to All Children's Hospital also contained those suspicions or diagnoses?
That's irrelevant.
I asked you if you were aware of whether other institutions prior to All Children's had also made those diagnoses or suspicions?
I'm just trying to think of the hospitals. No, not aware of any.
So the totality of the records that you reviewed and everything you reviewed, you don't remember ever seeing either at Tampa General or Lurie's Hospital prior to All Children's, their records containing either diagnoses or suspicions from other physicians about either Munchausen's or other psychiatric disorders. You don't remember ever seeing it?
Objection.
I know.
Across because facts are not in evidence. No.
I don't recall any of them diagnosing.
That's all. Thank you, Doctor.
Anything further from the claims?
No, Your
You didn't see.
You don't understand. The jury actually gets asked questions too.
Are you serious? It's a nice day.
Members of the jury, do any of you have questions for the doctor? I see at least 1, 2, 3. Lawyers, please come forward.
Seriously?
Notes. I know you're trying to conserve paper, but we have enough paper for your notes. Just pull the whole sheet of paper, please. Thank you. Hey, Dr. Chopra, I have quite a few questions from the jury. Do you have an opinion on how Maya's CRPS started?
That's actually a very good question, and the answer is no, I don't know. What had happened was she was admitted, and that was before this case. She was admitted to the same hospital. She had been given very high doses of steroid for her asthma. And at that point, she developed pain in both her legs. And that was eventually diagnosed as CRPS, but we never could find out why. And that does happen in CRPS.
So the attorneys are aware, based on how he answered that question. I'm not going to ask the next follow-up on that.
Yes, Your Honor.
The next question, is ketamine addictive physically or psychologically?
No, not at all. Not at all addictive.
Does ketamine cause constipation or continued use cause obstination?
No, not at all.
How do you simultaneously acknowledge this case is rare and unknown, but also answer that the treatment would have a certain outcome? What's the basis for your belief? Is it opinion or science?
I didn't understand that.
Okay. How do you simultaneously acknowledge this case is rare and unknown, but also answer that the treatment would have a certain outcome?
You mean case or the condition?
I think the question is case, but the attorneys and then the jury can follow up if I'm misunderstanding the question.
Well, I'll address both. CRPS is officially considered to be a rare condition, officially. But in reality, the incidence is actually very high. I have it here. It's about 200,000 cases per year, and the incidence is about 7% in children per year. It's officially considered rare because no one has gotten around to, because it gets missed all the time, so people haven't been able to accurately get figures as how many people actually have CRPS and was missed. This case of where a child developed CRPS and was accused of, parents were accused of child abuse, and then ending in a mother's suicide, is actually very common. It is worrisome, and it is extremely common, more than you would think.
The follow-up to that, what's the basis for your belief? Is it opinion or science?
Belief of what?
Your answer just immediately before.
Oh, no, these are all facts. It's not my belief. It's not a rare condition, but that's my belief. It's not a rare condition. And it's a general consensus also. It's just that we haven't gotten the data going. No one has bothered to collect the data. So it's still considered a rare condition. And a lot of people want it to remain as a rare, patients want it to remain as a rare condition because the FDA then approves drugs easily for rare conditions. So a lot of people want that. And it's not, so it's my belief is that it's not a rare condition, but the official statement is that. Any other beliefs?
Well, the next question
is,
and this is going back to ketamine, are there withdrawal side effects after long-term ketamine treatments?
No, not at all. No, you can be on ketamine continuously, and it happens. You can be on ketamine. Hospitals will put a patient on ketamine infusion continuously for 10 days, and then abruptly stop it, go home, and nothing, no withdrawal at all. That's the beauty of this drug.
And the last question at this time from the jury. Is it more common for the onset of CRPS symptoms to gradually progress or to just appear one day with excruciating pain?
No. This condition, if you don't treat it, it just keeps progressing, and eventually just keeps progressing till the patient eventually becomes bedridden, and then it's the end of it. It doesn't get better on its own, ever.
Plaintiffs, are there any follow-up questions?
Yes, Doctor, part of your review, were you able to determine whether in those instances where Maya went off ketamine, such as after Dr. Kirkpatrick, and before she went to Mexico, whether she ever experienced any withdrawal symptoms?
No, you don't. You don't get withdrawal from ketamine. I mean, she came back from Mexico and she didn't have withdrawal. No, you don't get withdrawal from ketamine.
And can you tell the jury, just so that when they're back there looking, what if it were to be withdrawal, if it was an opioid-like withdrawal, which I think is what they're thinking, what would you expect to see in her records?
Well, she would have tremor, like any other withdrawal. She would have tremors and, what's it called? Feeling like bugs under your skin, and all of those symptoms. Severe nausea, severe nausea.
All right, and it's sort of similar to alcohol or nicotine or substance, any addictive substance?
Kind of.
But ketamine, is ketamine addictive?
Not at all.
Your witness. Oh, one more. Can ketamine, have you seen in your career asthma attacks cause CRPS?
No, there's no direct there's no direct correlation in that. There may be an indirect correlation, but not a direct correlation.
Thank you, Doctor.
I'm only going to owe you $1.
Is there a
one question? $1.
Is there a stop period? Do you have a button to push for stop?
I told you I'd pay you your $1. Yeah, it's going to be quick, I promise. Just to follow up on one of the jurors' excellent questions. The side effects of ketamine, those include nausea, vomiting, colorful dreams, hallucinations, and headaches, correct?
Yes, but I need to elaborate on that. If you give someone a whole lot of ketamine suddenly, let's say I gave you 200 milligrams of ketamine as one shot, you would have all of those. You would be seeing pink elephants flying around this room. But if you give 200 milligrams over 4 hours, you'd be fine.
Okay. So high doses of ketamine would cause those side effects, correct?
Again, high doses of ketamine given slowly over time, you probably will not see that effect.
Those are the potential side effects of ketamine.
Those are the potential, yeah.
Okay. I owe you $3.
Oh, yeah, I know. And $4 there, $7 today. My day is done.
No other questions?
Well, members of the jury, do any of you have any further questions? None. May this witness be excused at this time.
I may hold him for potential recall later, but he may be dismissed today.
Okay. So, sir, what that means is you're free to go today. It's possible they might ask you back. So let's not talk about our testimony with anybody except for the lawyers, okay?
Okay. He hates me.
Thank you for being here, and have a good afternoon.
Thank you very much.
Okay.
Am I supposed to leave first before everyone?
You can go right now.
Oh, cool.
And you might want to leave before we change our mind.
I know, because these days.
Thank you, Doctor.
Thank you.
Okay. Members of the jury, let's take care of a few housekeeping items. That's going to be our last witness today. So I know it's only 4 o'clock, and I'm
sure you're really upset that we're leaving at 4 as opposed to 5. I know that there was a request earlier to kind of know what the schedule is. And I will tell you, I have been discussing that with the lawyers, and I should be able to tell you tomorrow what our schedule is next week. And it's my intent, hopefully by the Friday of each week, to kind of give you a preview about what the following week's going to be, and if we're going to have some time. When I say time off, it's really time off for the jury because there are other things that we are doing outside your presence. So when I say time off, don't assume that we're not working. I will tell you the logistics that go into a trial are extremely difficult. And before I was a judge, I was where these lawyers are, and you're balancing witnesses. They've got their own commitments and work, and that's before you even get to the life issues like a plane gets diverted or a delay, or someone gets sick, or someone has to go to the hospital. I mean, there's just all the life issues that go on. So we kind of build into our schedule a little bit of time to account for that. The good thing for you right this second is we are a little bit ahead of our schedule. So I'm constantly discussing with the lawyers, usually it's outside your presence, where we are, what witnesses we have going on. And the lawyers on both sides are working very hard to coordinate what witnesses are going to be here. So everybody knows when you walk through the door that we are asking witnesses questions and everyone is prepared. And so, the lawyers have done a very good job on both sides to do that. So I know that there is a desire for a schedule, and I will accommodate as best we can. Understand also that there are issues that sometimes crop up that, what will I know tomorrow might not be the same as what I know next Wednesday. And so I will do my best each Friday, if not before then, to kind of give you what the following week's preview is. Is that level of frequency sufficient for you all, or do I need to have a more rapid? Okay. I promise you that I will do that. And I do see, sure.
It would be nice if we knew that, October 15th, we would be needed here or whatever, so that we can look. I think the reference was sort of like, are there any known holidays or court holidays?
Well, I can tell you right this second that next Friday in the afternoon, we're not going to be here. Whether we're here the whole day, the morning or not, I don't yet know. I hear your point. There might be a day or two that I can give you this far out, but it's not going to be, but maybe a day or two. I'll talk with the lawyers about that. But I just, I'll get back to you on that. But I don't think there's, but maybe a day or two that I'm going to be able to tell you tomorrow, hey, on October, blah, 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 we're not going to be here. So, but I will do my best. Anything else on that issue? Okay. Tomorrow, we will be here again, and tomorrow is Friday. So do not discuss this case amongst yourselves. Do not do any investigation, receive no information. And based on my new questions, also please make sure that you're not observing any sort of media reports about this case. With that, have a good afternoon, and we'll see you tomorrow at the rallying point at the same time. Presence probably is a good thing that Dr. Kirkpatrick wasn't here today. Do we need a break before we talk about whatever we need, or do you want to keep going?
Can we keep going? Because
Okay.
Keep going stuff. We're going to get out of here, Judge.
Keep going it is. So what's the next issue? Obviously, the jury's out of our presence. What's the next issue we need to address?
Judge,
none by plaintiff.
Judge, I'd like to reprise my concern that I raised or made briefly, brought the court's attention to briefly this morning regarding trial publicity. Yesterday, there was telecast on Court TV an interview from Mr. Anderson in which he made reference to a Nuremberg defense, to the merits of the defense, and then he made reference to his confidence that when the jury hears how the DCF proceeding was manipulated behind the scenes, that they would act in a certain way. What concerns me about that, there's a number of different concerns about that, not the least of which is the nature of the reference to a defense asserted by Nazis. But there's also a very real publicity issue with respect to what the jury hasn't heard or what the court is going to let the jury hear about something behind the scenes, which suggests to me that there is reference to matters which are not yet in evidence and may never be in evidence. And I have a concern about that from the standpoint of, again, of jurors being approached by outsiders and that subject being brought up to them and having, as a result, a juror who otherwise is trying to abide by this court's admonitions tainted in some way by trial publicity. Counsel has indicated his concern about publicity that has been, or comments that have been made in the media by the defense team at one point or another. I would say to the court that one of those concerns regarding Facebook posts by a spouse has been stopped definitively and will remain so. Otherwise, you have not heard any comment from the defense team regarding what's going on in this trial, and as far as I'm concerned, you won't. I would ask that the court basically make clear that we should not be engaging in publicity during this trial, certainly not engaging in comment on what the evidence may show or not, and certainly not talking about or editorializing regarding the merits of the opposing party's case or lack thereof. So that's the concern we've got, Judge, and I'm sure that Mr. Anderson's got something to say about it, but I don't think that it's untoward for the court to admonish all concerned that the place to try the case is in here, not out there.
Well, let me ask you this. Is there, other than a concern, a generalized concern, is there any basis of belief that there is tainting to this jury?
You've seen the same thing I've seen, Judge. I have no information at this point that the jurors have strayed from your instructions or that they intend to. Okay. My concern is not so much what the jurors may voluntarily do. My concern is more what the jurors may be confronted with as a result of this, or what pressure may be exerted on them as a result of an outsider or a third party's belief that these defendants are acting as if they were Nazis at Nuremberg, or acting as if they were manipulating the court behind the scenes, or some other nefarious activity of that nature. It doesn't assist the court or anyone for outside influence in the ecosystem of society out there to be in a position or even potentially to influence jurors or to exert pressure on jurors, or even make jurors feel like that there's pressure being exerted on them. So that's my point, Judge. I can't sit here, I can't stand here and tell Your Honor there of anything actually having been done to taint that jury so far. But what I can do and what I am doing is standing here and asking that we all take steps to make sure that it doesn't happen going forward.
Mr. Anderson?
First, Judge, I want to assure the court that I am very much aware of Rule 4-3.6 on trial publicity. And I know that I am not to be revealing facts. Schedules, fine. General view about the trial, fine. I looked it up. You can't put facts out there that are possibly not going before the jury, and you can't elaborate on those facts because, again, that is an outside source for the plaintiff, the jury to somehow access. And I have not done that. The defendants, however, have repeatedly in multiple different media. I've just got one from the Daily Mail, but it appeared in the Tampa and the Tampa Bay Times. Exclusive. Maya Kowalski's mom, Beata, was fraudulently writing prescriptions for her daughter and faces charges before she killed herself. Florida hospital who accused her of Munchausen by proxy claims. And that was from counsel here, attributed in any event to counsel. We asked them to take that down and withdraw that allegation because the court may recall that we had a hearing on a motion in limine because that was strictly an error in coding where it went in the wrong column. And the court saw that. But before we had an order from the court, the defense completely withdrew it, which to me says more about it than anything else. So I do not intend to violate, nor would I violate in any way, an ethical rule. If I am asked how the trial's going, I'm going to say, fine, it's going well. The defense scored some points, plaintiff scored some points. And these are, if you look at it, and I take great offense at them implying that I call them Nazis. In fact, if you watch it, Judge, I specifically said, well, some people call it the Nuremberg defense. And that is a term of art among trial attorneys for blaming it on I was just following orders. Now, at the time I said that, I immediately said, I do not mean to imply in any way, just to make sure that it was taken in the context in which it was intended, which was solely to repeat a way of expressing the defense's defense that I've known for 30 years, 40 years. So I don't think we need to be admonished to follow the rules of professional responsibility. I think we're all professionals in this room, and we're going to do our best to get this case tried with a minimum amount of error.
Mr. Hunter.
I think I don't have anything else to add, Judge. I think what was said speaks for itself.
Here are my thoughts. My number one concern would be that the jury not be receiving any sort of outside influence. And even leading up to this case, I took steps to protect the identities of the jurors. As you know, every time the jury comes in, I ask them about whether there's been anything, any discussion, or if they received any information. And now at your request from this morning, I've made a little bit more specific question, and I think that's fine and appropriate. Both of you are licensed members of the Florida Bar, and you both know Rule of Professional Conduct 4-3.6. So I don't think I need to tell you that you have to follow the rules of professional conduct because that is an ongoing obligation that the lawyers have. As far as the content, certainly I've seen no indication that any of the media attention that has occurred in this case has been observed or provided information to any of our jurors. So at this point, I don't have a basis to believe that the jury has been tainted in any way, shape, or form. One of the greatest things about our country is the First Amendment and the ability to talk and to speak, the freedom of the press. And if I were to enter some sort of gag order when I don't yet have a basis to believe that any of the jurors have been approached or somehow tainted, then I'm afraid that my actions would be beyond the First Amendment of the U.S. Constitution. I'm just frankly not going to go there. Now, if there are attempts at the jurors and there comes an issue, then we might need to revisit. What the lawyers say, you're responsible for the words you say, and whether someone walks themselves into a defamation lawsuit, that's between the two parties, or a bar complaint, that's between, the parties. But that's not an issue for me. So I'm not going to take any action other than what I did this morning, which is to ask the more specific questions. And I trust both of you as members of the Florida Bar to comply with the rules regulating the Florida Bar.
We understand.
Are there any questions or clarifications?
None by plaintiff.
Okay, what's the next issue?
Judge, they gave us the list of witnesses they intend to call tomorrow, one by Zoom. We object to one of the witnesses. I don't know if the court wants to hear that now.
Might as well, since we're here.
So they plan on calling Meg Boland. Miss Boland, as I understand it, was a woman that was communicating with Beata Kowalski. She didn't start communicating with her until May of 2016, so after the ketamine treatment had been decided on by the Kowalskis.
Let me make sure I understand. Are you objecting to her by Zoom or objecting to her as
Oh,
a
no,
witness?
not by Zoom. I'm objecting to her testifying.
Oh, okay.
I'm sorry. So her first interaction with Mrs. Kowalski is May of 2016, and she's part of this Ferocious Fighters for CRPS. She has a child at CRPS, and all the communication is through emails or Facebook or whatever, going back and forth. Everything she knows about what's going on with the Kowalskis is hearsay through Mrs. Kowalski. It's all hearsay, and the court has previously entered an order granting a motion in limine that on DIN 2580 that lay witnesses' proposed testimony about their personal experiences with CRPS is in no way relevant to the causes of action in this case. The court at present is not in a position to evaluate whether those witnesses' communications to the Kowalskis prior to the Kowalskis' determination of a ketamine therapy regimen for MK pre the hospitalization, would inform as to the Kowalski state of mind to pursue the ketamine regimen. So unless, maybe I'm missing it, Judge, and they can inform me otherwise, but Meg Boland's first interaction, again, was May of 2016, long after the ketamine treatment had been started. She has a son with CRPS. She has a blog, a Facebook page about it, and all of her communications and all her knowledge are hearsay with regard to the Kowalskis.
She was also one of the last, if not the last person to speak with Beata. And those conversations, once the court hears them, we are confident that you will find a number of exceptions to the hearsay rule, not the least of which is of then existing mental, emotional, or physical condition.
When was her last conversation?
The day before Beata committed suicide.
On the 6th or the 5th?
When was it? The day of. The day of the suicide.
Was it like after or before the hearing with the dependency court?
I assume it's after, because it wasn't that in the morning.
I wasn't there.
Yeah, neither was I.
January 6th,
I don't know, Judge. I can't tell you if what the case was there. I do know that the statements that she will attribute to Beata Kowalski go to the state of mind, probably, although no one knew the plan, somewhat of the motive and the pain, not memory or belief. She's not going to testify about memory or belief. Any reference to her son is merely a background side reference, and I am not intending to elicit the type of testimony that counsel worries about, which I believe is other people with CRPS testifying at length about how terrible it is. I think the jury has heard how terrible it is enough. And so I'm not bringing any of that out. I am bringing out, through Ms. Boland, Beata Kowalski's state of mind and descent to the point where she took her life. And she was the person that was most talked to in our view. We can continue on the different exceptions to the hearsay rule.
Let me ask you this. So, besides the conversation the day of, are you intending to elicit testimony of prior conversations?
A couple of them. And again, it's going to go to Beata's state of mind as to whether she was looking at other options, whether she had a plan regarding the continuance of the ketamine or getting Maya onto another type of regimen. It'll go to some pretty fundamental points that the defense has raised and continues to argue about whether or not this ketamine use was a Munchausen by proxy or an abuse. And the conversations where Beata relates, and they're not lengthy, but where Beata relates that, at least our parts aren't lengthy, but where Beata relates what she's doing and why she's doing it, clearly fall within the exception and are important for the jury to hear, to evaluate whether this mother was doing something crazy or whether she was of sound mind.
Judge, this is the type of genie that can't be put back in the box. I think there's going to have to be a proffer with respect to what the hearsay statement is and when it was made and under what circumstances.
Well, I don't think I can rule definitively at this point in time, because I do need to hear the circumstances of the conversation. It would seem the farther away from the date of Beata Kowalski's death, the less likely it is it's going to meet an exception to the hearsay rule. Okay. With respect to, yes, I can see a question or two about the fact that this witness has a child with CRPS, but we're not going to go into that witness's trials and tribulations with CRPS. We're not going to get into any sort of advocacy on CRPS. It's just my child has CRPS. You know,
Yes, Your Honor.
she and I bonded, or whatever it is.
Yes, sir.
Okay. But I agree with Ms. Crowells. I probably do need a proffer. Now, is she going to appear by Zoom, or is she?
She's appearing by Zoom.
Okay. Did we let my judicial assistant know so we can get an email address for her to send the panelist information?
You what?
I didn't know the procedure.
Oh, we didn't know that was part of the procedure, but we'll take care of it right now.
I need panelists, and like if a person's going to testify by Zoom, I think I put this in the order. We need to know their specific email address, because for security purposes, it's only going to be a single link to one person.
Right.
And it's not going to be to you, when I say you being the plaintiffs, for you to forward on. It's got to be directly to the person who will be coming in. So we definitely need the name and the email address. Now, what time were you anticipating this witness testifying?
She's later in the day. I think she would be probably around 2. She's going to be after lunch.
So perhaps either before we go to lunch or after we go to lunch, we might need to have that proffer. Is that what I'm hearing?
Whenever they're going to call her, Judge. I mean, I definitely think we need a proffer because, again, it's going to be hard to handle that otherwise.
I agree with you, Ms. Crowells. We'll do a proffer with respect to her proposed testimony.
Will the proffer be allocated against our time, Your Honor?
Well, it's not in front of the jury.
All right.
And speaking of time, just so you know, today plaintiff's 3 hours, 10 minutes for a cumulative running total of 10 hours, 15 minutes. Defense 1 hour, 15 minutes for a cumulative total of 3 hours, 25 minutes.
So where were we again, plaintiffs?
You're at 54 hours and 55 minutes.
I mean, Dr. Chopra put you up to that.
10 hours, 15 minutes total.
All right.
Okay, so what's the next issue?
Judge, I'm sorry, do you want?
Ms.
maybe something
Corrales?
next? Okay. Judge, recall, we started talking about this, but then we didn't have time this morning. During Dr. Duncan's testimony, Mr. Whitney stated at the beginning of a question, which I have the transcript of now, which said, if the record shows that MK did complain to the doctors at the hospital of physical and sexual abuse on multiple occasions, and then we stopped it and we approached the bench, and the judge informed the jury to ignore the statement. But we're concerned that that's not sufficient, and we would like the court to instruct the jury that there is no claim for sexual abuse by the Kowalskis. And there's no evidence that she complained to the, I'm sorry?
This is probably the time. So it's a bit of a story. When we were looking to dismiss Ms. Beatty, I had a conversation with my client, Maya Kowalski. And in fact, it's two texts which, without waiving the attorney-client privilege, I can provide to the court as to the day, which is about whenever we dismissed, I think it was last week. And she informed me that she had, before the 17th, because it's noted in Dr. Katzenstein's notes, she will testify that, well, let me continue the story. I said, Maya, we're going to dismiss Ms. Beatty. Now, are you telling me every single encounter you had there? I need to know every single encounter, no matter how big or small you think it is. And she told me one story about them dancing around her to try to get her to get out of bed and dance, and we know about this. Then she broke down, and then she told me that she had a doctor come in, and she figured it was a doctor because she described him as being tall, thin, glasses, I think she said round glasses, and dirty blonde hair. With a lab coat on, she could identify his belt and his pants. The doctor walked in, male, without chaperone or assistant. The doctor walked over to her and said, may I take a peek? The doctor pulled down Maya's pajamas. This was pretty late in the day. I know it was short shorts or pajamas, but it had a drawstring. Pulled them down, pulled her panties down, and then stared at her vagina for, Maya said, long enough for her to be not only startled, but start to cry. Whereupon he turned around, went to the door, turned around his shoulder and said, thanks. She never saw him again. Now, as an officer of the court, I will swear everywhere, had I known anything about this, I would have immediately brought it to the attention of both the court and to opposing counsel. I then waited. I've waited for the past 3 or 4 days, however long it's been, because I wanted to corroborate before I brought this before the court. So Maya was able to locate a witness where approximately 2 years, a little less than 2 years after it happened, she told a young man who was a friend of hers what happened, and he is willing to testify about it. Then I went to Dr. Katzenstein's notes, and there's a very cryptic reference in there. And it says first, this is why I didn't catch it, first it says she denies any sexual behavior, misconduct, whatever. Then it does say, she does say a doctor, what was the exact terminology?
I'll get the exhibit number out for them.
We're going to pull it up for you, Judge, so you can see it. Anyway, we'll show you the exact language, but it was words, I'm losing my place here. It was words to the effect of the child, or I'm not sure, we're going to see in a second, did say that a doctor pulled her pants down, and she was, I forget on the thing, it's been a long day, on the actual note, whether she said she was scared or whatever. I have checked this out with every psychiatrist we've got, and we've got a lot of them, as the court has seen, in an abstract manner, not referencing anything about the testimony here, but simply about repression, suppression of these kind of events. And I have learned that for children, these events are typically suppressed, and they are not brought out for years, which is why we don't have a statute of limitations on this type of behavior. And so I didn't know exactly when to bring it to the court's attention, except until I had corroborating evidence and I had determined that there was a profound reason why Maya did not say what she said. She is now old enough where she can explain it without, well, she'll still break down, but it is obviously upsetting to her. It was completely inappropriate. I don't know who the doctor was. I do know that Beata does not lie. And she said it was a Johns Hopkins lab coat, which she's very familiar with the Johns Hopkins insignia on the side. Which puts me in a quandary because we neither pled that nor informed the defense of it because we had absolutely no idea. And the note placed after the phrase child denies sexual abuse made me think that that episode was just a normal doctor visit and made me think that it was before she ever went to Johns Hopkins. I mean, it's there on the bottom, and for the record. She denied a history of sexual abuse. She stated that one time previously a doctor had looked at her private parts but did not touch her, and it made her feel uncomfortable. And we believe, and we would like to add, to ask Dr. Katzenstein about this. And
whose note is this?
This is Dr. Wasnauer's note.
No. This is a Johns Hopkins psychology note written by Dr. Katzenstein.
I beg your pardon, it says primary care physician, Dr. Wasnauer.
And it's from what time?
It was, this was on October 17th of 16, so she would have been in there approximately a week at the time. And so I then looked up the law, and obviously, Judge, you have very broad discretion here.
Obviously, this is something new.
Put it politely.
I'm sorry?
To put it politely.
I would have brought it to everybody's attention sooner, but I'm not going to release any of that kind of stuff unless I know.
This is how I think we should handle it. This is not a ruling. This is a suggestion. Let me get the party's view. And perhaps this is memo time in the future and not to answer right now. Obviously, we've got a question of late disclosure and whether it's within the pleadings or not. So perhaps what I need to understand is what the plaintiffs are asking the court specifically to do or not to do. And then we'll give the defense an opportunity to respond. I mean, and I think this is probably one of those that we probably need writing and we need case law and to be clear as to what it is that you are actually seeking, Mr. Anderson. So
yes, sir.
Perhaps, and I don't think you're putting Ms. Kowalski on next week.
No.
If you were to provide your position, maybe let's see, tomorrow's Friday, by like noon on Saturday, and then let the defense have until,
when I say close of business, probably the end of Monday to respond, and then on Tuesday we can have a dedicated discussion to the issue. Just as a spitballing ideas here. What?
That sounds fine, Judge. I mean, our requests are pretty obvious, but I agree we should all think about it, especially the defense. I have been in their position before. It's an unpleasant position. I know they'll object, but I think both sides need time to review this.
Your Honor, if I may, it's totally outside the pleadings. Not only is it new, so the only motion they can file is, at this point in time, is a motion, if they want to do it in this lawsuit and not some other lawsuit down the road. If they want to do it in this lawsuit, they've got to file a motion to amend their pleadings to add that to the complaint. And we can start this trial another year from now. But they can't try that in this case.
Well, I think because of the subject matter and the weightiness of what Mr. Anderson is saying, I kind of want to have a more formal process. I want to know specifically what the request is, and then we'll be able to review the defense's response, and I feel that might give me an ability to be able to make a more informed decision as opposed to just sitting up here and making this. Now, before all of that disclosure by Mr. Anderson occurred, my thought, Ms. Crowells, was going to be, let's kind of wait and see, because I felt that the instruction I gave yesterday was sufficient to inform the jury that that's not an issue. And so, could I be talked into an instruction later on when we're going through the entirety of the instructions? Yes, but if I were to do it, let's say if I just did it tomorrow, let's say, I think at that point I'm actually focusing and highlighting the issue, which I think would be worse. So I was comfortable yesterday with the proposed resolution that the defense suggested and I agreed with. And so nothing having to do with Mr. Anderson's disclosure. I probably wouldn't have done it given a further instruction on it in mid-trial. So, is the timing frame like noon on Saturday for the plaintiffs to file whatever they're going to file, and then sometime before midnight on Monday, a response? Are those times enough?
Yes, sir.
Okay, so that's what it'll be. The Madam Clerk notes will say that there won't be any formal order, but the plaintiffs will have it until noon on Saturday and then midnight on Monday night for the defense. And when you are filing your responses, please use that email that we used right before the trial to send a courtesy copy so I can grab it, because the clerk won't be able to docket those things over the weekend or at midnight.
Right.
Okay.
We have one other issue briefly.
Yes, sir. Is this before Mr. Altenberg, who's been so pleasantly waiting for days?
Can we get a reminder of that email address, if not now, tomorrow? I think we may have misplaced it.
I'm hopefully sure that your assistants can do it. I don't want to do it publicly.
That would be bad.
Next issue.
One of the witnesses for tomorrow is Ms. Deborah Hansen. Ms. Hansen is a former social worker at Johns Hopkins Children's Hospital. As far as I know, life is becoming full of surprises. As far as I know, her only involvement in this case was an early encounter with the Kowalskis, and the fact that she phoned in the first report to DCF. And I'm trying to divine what the purpose of her testimony may be and why it is that she's being called as a witness in the case. If that's the purpose of calling her, we're going to submit that that testimony is irrelevant given the court's ruling.
Well, the fact of it obviously has come in or will come in, and I'm not calling her to extemporize on making the call. I believe she made either the first or second call. I think she actually made the first call. But she was there working in the PICU during this period of time when Maya was brought in and is witness to certain events. She is not a managerial employee. She has been gone from Johns Hopkins for years. She is a counselor and teacher at a very, very good boarding school in New England now. And her testimony will circle around party admissions at the time of Maya's being brought in. And she was an eyewitness to several events that are exceedingly relevant and material to this trial.
Is she going to be live?
She's going to be live. She's here.
Judge, I brought up the issue of her report, and that's the only issue that concerns me. Obviously, if she sees other matters that are material and relevant, we can deal with that.
Okay. I don't think there's anything I can rule on at this point, so.
That was the only reason I brought it up was because of the report issue.
Any other issue other than the Mr. Altenburn issue from either side?
No.
Okay, Mr. Altenburn. And have you spoken with Mr. Elligott?
I have spoken with Mr. Elligott, and I got an email from him about 3 o'clock that indicated he wasn't too clear there was a hearing today. So
It's okay. I worked with Mr. Elligott last night, and I can cover what we've agreed to here or not agreed to.
Well, have you seen my amalgamation of the parties' requests? So what are your thoughts?
And my only one thing, you have just a sentence that you did a double on. At the very, before the last paragraph, the sentence, "These three false imprisonment claims are not claims," is actually the first sentence of the next paragraph, I think. It just has an "and" in it in the next sentence.
So I doubled the same sentence, huh?
Yeah.
So that sentence should read, "These three false imprisonment claims are not claims about Maya Kowalski's custody
Period.
and are not impacted by the dependency court's custody order."
I think that would be fine. And the last sentence, my only concern is that the way this case is being tried, I don't honestly know whether the shelter order or the custody order, I should be more specific, will have any effect on all of the other claims. It shouldn't have any claim on medical malpractice, and I don't think it has any claim on battery. I'm not quite so sure about intentional infliction of emotional distress. So I had worried about the language of that sentence, but I discussed that with Mr. Whitten, and I believe that if for some reason that becomes an issue down the road, I could ask for some clarification on that. But I doubt that this is going to be something that's going to catch the jury's ear in a fashion that will confuse them down the road.
So let me see if I can translate what I'm hearing. You want me to say these three false imprisonment claims are not claims about Maya Kowalski's custody and are not impacted by the dependency court's custody order, period, and then not read that next sentence.
I would prefer not that sentence, or at least, or maybe just to mention medical malpractice and battery if you were going to do that. But we had gone back and forth, and that was a sentence that I had taken out of my proposal and given you the one that basically said that it wasn't relevant to these other counts.
Okay, I guess let me make sure I understand, because I don't think I understand.
Okay.
You want me to, that clause, and are not impacted by the dependency court's custody order. Are you okay with that or not?
Yeah, the first sentence is totally fine. It's just the last sentence.
It's that last sentence.
And I actually would just prefer to leave it out, but if we're going to leave it in, I would prefer the plaintiff's claims for medical malpractice and battery are not affected by the order, and leave it at that, because I'm not sure about all the other claims.
And Mr. Whitney, what do you say about that last sentence?
We prefer to have that sentence in. The fact that you only see medical malpractice or battery there was done specifically for this concern of the defense, which is the custody orders may at some time become impactful on, let's say, the negligent infliction of emotional distress or intentional infliction of emotional distress. So this is the first time I'm hearing that that sentence should be stricken. What we discussed earlier this afternoon was that he was agreeable to that language because it only mentions medical malpractice or battery, which neither side has devised any way in which those would be impacted by the custody orders at this point.
Well, how about a more affirmative statement? The plaintiff's claims for medical malpractice or battery are not affected by the dependency court's order.
I don't object to that.
And again, did it say and others, or does it say just
He's taking out others.
I would really prefer to have others. I really don't want to send the jury a message in any way, shape, or form. And I particularly don't want the defense to capitalize on any ideas that it somehow affects the remaining causes of action. So, an abundance of caution, I'd like to leave it in.
Well, if it becomes necessary, why at the end of the court, why can't I say it, you know, this custody order has no bearing on the following claims?
Oh, I believe that the court will. I believe that you will.
So for today, I tend to agree with Mr. Altenburn. I like a more direct sentence as opposed to, you know, such as. So plaintiff's claims for medical malpractice or battery are not affected by the dependency court's order.
Well, not our objection. We just do not want the jury led to believe that they might affect the other counts, but we understand the court's view.
I don't think it's that big of a deal. I don't think that nuance is something they're going to focus on, and even if they did, I think a instruction at the end specifically identifying the counts could alleviate any possible concern that you had. And
very good,
I have two other concerns.
Okay.
If you turn to the first page, Your Honor, and I think we have agreement on this one. This is the second, the largest paragraph on the page there.
The one that starts after that report was made?
Yes, Your Honor. The fourth and fifth sentence says, the dependency court made the decision to keep Maya Kowalski at Johns Hopkins All Children's Hospital. We agreed that we would add to the end of that sentence, after October 13th.
Wouldn't it be on October 13th? Because isn't that what the dependency court...
Actually, to be really clear with you, the order is entered on the 14th, but it's one of those shelter orders that has the nunc pro tunc. They were taken into custody on the 13th at 2:30 in the a.m.
Because the judge did this like at 2:30 in the morning.
Yeah.
If I remember correctly.
Some judge did this at 2:30 in the morning. I'm not clear about who that was.
And I don't recall, but normally they would then go to first appearance.
And actually, before first appearance, they went to a shelter hearing
at 9 a.m. that next morning.
The next day on the 14th. So on the 14th is when he said, when basically it's not that he's keeping them there. They're just going to. It's a continuation of that. But he's worried about his false imprisonment claim, which cuts off on the 13th.
Okay, so you want to say after October 13th?
So I just. Are we saying the order's the 14th? I guess we should change these dates to the 14th.
No, because the order has a retroactive finding in it. Because the written order is entered differently than.
Does someone have the physical order I can actually look at?
I do.
Okay, so the dependency court did this at 2:30 a.m. on the 14th.
On the 13th.
I don't think so.
Yeah. Can I approach, Your Honor? And I can show you on the document.
Okay, sure. Let's see, the clerk's stamp is the 14th.
Yeah, but at the front end of a shelter order, it'll tell you when the child was taken into custody. And in the front end, someplace on that first page, there's a statement that the child was taken into custody.
On the 13th.
On the 13th at 2:30 a.m. I think that's normally done with an oral ruling from a court, and then the shelter order normally is later. This is not the first time I've seen an order that looks like that.
Okay, so what I heard Mr. Whitney say is the parties agreed to, where it says dependency court made the decision to keep Maya Kowalski at Johns Hopkins All Children's Hospital after October 13th.
Right, and I think that's an accurate statement of fact and law.
Then let's go with that.
Can I just say we'd reserve on coming back to this later when we have a chance to look at that order closer. But
Yes.
for now, we're fine. And then I have one more issue when Your Honor's ready.
Yes.
The next paragraph, the third paragraph, it reads, "You have heard witnesses suggest that Johns Hopkins All Children's Hospital took Maya Kowalski from her parents. We think the testimony offered was accurate. We think we object to this being included. We think it belittles our witnesses and prior testimony, and similar to the court's concern a few minutes ago, we think it would simply highlight the issue that has now passed. So we'd object to that first sentence."
I am comfortable with paragraph 3 in its entirety as it's presented here. I think it's accurate, and I think it needs to happen.
Well,
anything else?
I guess we've made our record, right?
I know you don't want it.
You're going to read that
That's
first
the way the
thing
ball
in the morning.
bounces, isn't it?
Mr. Altenburn asks when I'm going to read it. Unless there's a reason not to, I think I would just do it at the beginning of the day tomorrow.
Thank you.
Okay. So everybody knows who the witnesses are tomorrow.
Yep, I believe so. I mean, we're communicating with them as much as we...
And we've gotten to my judicial assistant the name and email address so she can get...
Come over and get the email addresses that we
They-
need.
Your assistant kindly just emailed us that information.
There we go. Anything else? Since there's
We
still
need to-
9 minutes before 5 o'clock on the day we're only going to be here half day.
30 seconds. We just need exhibits from our judge.
Do y'all have the exhibit list? Exhibits?
What am I supposed to do?
We'll have it to them within an hour, 5:30, 6 o'clock. She's been here all day. We hope to have a half day, so.
Is it a lot or a little? Is it short? Please do it as soon as possible. And I don't want to start creeping a lunchtime deadline to 5 to 5:36, then to 9 o'clock, and then 11 o'clock. I really want us to get it around lunchtime because they need time too.
We understand. I've been a victim of that, and getting the opposition's information at midnight is no fun.
Okay.
Sleep-wise.
Thank you all very much. We'll be in recess until tomorrow at 8:30 in the morning. Okay, feel free to move around. I'm just going to clean up.